Good morning, good morning, good morning. It is day 16 of the Karen Read Retrial. It's May 15th. It's Thursday. Could be a Monday, could be a Friday, who knows? We are going to be doing more of the same today, I suspect, because yesterday we did quite a lot of scientific evidence, and I suspect today is going to be quite a lot more scientific evidence. The lab technician, the forensic analyst 2 who was on the stand yesterday is still under cross-examination. Will the sticker that's one sticker mirror reflected in the SUV come back up today? I suspect that it will, because we still have a whole redirect to get to. And I meant to go back and rewatch Hank Brennan's direct to see if he flagged that, and just didn't have time because there is too much going on in court these days. And today is a very busy day as well. And, you know, if there's any interruptions, I have a kiddo home from school today, so we're just, we are professionals. But for anyone who had a full panic attack with me yesterday, I apologize. We are rolling out something in a little bit that is a surprise that we are working on in the back end. And in dealing with that, somehow everything glitched on this channel. It was nothing nefarious. It was purely me moving at the power of ADHD, and then something that was not supposed to be connected, being connected and completely glitching. So I know there was so much panic. I let you know in the Lawnerd app as soon as we figured out what was going on. Thank you to everyone who was concerned and reached out. We will always communicate when we know what's going on. That was unexpected, and we had no idea it had happened, and it took us a minute. I'm so sorry. The way I panicked yesterday, I am still sweating. But no, the FBI has not found us. No, Chloe did not come for Fred and George. George did not hurl the internet into oblivion in rebellion for not being allowed to chew on my audio cables. I am not in witness protection. Everything is fine. I have not been rehomed. The internet has not been rehomed. The channel has not been rehomed. It was just purely something that glitched that shouldn't have. And the fun part about it is, when I was asking, like, how did this happen? Everybody's like, that shouldn't have happened. I don't know how that happened. So do we have full answers yet on how? No. But is it fixed? Yes. It's fixed. We didn't get yeeted. But if we ever do get yeeted, because that has happened in the past, we've always been able to fix it. We will let you know. We have other means of communication, and that is one of the reasons we built that. But today, well, we're probably going to be at like 1.25 speed during this cross-examination. We should probably just get to court. When the lawyers first came to court, they immediately went to sidebar. I'm skipping us right to the hear ye's, because that's the part I look forward to the most in the day. I got to be honest. We should just
bring the jury,
roll the intro, bring the jury, and just get after it today, because I'm going to be trying to run on time, because today is a busy one just in my life. For all of you that tuned in this morning and listened to me on Carson and Kennedy, thank you so much. I always have a good time talking to them. We chatted about Karen Read. We chatted a bit about Diddy. It's going to be busy. It's going to be busy today. Are you ready? I'm ready. Let's get to court. Let's go. Hey there. I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. It's time to go to court. All of our members, it's so good to see you. Daniel, it's so good to see you. Daniel said I had family members texting me in a panic that something awful had happened to you. I know. I'm sorry. I apologize, everybody. I'm so sorry. It was stressful for us too. The way you felt, we felt it. We felt it. We felt all of it. And it's been tough, for sure. All right.
All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the
I need to back this up. I try not to pick favorites, but can we just, for a minute, this bailiff does substantially better hear yous than anybody else. I don't know which bailiff this is. I don't know, but the hear yous just have the right amount of Massachusetts. They have more energy. The other guy was saying Hear you. Like he was being forced. These are my favorite hearings. I had to back up. We had to do it again.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard.
I do. I have a favorite.
Massachusetts, this court is now open. You may be seated.
These are better hearings. They just are.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. We thank you for your patience. Once again, we worked out something here this morning rather than having you watch us over at sidebar. So we appreciate your patience.
I didn't want to watch you at
Do you have to
sidebar
ask
either.
questions?
You're going at
Were you
1.25. Good
able
morning,
to
Your
follow
Honor.
the instructions and
We're all
refrain from
just
discussing this case?
yes. Same
Left
questions.
hand.
That's not
Everyone
1.25.
said yes or no.
Emily, don't put on the sleep timer. It's too
Were you
early in the
also able
day.
to follow the instructions and
I
refrain
know.
from doing any independent research?
Any
or
research?
investigation
No.
in this case?
No.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you. May we have Ms. Harnett, please?
Ashley said, I almost pooped my pants when I couldn't find your replay this morning. It should have been there this morning, depending on what this morning is, where you are. Oh, that's fair. You're in Australia. Yes, fair. And it is back now. I'm sorry. It's not a bug. It's a spontaneous enhancement. Yes, it was stress testing all of our systems mid-trial. That's exactly what it was doing. So Diana said your subscription icon glitched into another dimension, and I panicked. Then I couldn't search you. So happy I was back to normal.
Alessi.
Thank you, Your Honor. Good morning, Ms.
too.
Harnett, and welcome back this morning.
Good morning.
Me too.
Your Honor, if I could please have Exhibit 145 that is in evidence
Okay.
published.
Yes.
Mr. Wolk?
Sorry, Brandy. I know it was not.
Ms. Harnett, you will recall discussion about the taillight from the Lexus that was discussed on both direct and cross-examination yesterday.
Yes.
And you recall the discussion with regard to the weather that was in existence on or about January
if they're gonna
29th.
ask
I'm
how
not going to go
clean it
into it
is.
at all. I just want to sort of refresh and reorient
Okay,
to where
Alessi.
we were on that topic. You recall that?
Yes.
We're at 1.25.
And
just
I am
so-
now going to reference specifically
Alessi's talking so
what
fast.
you
No, he's
referred to
not.
yesterday, I believe, as the inner part of the taillight, sometimes the inside of the taillight.
Yes, chat. We're back to the toilet for ants. Also, let me know where you're coming in from, what you're drinking. I have a cappuccino this morning. Where's my cappuccino? It's time for more coffee.
Do I have that parlance correctly?
Yes, that's correct.
Thank you.
Oh, he's
So
talking
my
so
question
slow
is,
in real life.
did you find
I like that he asks
any
for the parlance.
sand or salt or any other debris in the
Okay, I'm putting this back to normal speed because it's the question everybody's been asking. Why is everything... No, Emily. Emily, use the internet properly. Why is everything so clean? Any salt, any snow, anything. He's coming in hot with the question everybody wants to know. Why is it all so clean?
taillight, sometimes the inside of the taillight? Do I have that parlance correctly?
Yes, that's correct.
Your
Thank you.
parlance is correct,
So
Alessi.
my question is, did you find any sand or salt or any other debris in the inside portion of that taillight?
No, I did not.
Nope. But what about the outside
Now,
portion?
and you can take that down. Thank you, Mr. Wolf. You recall discussion about shards of taillight? Do you recall that discussion at all in your testimony?
No, I'm sorry, I do not.
Okay. I wasn't certain whether we had that parlance. So my question is, to your knowledge, was there any testing of any taillight alleged to have been found at 34 Fairview for biological material?
No, there was not.
Okay, I'm sorry. I've tried.
And
Mr. Alessi,
could you just
you're
please
great at 1.25.
state what your
Just
definition
We're-
is inclusion when
we're
you
trying,
refer to biological
but we're not.
material?
Those items were not processed in the criminalistics unit for any type of biological, meaning they would not tested for
Bodily
blood,
fluids,
semen, saliva, or a
skin.
skin cell collection.
I'm sorry, I missed the last part. That you,
Or a skin cell collection.
Skin, fluids,
now
biological
turning and changing
materials.
topics.
They weren't tested
there
for
was
biological materials because they did the
a
presumptive testing,
T-shirt
didn't they?
and
then
a
we're like,
hoodie
nothing's there.
of the decedent. Do you
Once they
recall
did the
that?
presumptive testing, that
Yes,
kind
I
of
do.
And are you okay with
changes
my
the direction.
parlance of T-shirt, the yellow or orange T-shirt on the one hand, and then the gray hoodie sweatshirt? Is that an acceptable parlance for you?
Yes.
parlance might end up just being our word of the day by default.
So, with regard to those two items, if I could, Your Honor, have published what is already in evidence, Exhibit 151 and 150, and Mr. Wolk, if we could please put those side by side.
I appreciate that Alessi just talks through what he's doing. Emily, is that because you do the same thing? Probably. Probably. Except in court, I was never like asking
Alrighty,
anyone
so
for help because it was just me.
Is it correct that what's
Emily,
on the
can you
left
put
is
this
the
up
right
again?
sleeve
Sure, Emily, that would
of
be
what we
great.
refer to as the hoodie, and on the right is the, what color would
care
you
of
like
it
to
all
call that
together.
T-shirt?
Orange, please.
All right, so the orange T-shirt. Is that what we're looking at up on the screen?
Yes, so it's the right sleeve of the gray hoodie and the back of the orange t-shirt.
Thank you. Am I correct that you included a handwritten note on your report that you found, quote, debris from each of these two items or from these two items collectively?
I don't handwrite notes on my report, so I'm just confused about where you're asking that.
Okay, I'll ask a different question. Hopefully it will be clear. Did you find debris on on either of those two items of clothing?
Yes, I performed a debris collection on each of those items and combined them.
I'm sorry, it's not your fault, it's mine. There's a HVAC noise I can't hear. If you
So
could
can we
speak up
turn the
just a
air
little.
conditioning off, please?
I'm okay with
can
it.
speak
It's
up.
just
I'm
if you could
sorry.
speak up a little. I don't want to
Of course.
discomfort people. Can you move the mic?
Yes, I can speak up. My
If you
apologies.
They're actually genuinely just politing at each other. It's like, no, I can speak up. I don't want to discomfort anyone. Let me move the mic. I can. I think there are times when we saw witnesses maybe aggressively nicing, but I think the two of them are both like, oh no, I'm sorry. Let me just.
Speak a little louder, that would be great. Thank
Let
you.
me just.
Can you repeat your answer, please?
Can you repeat the question? I apologize.
Sure. Did you find debris
it's fine.
on these articles of clothing?
Yes, I took scrapings from each of these items of clothing and combined the debris. Yes.
The problem with taking the scrapings is they all just got combined, so you don't know what came from
With regard
the
to
hoodie versus the t-shirt, which in this case may be super relevant based on the defense's argument, but at the time, and even in 2023, I don't think they saw it as relevant. It was like, well, the shirt was under the hoodie, but for the defense, what is coming off of the shirt is relevant to them for their argument, but everything got combined. So I don't think any real way for her to say, this is what came from the shirt, this is what came from the hoodie, because for them, they were like, this is a vehicle collision. So they didn't see the significance of keeping those separate.
Scrapings. Can you describe how the term scrapings relates to these two items of these two items that are on the screen?
They
Yes.
combined
Scraping
the
is the
hoodie and the
mechanism I used to
shirt.
remove any debris that
but
was
not the
remaining
pants.
on both the sweatshirt and the t-shirt. I held each up over my lab bench. I took a long metal spatula and scraped any debris that was on these items into a small glassine packet.
Is it correct that you do not know where the debris came from specifically, other than it came from one or both items of both of these two items?
Yes, that's correct.
Right.
So the debris could be from just the hoodie, it could be just from the t-shirt, or it could be a combination of the both?
Correct.
Yes, the items were packaged together, so they were already commingled. So there was no way for me to determine which debris came from which item, and it would be misleading to label them as such. So I combined them.
Exactly where my next point was going to go to.
Right.
Thank you. And my next
So I
question.
combined them.
So what, if anything, were these two items contained in when you got them?
They were contained in a brown paper bag, and they may have been contained in a larger box, but I don't remember off the top of my head.
So
Right. They were contained together. So the evidentiary value of what comes from where is really hard to determine because law enforcement just hucked everything together. So for her, they're already cross-contaminated with each other, and they were from the beginning. So they were cross-contaminated from the time they really got off the floor of the ambulance.
When you got them and you saw them for the first time, using your term, they were commingled together, correct?
Yes, that's correct.
And was there any debris in the bottom of the bag?
There may have been. When I examine something on my bench, I also shake out the bag to ensure that nothing is left behind and that everything is examined and accounted for.
Which is why
Now,
she was probably so mad that there
am
was
I also
random shit in
correct
the bag. Well,
that
Emily, it's other pieces of evidence, but why there were things in the bag with the light casing that weren't hers. She's like, I have a very specific way of doing my job and everybody's touching my shit. And for anyone else who gets super annoyed with people touching their shit at work or anywhere else, you understand. She's like, this was my bag. It was sealed. And other people put stuff in it. Stop touching it. Just stop touching it.
there is no description of the actual debris that you found? For example, you didn't specify whether it was little fibers, little hair, little pieces of this or that. Do I have that correct?
Correct. I did not do any examination. I just packaged it.
And therefore, you didn't note whether any of the debris was a plastic or a plasticine nature, correct?
Correct. That would not be part of my analysis.
And there was no marker put on any part of the debris that was recovered. Is that also correct?
I labeled the debris with an item number. I'm not sure what you mean by marker, if that's what you mean.
Parts of debris, in other words, there wasn't separate identification or markers for separate pieces of debris.
No, I did not separate out the debris.
There was no photograph taken of the debris?
Not by me, no.
Do you have knowledge of whether there was a photograph taken of the debris by anybody?
I do not.
So you have, as you sit here today, you have no knowledge that there's a photograph of the debris?
That's correct. I do not.
When you received the hoodie and the T-shirt.
And again, those that tested the debris, if it was tested, might have taken photos. She scraped it and kept it.
That's depicted as 150 and 151. They came in together, commingled with some debris at the bottom in an evidence bag. Is that correct?
I'm not sure if there was debris at the bottom of the bag. What I can say is that there was debris on the items, and I did shake out the bag. I don't have a memory of anything coming out of the bag. I don't know.
So there could have been debris at the bottom of the bag when you shook it out. You just don't recall.
Yes, correct.
If we could, Your Honor,
And if there was, it would have been put in
Exhibit 154 already in evidence published. And let's keep it there for a moment, and then I'm going to ask Mr. Wolk for you to zoom in.
And yes, for those of you just joining us,
Ms.
we're at
Hartnett, do you recognize
1.25.
this generally? And I'm going to have it zoom in so you can read
Both
it
of
as an
these
evidence
witnesses
bag.
speak very
Yes.
deliberately.
Now, Mr. Wolk, could you please zoom in, starting from the top, so that Ms.
And
Hartnett
we
can
had the room
fairly
to do it.
read this. And if you could, Ms. Hartnett, just take a moment to read it, and then I'm going to ask you some questions, but I want you to have a fair opportunity to read it. Let me know when you're done.
Oh, shocking. Whose name is on it?
Okay.
And if we can then scroll down, Mr. Wolk, so that Ms. Hartnett can fairly read the rest of what's on there.
Okay.
I did it.
Thank you. Now, Mr. Wolk, if you could just leave it where it is now. With Your Honor's permission, I don't see a need to keep the lights off. Can have that on, but if
That's
Ms.
great.
Hartnett
Lights
needs
on,
it,
please.
you'll just let us know.
The court immediately saying, that's great, lights on.
Is this the evidence bag that the T-shirt and the hoodie were in when you received those items?
To the best of my recollection, yes.
These are from Good Samaritan.
You see the name of collected by someone
Trooper
there. Can you read
Proctor.
who that states it was collected by?
Yes.
And state what that is.
It says TPR Proctor.
And are you able to conclude what the TPR stands for?
Generally, we use that to abbreviate trooper.
Right. So that is former Trooper Proctor that it says collected by, correct?
That is what's written on the bag, yes.
And the date of the collection,
She doesn't know. She wasn't there.
if we can just, Mr. Wolf, just focus in on that. Thank you. The date of the collection is January 29th, 2022.
Oh boy, are we going to ask why it took so long to test? We're going back to normal speed for that. We're going to stop our warp speed to Endor and we're going to go right back to normal speed. That says January 29th, 2022, right?
Correct?
Yes, that's correct.
I want to get into all of this.
Is it a fair conclusion from this evidence bag and your experience on the matter to conclude that former Trooper Proctor was the person who collected the evidence and put it in the bag?
I have no knowledge of who actually collected it and put it in the bag. I can only read what I see on the monitor.
In terms of...
Right. Stay in your lane.
And if we could, Mr. Wolk, please take that down and put back up the side-to-side images and depictions of the T-shirt and the hoodie.
The defense has done a good job of continuing to remind the jury that Trooper Proctor is the elephant in the room. Former Trooper Proctor is the elephant in the room. And
do you know...
I don't think they should let up on that at all.
The journey, if you will, of those two items before you receive them?
I don't think we're going to either.
No, I do not.
The debris that you ultimately saw on the hoodie and the T-shirt, and that which may or may not have also been
Wait, we didn't get to
additionally
time?
in the bag, do you know where that debris would have been picked up from?
No, I don't know the source of the debris.
And you were not provided with information as to the potential source of that debris, correct?
No.
Okay. Alessi, I like the methodical approach. You're going back to 1.25.
Were you aware of whether or not the debris...
Oh, thank you.
Excuse me, whether those items had been on the floor of an ambulance or a floor of a hospital?
It was hurting my brain.
No, I did not have any information like that.
He's reminding the jury, again,
Is it important to maintain
where these things were.
the sanitary condition of evidence generally to avoid contamination?
We do our best to avoid contamination once we receive items into evidence, yes.
And what are some of the protocols that are used to avoid contamination of evidence?
And tell us more about your mini toilet.
Generally wearing gloves, putting items in packaging, bleaching any materials or utensils that we're going to use, or using disposable materials, sterile materials when possible or necessary. We also wear lab coats when processing evidence.
Is another protocol or technique to separate out pieces of evidence to prevent cross-contamination?
Sometimes we will separate pieces of evidence. If the items are already mixed in with each other, then the items are kept together, can be kept together.
And I think that's the point, right? They were already commingled.
Do you
Plant
know
hoarder, I'm
the
sorry.
chain of custody of...
Oof. R.I.P. everyone wearing headphones. All right.
Do you know the chain of
I did put it at 1.25.
of
It's too
either
fast.
the hoodie or the T-shirt?
I only have record of the chain of custody from when it was delivered to the lab.
So before any delivery to the lab, you do not have knowledge of the chain of custody of either of those two items?
No, I just know which detective unit dropped the items off.
And which detective unit was that?
Norfolk Detective Unit.
At
What I
1.25,
would
it sounded
to
like
now
she said
do
Norfolk.
is to, we can now take that
And I'm
down.
here
Thank
for
you,
it.
Mr. Wolf. I want to sort of speciate, if you will, separate out the...
Okay, Alessi, I've got to put you back to normal speed as we get to speciate. We're going to have words of the days for days. Hold on. We were cruising along on who dropped it off and protocols, and then you dropped the speciate on us. All right.
the evidence that you have talked about so far, so that it's clear what you submitted and what may have been submitted by others to the lab. Do you understand that concept generally?
Yes.
Thank you. So what I'm going to do is to give categories, and if you would be kind enough to say, I submitted it by some other person, that would be helpful.
All right. We're back to
Any
normal speed
items
as we
that
go
were
through what was
collected
submitted
from
and
the
when, because the
vehicle,
timing's
who
going to matter.
submitted those to the lab or brought them to the lab?
I did.
The swabs from the red Solo cups.
I submitted the swabs.
The drinking glass that you were presented with at Canton PD,
I submitted that item.
the two clothing items that we just saw on the screen, the hoodie and the T-shirt,
Those were submitted by the Norfolk Detective Unit.
Okay.
were there also any fingernails that were part of the investigation and that you had knowledge of?
Yes.
Describe what those were, please.
Fingernails may be collected at the medical examiner's office, and they're clippings from the top of the fingernails of the victim.
And were those submitted to the lab?
Yes,
And by whom?
by the Norfolk Detective Unit.
And the phrase known blood standards, are you familiar with that phrase?
Yes.
Can you tell the jurors, please, what that means?
A known blood standard is a sample of blood that is collected from an identified person.
And which person were those known blood standards related to your knowledge in this matter?
We received a tube of blood that was identified as belonging to John O'Keefe.
And with regard to the fingernails and the known
I'm holding
blood
on to a lot of y'all's
standards,
questions. They're
who
great.
submitted those to the lab?
The Norfolk County Detective Unit.
At some point, there will be.
So am I
a,
correct to
sidebar.
conclude
Get to them.
that for those items that you submitted to the lab, you knew about, you knew sort of their journey, if you will, but that those items that were submitted by, I think you referred to as Norfolk County, was your parlance?
Yes, correct.
You don't have knowledge about those other than that they were submitted by them?
Prior to them arriving at the lab, correct. I have no knowledge of what occurred, where they were stored or anything like that before that.
Right. She's like, I don't know what the fuck they did. I only know what happened once I got
And
it.
no knowledge of those items
it's like
not
adopting a pet.
submitted by you would
Sometimes
include
you
no
just don't know
knowledge
what
of
happened
the chain of custody
before
of
they
those
got to your
items,
house.
correct?
No knowledge prior to them being received into the lab. That is correct.
Right.
Your Honor, if I may have a moment, please, it'll probably be 30 to 45 seconds. Thank you.
Thank you, Alessi. We're going to put you back to 1.25. No, we're not. We're going to zoom past. He's probably almost done and asking if they have anything else that he wants to ask, which is a thing with having a big team. If anybody catches anything, you have a lot of extra brain power sitting at the table. Not something I'm used to. I rarely tried cases with other attorneys and only second chaired a very small amount of trials. I never had a second chair. Emily, it's like, distributing work is a challenge for you. Yeah, because I work at the speed of ADHD. And if I ask somebody to do it and they don't hyper-focus
So the
on
questions I have for Ms. Hartnett at this
Then
time,
I'm like,
thank you for answering
I'll just do
my
it myself.
questions, Ms. Hartnett.
Thank you.
Are you bad at delegating? Yes.
All right, Mr. Brennan, any redirect?
Working in government service worked well. There was no one to delegate anything to most of the time. I'm not saying that's preferable. It's a quick recipe for burnout. All right, Mr. Brennan. I don't hate the suit. Is it hot? Is he wearing a vest? He's like full three-piece up in here. I'm not mad at it. I'm not. I'm just not mad at it. But wouldn't it get hot? I think it would get hot. Maybe. I don't know. I'm here for the three-piece suit, Mr. Brennan.
You mentioned that you had an opportunity to observe a paper bag that had red Solo cups in it,
Yes, that's correct.
and the red Solo cups had a coloring of red in the cups.
Yes.
I mean, it's difficult with Brennan because at the same time, I can hear him giving all the speeches as like a Star Wars villain. So it's difficult. He could just swap out for most of the actors that are on the dark side. But I do like the suit. Except for Kylo. We can't swap him out for Kylo.
Ever seen blood preserved in cups like that before?
Objection, Your Honor.
To the form.
He
Had you ever seen blood stored in cups like that
Redirect.
before.
No.
Do you know the circumstances of storing that blood?
Can you rephrase that question, please?
When the blood was stored in the cups, do you know the circumstances?
Sorry, Mr. Brennan. Your Honor, objection. Can we have a sidebar, please?
What?
Okay?
I said we would get to it. Sith Lord Brennan is an interesting mental picture. Right? We might get to full Palpatine at some point. I don't know. I don't know. I feel like he's just going to let the power flow through him. I'm going to zoom past this. This is why we have zoom room. I'm not sure why they need a sidebar on this because the defense asked about it to good effect. I thought when the defense said, you know, have you ever? No. When the defense
Coloring
asked,
in those cups. Do you?
oh, he was saying blood. That's fair because it's not been established and it was never tested. So you can't say that it's blood. That's fair. Fair.
Do it.
My coffee hasn't kicked in all the way. It's completely fair. Yes. Shannon in the chat said he keeps saying blood. That's exactly it. And it was never tested. So you don't know that it's blood. Suspected blood is fine, but the reddish brown substances, yeah, you can't assume. However, the jury has assumed that it's blood and that nobody tested it. And they're probably annoyed with that.
Know firsthand what that comprised of, what the item was?
Are you asking me if I knew what the contents specifically of the cup
Yes.
were? No, I do not.
Do you
And
know
so the
why
red
they did
cups
that?
with the red spots stored in them. Do you know the circumstances surrounding the effort made to try to preserve that evidence?
Can you just be more specific in what you mean by circumstances?
Sure.
He wants to ask you, do you know the heroic efforts the troopers went to preserve what was in the snow amidst a blizzard? And they had nothing to use, so they decided that they would use red Solo cups because they are great at preserving liquid. That's what he wants to get to. She has no idea why they chose that.
Do you know where those red cups came from?
I was told they were collected from the scene. I don't have firsthand knowledge of the collection.
And you weren't at the scene that morning, were you?
No, I was not.
Do you know that what the circumstances or the challenges were that morning?
No, I'm not aware.
You said that you respond to active scenes and sometimes, like in this case, after the event happens?
Yes, that's correct.
Is there a difference when you're at an active scene as opposed to when you arrive at a scene that is past the event?
I would say multiple units are working at the same time, attempting to document, preserve, and collect evidence.
At an active scene.
You were asked a few questions about the top back of the Lexus SUV.
I just wanted him to
Yes,
ask her,
that's
like,
correct.
When you were first asked the question,
Ma'am?
you were asked if you
when you saw the red Solo cups, like, what was your first thought? Like, what was the first thing that you knew you weren't going to, like, say out loud? But what was the first thought? Was it like, what the fuck is this? Or are you fucking kidding me? Like, what was the first thought?
had studied that area and you said you didn't recall if you looked at that area.
Tracy, no, I was a
did
band
look at the area. I
kid.
looked over the entire
Band and water
vehicle, but I
polo.
didn't know anything specific in that area, no.
When you
love
say you looked
theater.
over the entire vehicle, did you look over the
I went into
back of the vehicle
trial
as well?
work.
Yes, the only part I did not look at was the
Not too
roof
dissimilar.
of the vehicle.
Did you study all sides equally? Did you spend time with the entire vehicle?
I believe I made an effort, yes, to look at the entire vehicle.
Did you spend quality time?
When you studied the back of the vehicle, not the right side or left side, the back, middle, did you find any hair?
I did not note any hair, no.
Did you find any scratches?
The only scratches I noted were ones that I had spoken of previously on the
Yes.
right.
When you looked at the left side,
Was it
of
Runkle
left,
that called them
did
the
you find
vampire
any
slushies?
dents or scratches?
Nothing that I noted, no.
Did you find any hair on that side of the car?
Not that I noted, no.
Brennan, the hair is not a serve, buddy. The hair is not a serve. The hair is... Did you ever find a hair anywhere else? The hair is just not... It's not. I would just let that go.
Did you find any dents, scratches, or hair anywhere but on other than the right side quarter of that Lexus?
I did not note any. I also did not examine the interior of the vehicle.
You said that you removed the hair. What do you do after you remove the hair?
The hair is placed into a small glassine envelope, then placed into a larger manila envelope, and then I signed and sealed it, gave it the appropriate case number and item number, and then secured it in our storage room.
Can that hair be further tested?
Yes.
Is that something you would do or a different person?
I don't perform testing on the hair. I performed a microscopic examination of it, and then additional testing can be performed by a different unit.
Oh, you did?
Let me ask you some questions about where you found the hair. You saw the two different angle pictures yesterday that you described.
Yes, I saw
Oh,
two
boy.
pictures of that hair yesterday.
You were also shown some video where the car had snow and ice on it.
That was a great video.
Is water a conduit?
What?
Does water ever act as an adhesive?
What? What? What?
Watch the form of the question.
Okay. Why don't I show you a similar video that you were shown yesterday, but we
Like,
can
I know where
clarify
you're
that so it's
getting,
more
but-
clear. And I ask you to take a look at video 125.
Oh, sir. That's actually a lot of snow in that footprint. This video says it is from 1/29/2022 at 5:03 p.m. I'm gonna back that up. It says 5:03 p.m. 1/29/22. It looks like snow to me. What's it look like to y'all? 5:51 p.m. There's a vehicle. 5:51:53 on 1/29/22, and it looks like there's no snow. What is happening in this video? I had to back it up again. It's for my own curiosity. What was in there before? Unless the video is just making its own snow.
Can we stop that, please? And can you see that's 5:51:54 p.m. on 1/29/22?
Yes.
When you first saw this vehicle, it didn't have that snow on the right back near that taillight, did it?
Objection, Your Honor.
Ask it differently, Mr. Brennan.
When you saw this vehicle for the first time, did it have
Snow.
that snow packed into the back right of the car?
No, to the best of my recollection, there was no snow on the vehicle when I saw it.
And
Right.
the hair where you found it, you see the red back taillight, the piece of red that's showing?
I do see that, yes.
In reference or relative to that red, was the hair to the right, left, below?
I see where he's going, but
I don't
again,
recall at this time.
Okay.
I don't know if
Do you
this is the
see
serve you think it is.
ice or snow on the right side quarter panel of that Lexus?
I don't see it on the quarter panel. I'm not sure what you're speaking of.
If we could move that video forward, please.
She's like,
702.
I don't know what you're talking about, sir.
And then to 749, please.
That looks like 7:02 p.m. Do you think this is what Brennan did last night? Oh,
Stop. Go forward just a little bit, please. Stop.
that's 9:23
Still
p.m.
remnants of snow. Did it look like that when you
It
first
looks
saw
like it's
it?
mid-fall.
No, I believe I did not see any snow on the vehicle when I saw it.
You could fast forward, please.
Why are we fast forwarding? I want to watch the snowfall. And I would start singing Skyfall, but Adele, there's no way. We're at like 11:58 p.m.
Thank you. You can take that down. Thank you.
Okay.
You were asked if you
The jury will
had any
have that to
information about
watch
when damage occurred,
if they want to.
Yes, that's correct.
and you offered us, you don't have no idea, right?
Correct.
Objection, Your Honor.
I'll allow that.
No, I do not know when the damage
Kathy,
occurred.
I saw somebody walk into frame,
You were asked
It's
whether
late.
or not
but yeah.
damage existed on that car prior to that day, prior to January 29, 2022. You remember that question?
Yes.
Did you know there are ring videos of that car from January 28, 2022?
No.
He's doing the flip side of what the defense did,
I want
right?
to show you some photos and ask you a few questions.
So there's
If
this
we could
other
have
evidence. Do you know that this other
147C,
evidence
please?
goes to the car? I wonder if he will choose to show some of those. It seems like he might.
If you could
Does
close
this
up.
look like the damage you saw? If he
Remember
hasn't
what that's a picture of or a photograph of?
done this
Yes.
yet with this
What is
witness,
it?
it'll be difficult.
That is a tear that was on the right sleeve
Okay.
of the gray
He's moved
sweatshirt.
on to close.
The threads coming from the side of that hole.
Yes.
Those threads, could you pull those threads and pull them out by hand if you wanted to?
Can you repeat that question?
If you pulled on those threads, could you pull thread from that hole if you wanted to?
Objection, Your Honor.
I'll allow that.
I don't know. I didn't attempt to pull at them at all.
Did you examine them to see if they were woven or loose, those threads?
Yes.
Okay, and what were they?
They were loose. The fibers had started to separate up from the shirt. Separate and weave. I don't want to say they were separated from the shirt completely. The weave was starting to separate.
If we could have photograph 57.
If you want to destroy my spirit, oh, 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 hold this thread as I walk away. As I walk away. Well,
57, 57.
that's riveting. Yeah. It's not your computer. It's not your internet.
Are those the red cups that you saw?
Yes.
And what color is the fluid inside?
I noted there was red-brown stains inside.
Okay. And do you see that white object, the rag or the paper towel?
Objection, Your Honor. Scope.
Yes, sustained.
Well, you were asked about, you can take that down. You were asked about,
Alessi's objection was scope, which means this. And I wonder if the defense had a chat about this, because we're starting to see more of these objections regarding scope on redirect. You don't get to just save stuff for redirect and then bring it up if it did not come up in cross. Redirect is to address specific points that happened in cross-examination. And so he's like, this is outside the scope of cross, which is part of the reason the judge takes notes as they're going, especially when crosses are long, because yeah, that is outside the scope of cross. And that's why it was sustained.
who had custody of items. You only have custody of items once you receive them, right?
Yes, that's correct.
If somebody had access to that rag and dipped it in those cups and then smeared it,
What fresh hell is this question?
Yes, that's
I
correct.
had to back up and start again.
if somebody had access to that rag and dipped it in those cups and then smeared it on the taillight, and you went and tested, would you potentially be able to find that red liquid on the taillight?
Objection, Your Honor.
It's sustained.
It would test positive.
If strands of cloth were pulled from those clothing and placed in the taillight area, would you know when they were placed?
Objection, Your Honor.
Sustained.
When you get to a scene and you examine an area, if you don't see it firsthand, is there any way you can date when items are placed on an object?
What?
I'm sorry, can you ask that one more time, please?
Sure. when you look at an area like a taillight,
Yeah, this witness is like,
if
what are you
found
saying?
blood or cloth or another item in that area, would you know when it was placed in that area?
Objection, Your Honor.
I'll allow that.
I think there are really just too many variables to say either way.
She's like, what are you asking?
And if
Brennan, this witness's face has told you she has no idea what you're
an
asking.
item like blood or cloth was placed in that area, is that something you would be looking for in your examination?
In which area?
Say the taillight, for example.
If there was an object placed in the taillight, would I be looking for that? I would be looking for any item evidence. I'm not specifically looking for anything. I'm just looking for anything that would potentially be evidence.
Thank you. I have no further questions.
That was rough.
Briefly, Your Honor.
If we could, Your Honor, have 147C republished.
Recross.
If we could have
Zoom,
Ms. Gilman, I
zooming.
have just one question, Your Honor. Thank you very much, Ms. Gilman. 147C, I believe it.
Okay, I think you already had it up there.
No, it's this one. Yeah, exactly. Thank you, Your Honor. Do you recall Mr. Brennan asking you just moments ago a question about this depiction?
Yes.
And to be clear, this is the right sleeve of the gray hoodie, correct?
Yes, that's correct.
You didn't perform any analysis of this area of the right hoodie, did you?
I performed damage analysis on each of those tears on the sleeve.
Right, but you didn't perform an analysis as
Which
to the
includes
source
its
of that
damage.
item, what it could be, correct?
Can you rephrase that question, please?
Sure. You didn't do any analysis of what could have caused that hole in the sweatshirt, did you?
No, I did not.
No further questions. Again, thank you for answering my question.
All right, Ms. Hartnett, you are all set.
I
we're
wanted to correct something from the
Oh.
record yesterday. I wasn't sure when was
What?
appropriate to do that.
Okay.
What?
Do you recall which lawyer asked you the question?
Yes, Mr. Alessi asked me the question.
Your Honor, are we going to proceed along with that?
So why don't I see you outside?
Thank you.
Oh, I bet she wants to correct the record. He didn't ask her about it. Oh, boy. She just had some time to think about it. They're at sidebar. Yes, they are. We're going to zoom. You guys have
Going
some...
to let you step down because questions from both sides are completed.
Okay,
So
thank you.
you, though.
The court's like, nope. And the DA's like, nope. This witness said she'd like to correct something she said, and the questions are complete from both lawyers, and Brennan didn't ask her about it. Brennan didn't ask her about the mirror reflection. Redirect is when you get to ask those questions, and he didn't. So she can only answer the questions that she's asked. She doesn't get to say, excuse me, I would like to correct the record. I imagine it has to do with the photos, but Brennan didn't ask, and neither did Alessi. So that would be my guess. But the jury's going to be like, but if she wants to correct her testimony, if some of her testimony is wrong, shouldn't we get to hear it? The witnesses can respond to questions. Oh boy. Let me just make a note and we're going to get on to witness 30. Wow.
Okay, Mr. Brennan, who is your next witness?
Next witness is Dr. Scordi-Bello.
Okay.
The coroner is next.
Yes.
Thank you.
I'm sure the mods have been wrangling spoilers in the chat nonstop. It's about time they called the coroner. Dr. Scordi-Bello is the coroner. I know everyone's excited to hear from the coroner. It's going to be slower scientific testimony. So I know everybody's like, I'm ready. I know. I'm ready too. But it is also going to be it is going to be methodical. It is going to take some time. And for everyone who said, I thought the Commonwealth wasn't calling her, I don't know where that rumor started. I have said since the beginning of this trial that the Commonwealth's going to call the coroner and that the coroner was on their witness list. So and you guys don't need to say where the rumor started. I don't know, but not on this channel. Because I said they're going to call the coroner. They're going to call the coroner. I just didn't think they were going to do it today. I'm glad that they are. So, all right, hold on. Let me do that.
Why don't I see counsel at sidebar, please?
And they're going to sidebar. All right. So as long as we can send out an app notification. Julie, will you just let me know if I need to do that? I don't know why they're at sidebar. Oh, I can speculate though. I'm guessing they went to sidebar just to talk about how photos would be presented and if they would be presented. So I liked this witness quite a lot last time.
Tell us the evidence gives the court
So.
and jury in the case never hears the truth, the whole truth, and nothing but the truth, so help you God.
I did. Thank you. Good morning, Doctor.
Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning. Could you please introduce yourself to the jury?
Good morning. My name is Irini Scordi-Bello. That's spelled IRINI-SCORDI-BELLO. I am a medical examiner employed by the Commonwealth of Massachusetts.
How long have you been a medical examiner for?
In the state of Massachusetts since December of 2016. In general, I have been a medical examiner since 2008.
Did you attend medical school?
Yes, I did.
Where did you attend medical school?
I completed medical school in New York City at the Mount Sinai School of Medicine, now known as ICANN School of Medicine.
Did you attend a residency?
All right, guys, while they're doing
Yes,
background training and
I completed my
experience, I'm going to
residency
send out
in
an app
anatomic
notification real quick.
pathology at
It's a
Mount
busy,
Sinai Hospital.
busy morning
Is
over
that
here.
what you specialized in during your residency?
Yes.
After your residency, did you go right to the medical examiner's office or did you work anywhere else?
After my residency, I completed a one-year fellowship in forensic pathology that was done at the Office of the Chief Medical Examiner for the City of New York. And then I went to work as a medical examiner.
Is there a certain type of doctor you are? Do you have a particular?
Yes, I am a forensic pathologist.
What are your duties?
The jury's got to be like,
at
oh,
the medical examiner's office?
thankfully.
My duties and responsibilities at the medical examiner's office include performing examinations and autopsies to determine the cause and manner of death in cases that fall under our jurisdiction.
How many other doctors work with you at the medical examiner's office?
I think there's close to 20 of us. I don't know the exact number.
The medical examiner's office, are you responsible for all counties in Massachusetts as far as doing examinations and autopsies?
No, I work, my primary location is in Westfield, Massachusetts, where one of our satellite offices is, and we cover Worcester County and the entire western part of the state. There's 3 offices in the state, the one in Westfield, the one in Boston, and the office at the Cape, in Cape Cod.
You mentioned that part of what you do is to try to determine manner and cause of death.
Yes.
I use the word autopsy generally without too much detail. Can you describe for the jury what the process is when you're trying to determine the manner and
Don't
cause
tell them about
of
pulling
death?
skin off of people's faces and
You
stuff.
would like me to explain what
that
an
gets a little
autopsy
gross.
is?
Please.
An autopsy is a large surgical procedure with 2 main parts. The external examination, which is an examination of the outside of the body, where we document physical characteristics such as hair color, eye color, We document any identifying features such as scars or tattoos, height, weight, and then we also document any signs of
They
disease or any
document all
signs
the
of injury
tattoos.
on the body.
Yes, they do.
The second part of the autopsy is the internal examination, where we make surgical type incisions on the body and we examine the internal organs of the neck, the chest, the abdomen and the pelvis, as well as the head and the brain. Part of the autopsy procedure, and this depends on the kind of case we're doing an autopsy on, might include other studies such as taking evidence, toxicology, which is done on almost every case, and any additional dissections or any additional steps we might feel we have to take. But that's, in general, what an autopsy is.
Do you ever seek the assistance of any other doctors or professionals that have specialties in your determination in an autopsy about manner and cause of death?
Yes, absolutely. We often, well, like I mentioned before, we perform toxicology on almost all our cases, and those samples are sent to the toxicology state lab. We also have a board-certified neuropathologist and cardiac pathologist in our office, and very often we will consult with them in determining cause and manner of death.
Are cause of death and manner of death the same or two different things?
They're two completely different things.
Can you explain to us what the difference is between the two of them?
Yes. Cause of death refers to the disease or the injury that initiates a sequence of events that ultimately leads to someone's death. So that disease or that injury can be a natural disease such as atherosclerosis or coronary artery disease, or it can be some sort of injury. The
Gunshot
manner
wound,
of death
stab.
has to do with the circumstances that led to the death.
Oh, no.
So there
That's the other-
are 5 manners of death that we use in our practice. The most common one is actually natural. Natural means that the person's cause of
Heart
death,
attack,
the disease
cancer,
that killed them, was due
age.
to natural causes.
Right.
And that would include
Oh,
heart
that sounded like a
disease,
Zoom call. That wasn't you. That was in court.
diabetes, cancer. All those are natural processes that take place in the body that lead to death. And so the manner of death is natural. If trauma or an injury is involved, then we have to decide then let me back up. If trauma or an injury is involved, then the manner of death is no longer natural. And therefore, it could be that the trauma was inflicted in an accidental manner, in which case the manner becomes accident. If it was
Skiing, car
inflicted by
crashes,
another person
homicide.
with the intent to cause harm, then the manner becomes a homicide. And if the trauma, and when I say trauma, I should include both physical and chemical trauma. Chemical when it comes to intoxications due to drugs, etc. If the trauma was self-inflicted, then the manner of death is suicide. So we have natural, accident, homicide,
Suicide. And undetermined.
And then the 5th one is what we call undetermined or could not be determined. That is when the circumstances in a case are not entirely known or clear to us. And
I agree. She's real easy to
the
follow.
information that we have does not support one manner of death over another. In that case, we classify the manner of death as undetermined.
You know, it was
When
not
you
your
are
team's
conducting
notification.
an autopsy and making an analysis.
That was the
and
court. That
attempting
wasn't
to
even
reach
me.
a conclusion. You said when you looked at in a case, is your case and what you do different than procedure in a prosecution's case?
Can you repeat the question? I'm not sure I understand.
I can.
We will get to
When you're
cause
making
and
your
manner of death
determinations
later.
about
It will come
cause
up.
or manner of death, do you have any limitations?
Okay, so the cause of death is something that is determined by the autopsy. That is my opinion or our office opinion
That's
as
in
to
court.
the disease.
Everybody take a breath. The court is trying to remind all of you that you need to be working and not watching trial. I say boo to them because we're finally getting to what happened to John O'Keefe. And I have no idea why everything is bing-bonging this morning, but it's in court. It's in court. I don't know.
Or injury that led to that person's death. So that is, I don't have any major limitations unless we're dealing with cases where, the body's decomposed and we're not able to do,
lots of people do.
all the testing necessary. But in most cases, the cause of death depends on my findings during the autopsy. The manner of death, yes, there are limitations because it's circumstance driven. And so the circumstances might not be known to us at the time of the autopsy. They might not be known to us ever. And therefore, while the cause of death is my medical opinion, the manner of death
Might be unknown.
Depends on information I get from other people.
Right.
Are you always able to reach a conclusion on manner of death?
No, that's why I said that in cases that we cannot, that manner of death is classified as undetermined.
I want to
It's
now
not
ask you about whether or not
unusual
you examined John O'Keefe.
to have a
Yes,
manner of
I
death.
did the autopsy.
Remember, the manner of death is not a legal determination for the district attorney's office or for a prosecution. It is their best medical determination based on all the information that they have. So she is going to get into that. This is going to be thoroughly discussed on cross. So we're going to get into all of it, but the manner of death, again, not a legal determination.
On Mr. O'Keefe.
When you examined Mr. O'Keefe, did you work with a team or by yourself?
Madeline,
No, we
it's-
always work.
if they don't know if a vehicular collision or a vehicle collision was, because there are vehiculars that are intentional, they are more rare. Sometimes those are ruled as an accident. Sometimes they're ruled undetermined if they don't know all of the facts surrounding it. So it's not the strangest thing to me. And I don't think it is hugely detrimental to a case. Where it becomes problematic is more a case like the Birchmore case, which we're not going to get into today.
Work in a team. The team is made up of the medical examiner and a medical examiner's assistant that helps with the actual performance of the autopsy, especially when we examine the head. And then, of course, we work with the toxicology lab and, in this particular case, our neuropathologist.
The medical examiner's office, is
Chat,
that a division
we're just going to have to wait till
of
cross. I know
the
you have a lot of questions.
Massachusetts State Police?
Just hang in
No.
there. Some people haven't
Is it
seen
a
her
division
testify
of the
before
Norfolk
yet.
County District Attorney's Office?
No.
We got about
Is the
20%.
medical examiner's office independent?
Yes.
Oh, he's going
When
to
you conduct an autopsy,
step right into
are
that, Brennan.
representatives of law enforcement or district attorney's office able or allowed to attend an autopsy?
Yes, they're usually allowed to attend the autopsy if they wish.
Is that an uncommon practice?
No, it's not uncommon.
Would you remember when your autopsy of Mr. O'Keefe occurred?
Yes, I performed the autopsy on January
Me, it's
31st
me.
of 2022.
If
I have to take off my glasses to see better.
Yes, I do.
I think you'll be able to use them, but we'll just want to indicate that you're reading from your notes if that's the case. Thank
So
you.
you can use your notes, doctor. Just
Thank you.
Thank you, Your Honor.
The court's like, I got you.
When you began the autopsy of Mr. O'Keefe, do you know who, if any, representatives from the Massachusetts State
we've already
Police
seen that
or
witness
the
testify.
Norfolk County District Attorney's Office were present?
I don't remember their names. I do believe there were two individuals, and every person who attends an autopsy has to sign a log, and their names would be logged in our records. I don't remember their names.
Yeah, we have about
What is the
20%
role of law enforcement
of viewers that haven't seen the first
relative
trial.
to the actual physical autopsy? Do they
Also, there should always be a log. of people logging in and out of the coroner's office. And if they're watching an autopsy, it should be noted. Document everything.
Have any role?
No, they're not part of the autopsy. They don't have a role. Their role
observe.
is to observe. Sometimes they will ask questions, based on my findings, they might.
And yes, I'm going to eat breakfast while she's
go
testifying.
on and do their investigation.
Is it weird to me to eat while the coroner's
Does your
testifying?
office
No.
photograph things of interest?
worked in criminal law for a
like
long time.
injuries on the person that you're doing the autopsy on?
Yes, we do.
Is law enforcement allowed to take their own photographs as well?
Yes.
Did you in fact memorialize your findings in this case?
I did.
Are there a number of different ways in which you memorialize your findings?
Yes.
I'm sorry.
I took notes, physical notes, pen and paper. There's a report that's issued within 90 days of the completion of the autopsy, and then photographs, digital photographs.
You mentioned a report is due in 90 days. Is that often referred to as an autopsy report?
Yes.
Why 90 days?
That is the standard that is set by the National Association of Medical Examiners. We're part of NAME, and therefore we try to have a finalized report for all our cases within 90 days, because we know that families are waiting for these reports, and therefore we do our best to finish a report within 90 days.
Did you in fact complete a so-called autopsy report in this case?
Yes, I did.
Part of what
In
takes
addition
time,
to
look,
the-
Emmys take really extensive notes. Sometimes they also do audio recordings, but there is a lot that they have to send out to the lab. And sometimes it just takes time to get back all of the toxin lab results, but they take really extensive notes. So their reports being done within 90 days is not odd for me at all. That, that would be ideal, and it would be better to have them done quicker, but also you've got to wait until all of the talks and what have you is done.
The autopsy report, included in the autopsy report, do you make handwritten notations about locations of injuries?
Yes.
And
have a
share
little
with us,
chart.
how's that done? Is there a picture or a graph?
There's a diagram, a body diagram that we use to mark the location of injuries.
May I approach, Your Honor?
Yes.
Everyone that says it's so much faster on TV, it is. It is so much faster on TV when they get to just decide what the lab results are and not wait for them to get done by a lab that probably has quite a lot going on.
Yes.
Do you generally recognize what these documents are?
Yes, these are
That
my
is the
diagrams
feed buffering,
from
not you?
Mr. O'Keefe's autopsy.
And could you just very basically describe each one of them?
Some of them. Yes, the first one is a body diagram. A lot of things have been whited out, but it's the diagram that I would use to make note of
Seems like
any
there's things
injuries.
that are redacted.
The second one is a diagram of the face and the skull. I would also use this diagram to make notes as to any injuries on the face. And the third one is a diagram of the inside of the skull, what we call the base of the skull, as well as different views of the brain itself. Again, I would make notes to point out different injuries.
The jury,
As you are noting injuries in your autopsy report,
the jury does
these
not get the redacted information.
diagrams, they start off blank?
They start off blank and then they're filled out as
There
we
will
go.
be some information. If it is not relevant to the case, it'll be redacted. But no, if it's redacted out of the exhibit, then the jury will not get the redacted information. Not everything that happens in a case is proper evidence. So the jury will not get all of it, which In this case, there's been things that are referenced that the jury will not get, and I'm sure it's incredibly frustrating to them because at some point you just want to know everything. And if you know there's something you don't know, it's like, why can't we know it? The rules of evidence are pretty, well, they seem pretty simple, but there are a lot of them.
Go along.
And you fill out all the details you find important in your report?
Correct.
For reference, and to assist us, I have some blank diagrams that I may ask you to point out things on the blank diagram for us.
Okay.
And Your Honor, I'd ask permission. I've spoken to defense to use these simply as a chalk.
Sure.
So he's going to show the jury what the blank diagrams look like, which are just
Before
an
you
outline,
begin
front and back of a
an
body.
autopsy, do you seek any medical records if available?
Yes. When a case is called into our office, depending on the time and the day that it is called in, our intake department, who are the people initially on the phone taking the information, will start asking for both medical records as well as police reports. So in the morning when we start the autopsy, it's possible that we have some records. Sometimes if a decedent is brought to us from the hospital, there might be some records that come along with the body. But to answer your question, yes, we always ask for medical records, what we call PCP records, which are primary care physician records, any records from a hospital where the decedent may have been, and investigative reports, police reports.
Do you recall whether you had access to John O'Keefe's medical records from Good Samaritan Hospital?
I did have
Jojo,
access.
the family normally
yes,
has
in
the heads up
the day
and can opt out
I believe
for
the
the
day
entire witness.
of and the following day.
It's generally not proper for a family to get up in the middle of a witness testimony and leave, though sometimes it happens. But witness families should be given the heads up that this is the witness that's coming up so they can choose to not be in the courtroom for the entire testimony. And a lot of families choose not to be in the courtroom for the entire testimony of the coroner.
Yes.
Subject to any
They also would have known what the coroner report says and all of that beforehand.
No
So
objection, Your Honor.
Exhibit 155.
the Keller, it really depends on the lawyers, and it really depends on the lawyers and how they interact.
This
But
time I would move for identification.
you can do your
all
job
photos of Mr.
without making it personal.
Injuries at Good Samaritan Hospital just for identification.
Okay.
Civil law tends to be a little less civil in that
JJ
way.
for ID.
Criminal law, people work together a lot.
Further, this time I'd move for identification all OCME, Office of Medical Examiner photos.
I saw EOS Rose say, sorry, Emily, I have to come back later. Don't apologize. We will let you know in the app when we switch to other testimony. If you need to opt out of a witness or don't want to hear coroner testimony, do not apologize to me. It is it's take care of you. There's some testimony you might not want to hear. You get to opt out. And that is the great thing about watching it. And the replay crew can zoom because we have timestamps down below. We will let you know when we get to cross of this witness. And then we will let you know when we get to the next witness after this. Not everyone wants to hear this testimony, and that's okay. I'll summarize it in the case briefs if we learn anything new, and I'll summarize what her findings are. So no need to apologize to me.
With the court's permission.
We're all good. You take
Ms.
care of
Gilman,
you.
if you could put up the diagram, full body.
So this should just be the exhibity one that's blank. And when I say they cover all of the
Enlarge that a
tattoos,
little
they
more.
really
Thank you.
do. Some coroners are pretty good at
Could you explain this to
recreating
us?
tattoos. Some not
Yes,
as much.
this is
no, this is not the blank one. This
diagram
is him.
that we use
Okay.
during every autopsy. As you can see, we note the name of the decedent. Every case has its own number. In this case, it was 22-1697. And then we take note of, as I mentioned, during the external examination, physical characteristics such as hair, eyes, teeth. And then on this diagram, we
Height,
would
weight,
note
age.
any scars we see on the body, any tattoos we see on the body, any injuries we see on the body, and any therapeutic interventions. Those would be things that are sometimes done either by emergency medical personnel or at the hospital. Everything would be noted on this diagram.
So depending
Now,
on
if you
how
could
much
take us through, I'm
medical
going to
intervention
ask
is,
you-
they'll talk about it.
We'll go body part by body part, if that's okay. I'm going to ask you to begin with Mr. O'Keefe's face, the front of his face. And
Yes.
if you could enlarge that, Ms. Gilman? Thank you very much. Did you notice any injuries on Mr. O'Keefe's face? And if so, could you, I think there's a pointer available for you, Doctor? If you could
Yes.
point out on the diagram what you observed.
So on the diagram, well, first of all, there was medical intervention on Mr. O'Keefe that included an endotracheal tube that had been placed to help him breathe. But once all the intervention, all the medical devices were removed, I observed on his right upper eyelid a 1 centimeter laceration. So as we're looking at the diagram, this is the right side and this is the left side. So on his right eyelid, there was a small laceration. I also observed abrasions on the anterior and the left aspect of the nose. So the nose would be here on the front and the left aspect. Abrasions are scrapes. Lacerations are tears in the skin. I should probably explain that.
She's like, let me back up real quick.
There was some bleeding and some swelling of the eyelids of both eyes.
Does that complete your analysis?
For the front of the face, correct, yes.
May I approach, Your Honor?
Yes.
All right. As they approach and go back and forth, I'm going to answer some questions. Kenny Wu said, Emily, you say you knew they'd call the coroner. What about the former Trooper Proctor and either Brian? See, that is a harder thing to answer, and I appreciate the question. I'm leaning towards they're trying not to call Proctor.
Yes, this is
I
a
don't know if they'll
photograph
call the
of
Bryans
Mr.
either.
O'Keefe's face.
But
That photograph depicts
they're going to call the coroner and another medical expert. So
Yes,
This one's an easier
it
call for
shows
me.
the small laceration that I noted during the autopsy on the right eyelid. You can see some of the swelling and some of the bleeding over his eyelids. And
they've handed her photos.
That's pretty much all I can see because
Those-
it's a side view.
Is there an apparatus?
There.
Those are photos that the jury will see, but should be redacted for dignity and privacy to the internet. When they are handing photos back and forth onto the stand, do sometimes you end up seeing them in court? Yes, you do. So that is a possibility here. We don't know if that will happen. I hope it doesn't, but it can. So if autopsy photos are a no-fly zone, we will let you know in the app when we switch witnesses. And let us continue on.
There
But the
is
jury will get to see them.
what we call an endotracheal tube, as well as a C collar or a C stabilization collar. That's something that would have been placed
From
on
the
him
hospital.
by medical personnel.
And they go to the ME's office with the medical apparatus still on. The medical examiners remove that.
All right. So, folks, during the testimony of Dr. Scordi-Bello,
The court's gonna also
photos
give a
will be
warning.
Introduced to you. There are photographs of John O'Keefe that Dr. Scordi-Bello.
Not all courts do this. I
From
like
the
this very
autopsy.
much.
So you'll have them in the jury room with you. I'll put them in an envelope, or I'll ask that they be put in an envelope. So if you don't want to look at them now, you don't have to. At some point, we'd ask that you make sure you look at it. These photos are not pleasant, and you may find that they're graphic. But what's important for you to know is that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not based on pity or sympathy for Mr. O'Keefe, which might be occasioned by these photographs. So consider the photographs only as they draw your attention to a clinical, medical status, or to the nature of Mr. O'Keefe's injuries, or to the nature of the incident itself. So they'll be displayed up on the screen for you as well.
They're going to be displayed in court. We should not see those. and then they are put distinctly so the jury can look at them more if they need to or want to. This is not the most graphic
Still,
case
can
of
you show the
criminal
jury?
cases, but it's still not something people deal with in their everyday
Doctor,
life
can you
unless they
point
work
out the
in
injuries you were describing
criminal law,
by
medical,
using the
what have
diagram,
you.
or when you
But
were using the diagram?
I really like the way this judge instructs as they go along, and I appreciate the judge giving everyone a heads up. It's going to be, I think, more prominent in cases like in Idaho and the Koberger case and others, but it's still difficult and something that I think all courts should pause before they do that and give the jurors a heads up. I really do. I appreciate it quite a lot.
So the laceration, the small laceration that I previously described would be here on the right upper eyelid of Mr. Keefe. You can see some discoloration that's bleeding under his eyelid and what I would describe as swelling. The endotracheal tube and the neck collar are also present here. And the other injury, which I noted, was on the front and left side of his nose, which you cannot see here because this is looking at the right side of his face.
Take that down, please. You mentioned that there was something about his eyes that was
Lucy,
notable.
Yes, there
They-
was bleeding or hemorrhage.
they are going to be shown in the courtroom. They are not going to be shown here. They are sealed for the case. I think autopsy photos should be sealed. The ones that are public are the arm. I think there's probably plenty of people that disagree with me on that, and that is fine with me. There are some things that need to stay in the courtroom. We will see argument about it, but they will not put those up on the screen.
As we call it, on the eyelids as well as swelling.
I'm going to ask you more detail about that later, but was that observation important in your ultimate diagnosis or conclusions? May I approach, Your Honor?
Yes.
So the jury will get to see it.
Another photograph, do you recognize that?
There will probably
Yes,
be
this
glimpses
is
as those get
another
passed back and forth, though.
picture showing Mr. Keefe's face. Again, the medical intervention is present, and you can see more clearly now the discoloration on the upper eyelids.
Is this vantage point helpful for your ultimate conclusions and diagnosis?
Yes.
Your Honor, move this into evidence.
No objection, Your Honor.
Jordan, thank you so much for the kind comment. Jordan Payne in the chat said EDB off the subject, but I love how you normalize ADHD. You make me feel more confident in my ways. Look, I'm
With the
always
court's
going to talk
permission, I'd
about
like to
it.
show this to the jury.
Otherwise, it becomes the elephant in the room.
P645, please. Doctor, could you point out what was significant regarding Mr. O'Keefe's eye area?
So I noted that there was discoloration, that's bleeding, that's blood, that's under those eyelids. The eyelids appear puffy, that's what we call edema or swelling. And then also there were two abrasions, two scratches on Mr. Keefe's nose. You can see one here and then the other one on the more front part of his nose.
Could you take that down, please?
So they're going to go through all of the external visible injuries, and then they'll go to the internal injuries.
If we could move down a bit to the chest and stomach area, did you make any observations about this area, Dr. Scordi-Bello?
The observations that I
They-
made on
Did you see me
the
moving to my mouse
chest
just in
were
case?
that there was, as I mentioned before, there were defibrillator pads on the body.
Her notes have all been redacted off of this, so we'll let her explain.
And there was an abrasion that's very commonly seen in people who have undergone resuscitation. Internally, that abrasion and the whole resuscitation apparatus was associated with some anterior rib fractures, which are also seen in cases of resuscitation, but I didn't make any other notes in terms of trauma on the chest or abdomen.
So
I'd like to move
the
to
trauma she's describing to John O'Keefe's chest and abdomen, she said were consistent with efforts of resuscitation, which is a difficult process. And we will get into the different levels of muscle tissue, I'm sure, at some point. But the broken ribs and what have you is, she thinks, coming from resuscitation. And I agree with her.
the arms and the hands. If we could come down
Her
just a
report
little
isn't
bit.
evidence.
Let's begin with
As you're asked
Mr.
why
O'Keefe's
redact
hand
if it's
or
part of the
hands.
report.
Did you
Her
make any
report's not evidence.
observations regarding Mr. O'Keefe's hand
Her
or
testimony
hands?
is.
Yes.
Cheryl, yes, it is. It's not
On
great.
his upper right arm, I noted that he had a superficial abrasion. So it would have been,
With John O'Keefe, I believe it was both manual and mechanical resuscitation.
Could we move that
They
down a little
move
bit?
it
once
down
they
a
got him
little
into
bit.
because
Yeah,
Karen
thank
Read
you.
tried to resuscitate him, and so did Jen and Carrie in different ways. And then when he was in the ambulance, they used the CPR machine once he was in the ambulance. But
somehow.
there were attempts,
Sorry if that's not working well.
and there were manual
It's
compressions
projecting
before
here,
he was
but
in the
not
ambulance.
on the actual picture.
And you actually see it when they show the camera from the dash cam. You can see one of the paramedics doing manual compressions before they get into the ambulance.
There may be a second pointer.
I can do it here.
Okay, great.
Yeah. So on the right upper medial arm, that would be the inner side of his arm, there was a superficial abrasion. Again, that's a scrape. Then on his right posterior arm and forearm, so not exactly on this aspect of the arm, but on the back side of the arm, which would be in the back of the diagram, there were multiple abrasions, which I described as ranging from 2 to 3 millimeters and up to 7 centimeters. Then, if you could move the diagram down.
Brittany Phillips,
please.
they do. We have lots of medical.
Again, there
Professionals
is a
in the chat who will
back
explain.
to this diagram. I don't know if you could put that on the screen. There we go.
She's
So
like, I need
this
to
is now
explain.
the right side, and this is the left. I noted that there were 2 bruises on the back of his right hand. Also, a faint scratch on the back of his left hand. And then moving down to the lower extremities or the legs, if you could please show the front, there was a small abrasion, a small scrape on the side of his right knee.
May I approach, Your Honor?
Yes.
Alley Cat, the court had told her she could refer back to her report.
Yes. This is the back of Mr. O'Keefe's right hand, I believe.
That's fair and accurate depiction.
So that is the photo from his hand.
Yes.
No objection, Your Honor.
Okay.
The Steve asked about lower extremity injury. The only lower extremity injury was she described as a quote small
The court's
scrape
permission, I'd show P647
on
to
the
jury.
right side of the knee. That was it. And the hand injuries they're going to talk about, and they're going to show that photo. I agree with
Could you explain? You said there were 2
you, Chad,
bruises.
that
Could you
is
point those out
medical
for us?
intervention.
Yes. There's one here and one here.
I'm surprised that they've chosen to show
Did
that
you
one, but they did
attempt
redact
to
out the medical
assess those to
info
determine
on
whether
his
you could
bracelet.
conclude or
It's helpful.
opine on a cause of those?
No, I did not. Well, I take that back. I'm sorry. So this particular one has 2 small little pinpoint defects in the middle, which we sometimes see when
Yeah, those are
emergency
punctures from
personnel
intervention.
tries to get access to a vein for fluids, for intravenous fluids. So But I did not put that in my report. I just described it as a contusion.
What that looks like.
Is it common to see that type of coloration where medical personnel put intravenous or other types of support into somebody's hand?
Yes, it's very common for the skin to bruise when someone tries to get access to a blood vessel.
The other coloration that is unrelated to those two small points, would you have a description of what those are?
No.
I'd also like to show you exhibit number 1.
Yeah, those
Exhibit
look like
number one,
IV
please.
punctures
Thank
to me as well.
You use the word superficial. What does that mean?
Superficial means that the abrasion is on the.
There are lots of questions about the hand IV. I don't think they asked EMS about it this trial, and we haven't heard from anyone at the hospital. I don't know if we will get to that testimony this trial. The jury does not have that information yet, but they were treating this as a code until he was warmed back up at the hospital. So they were still undertaking measures, but they did not ask. They did not ask any of the paramedics about that, and they haven't asked the hospital. So they were trying to resuscitate him until they called it. And remember, while this was happening, he was also undergoing CPR until, well, the hospital hasn't testified. I wonder if they will. And they will tell you when they terminated that. But while they are undergoing those measures, yes, there would still be blood moving around in his body because they have a machine moving blood around in his body. So, and then they puncture. If they puncture it, those look like puncture to me, but if they puncture it, then it's going to bruise because there is still blood moving around his body because they are still doing CPR and intervening measures. Have they explained that clearly in court? No. But can we have that conversation in the chat? Yes.
The superficial layers of the skin, usually the epidermis and sometimes the dermis, but there's no penetration of the skin.
When you're assessing to determine whether there's any penetration, do you measure the length of the wound, of the abrasion?
Penetration would be measuring the depth.
These are
If there was
John O'Keefe's
actual
arm.
penetration, I would have to measure how deep into the skin. For example, when we assess stab wounds, we have to measure the depth of the wound. In this particular case, you can see that these are scrapes or scratches, and
right.
there's no exposed underlying fat or
Tissue or
muscle. And therefore, to answer your question, I measured their length and gave a range, but I did not measure their depth.
As a routine practice during an autopsy, doctor, if there was penetration or depth, would you, as a routine, measure that?
I would make a note of it.
Are there any such notes in any of your autopsy findings or reports about depth?
No, I
because
did
they're
not make a
superficial.
note on the depth of these ones.
Do you have an opinion to a reasonable degree of medical certainty as to how those superficial abrasions occurred?
I don't think she does.
I do not.
Right. I was going to say, I don't think she does.
And I asked you about the hand, which we just saw, and I should ask you the same question. Do you have an opinion to a reasonable degree of medical certainty how that coloration, aside from the medical intervention, do you have an opinion to a reasonable degree of medical certainty how the other discoloration happened on Mr. O'Keefe's hand?
I can state to a reasonable degree of medical certainty that that's a bruise, a contusion, but I cannot tell you how it occurred.
Iona asked
And
why wouldn't she
to
measure
summarize
those?
finally what we've been through so
She's
far.
talking about measuring the depth of the injury. Those are superficial. There is not a depth layer where those injuries, as she said, are not getting into muscle layer, fat layer, or bone. So she's not measuring the depth of that. I don't want to be too graphic about it because some people are probably still eating, but they are superficial enough on the top of the skin that you're not going to measure how far into the body they go. We will talk about whether or not they were measured later, but again, spoilers. When she photographed them, she did not put a ruler on them. I think that'll come up more in cross. So this is going to be, well, we'll let her explain measuring the length, but she did not measure the depth, which makes sense in this circumstance.
Regarding the scrape on Mr. O'Keefe's right eye, can you provide an opinion?
Neon said,
to a
how do you know
reasonable
they're
degree of
not deep
medical
if you don't
certainty
measure?
How that
She can
scrape
see
occurred?
that. They are superficial
No,
scrapes.
I cannot.
She can visually ascertain that they do not go into the lower levels of the skin. Those are superficial abrasions. They are not deep.
You mentioned for us that when you looked at Mr. O'Keefe's legs, you observed bruising on his, or a small scratch on his right knee.
Correct.
I don't want to summarize it. Can you describe
I'm not going to be
that
graphic about how you can tell, but you can tell. You can tell when they are.
Yes, I described it
multiple layers.
as a 0.5 centimeter abrasion on the right lateral knee.
Did you see any marks or abrasions on his left
Right
knee?
lateral knee.
No, I did not.
Was the mark scratch on Mr. O'Keefe's right knee on the inside or the outside of the knee?
Shay, we haven't
It
gotten
was
to that
on
yet.
the lateral aspect, which would be
That's
the
the question.
outside.
Thank you. May I approach?
Yes.
Sherry said, I'm assuming the testimony will be exactly the same as the first trial. I think it'll come in a bit differently because Trooper Proctor hasn't testified.
Yes.
Former.
What is it?
This is a picture of Mr. O'Keefe's lower extremities, his legs.
Is it a fair, accurate depiction of how his knee appeared when you did the autopsy?
Yes.
It's me and my glasses all the time.
No objection, Your
Relate.
Honor.
Okay.
Lily asked, how is this helping the Commonwealth? They have to establish that John O'Keefe died and they have to establish what his injuries are. And this is the witness that is going to establish that. So,
With the court's permission, I'd like to show the jury 9467.
Yes.
his lower extremity injury is the
You used the word lateral. and you
half
talked
centimeter
about,
abrasion to the right lateral knee.
abrasion or a scrape. Could you
We haven't gotten to those
look at this
witnesses yet,
photograph?
Angel.
Could we enlarge it, Ms. Gilman? Could you
And
point
they
that
are
to
showing
jury
the photograph
and
of John
explain what
O'Keefe's
it is
lower
that you saw?
extremities.
Yes, you can
These
see.
are photos from the hospital. You can see that there's also medical intervention on the leg. I don't remember seeing these photos. These are not from the coroner's office. These are from the hospital. I don't remember seeing these photos first trial if they were omitted. I don't remember them talking about his knee the first trial at all. So those are up on the screen now. And I say that because a lot of people listen in the background and some people want to avoid the photos.
See the abrasion here with a little bit of adjacent discoloration, but this is what I was describing.
We
You
also
could zoom
haven't
back out.
we haven't heard from the hospital yet, but the hospital did try to use warm saline to the best of my memory in resuscitative measures. They took quite a lot of measures at the hospital, but we haven't heard anyone from the hospital discuss it yet. So those are the photos of the knee.
Please. And you didn't see any similar type bruising or abrasions on the left knee?
No.
During your autopsy, did you notice any injuries internally to Mr. O'Keefe's rib area?
Yes, I did note that there were rib fractures on the anterior, that would be the front, of his fourth and fifth ribs.
Cheryl,
So would that be his
they
left
interviewed
or
them. They
right
have
side?
not testified.
It would be both the right and the left, and it would be the part of the rib that is closer to the sternum.
Is there a number of ribs that had fractures, or are they connected as one?
The fourth and the fifth, both on the right and the left, close to the sternum.
Yeah, the rib fractures are from resuscitation efforts.
Have you, in your experience, seen ribs fractured during first aid or medical intervention?
Which is what she's going
Very
to talk
often,
about.
yes.
Those are fairly typical,
Given your experience and your study of Mr. O'Keefe's
both where they
body,
are, that they're
do you have an
bilateral.
opinion to a reasonable degree of medical certainty how those rib fractures were obtained?
I believe those rib fractures were due to resuscitation.
And you have that opinion to a reasonable degree of medical certainty?
Yes.
And there's her opinion on that. Yeah, everyone in the chat who has
I'd like to
performed
show you a
CPR
different diagram,
is
one
like, yep,
of
that's what that is.
the head area.
Again, I'm trying to
could
not
enlarge the
overly go into
bottom
detail to
right.
explain. CPR's
Thank
hard.
you. Using that diagram, could you assist us, doctor, and explain to us any observations you made?
I will just
about-
say, no matter how much you have done CPR training, annual CPR training, all the CPR training on the dummies, it's just not the same. It's just not the same. However, when it's something that you do regularly at work, I would imagine you get used to it. I was an EMT very briefly. I was like, this is a no for me. This is a no for me. This is all a no for me as I am 100% out, but it's different. It is different. It's
the
different.
back of John O'Keefe's head.
Yes. The main observation was a laceration that
Right, these
is
are
a
the
skin
injuries to the
tear
skull.
on the back of Mr. O'Keefe's head.
Or to head and
To the
skull.
right of midline. So this would be the midline. The laceration was somewhere here, is what we call the right occipital area. And associated with that, there was an abrasion over it that would have been here. So this was what we call a compound injury, an abraded laceration.
Abraded, not braided like braid your hair. Abraded laceration.
Turn in a few moments to your autopsy observations about the inside of Mr. O'Keefe's skull. But first, I want to just show
I
you a
never had to do
photograph
CPR as a lifeguard,
relative to what you
thankfully,
described
but I
to us.
lifeguarded
May I
as well.
approach, Your Honor?
Yes.
I actually became an EMT because I did want to get paid more lifeguarding and such. And then I worked in the hospital bit, went, nope, back to lifeguarding.
Showing you a photograph.
Until I tore my rotator cuff, and then not that either.
Photograph.
Yes, this is a picture taken at the time of autopsy. This is the back of Mr. O'Keefe's head. The hair has been shaved off so that the injury can be clearly photographed, and it's a laceration with an associated abrasion.
Your Honor, move this.
They will also discuss the level of those injuries. They will, what was observed. She talked a little bit about before the head was shaved, after the head was shaved, etc. Heather, see, it is the summer job, especially if you can lifeguard while at the same pool where you have all your water polo, which is what I did most summers growing up. It was water polo practice, guard practice, lifeguarding, swim lessons, water polo games. I think I was damp for an entire summer. My hair never quite dried. And
When
was
you
shades of
examine the
green.
laceration, do you measure it?
Yes,
Did you measure it in this case?
I did measure it.
How long was the laceration?
I measured it as 2.5 centimeters, which is close to an inch.
Do you examine a person's body before you begin to intrude?
Yes.
Do you examine the outside of a person's body first, or is there a certain
Yes.
procedure?
She talked about that
or order?
already.
Yes, the external examination is done first, and the internal examination is done second.
JC,
I want to show you that
later.
photograph that you just recognized, and I would like you to explain what you see to the jury. Ms. Gilman, with your assistance, thank you.
Michelle, I also
This is the
appreciate her
laceration
translating the
that I
the
noted,
injuries.
and this is the scrape that's associated with it.
take that down, please?
Also, there are times.
After you make observations, what are your next steps in an autopsy?
There are times that Brennan might be asking again for a point of reference for the jury. There might be times because he just forgot that she already answered it, but it might be bringing back the point of reference to the jury.
The internal examination, after the external is performed and pictures are taken, then we proceed to the internal examination of both the, as I mentioned before, the torso, the body, as well as the head.
I'd like
in
you
the
to take
chat,
us
more
through
of the first one.
internal examination. Did you have a chance to look internally behind the laceration you saw on the back of Mr. O'Keefe's head?
Yes.
And when you did that, could you describe for us what you saw?
Yes. The way we examine the head is we make an incision with a scalpel.
She's going to describe both the external and
behind,
internal
the
injuries
ear,
at this point.
from one side to the other.
The process she is going to describe is not pleasant. I'm just going to give all of you a heads up, but it's necessary to get into the injuries.
Allows us to reflect or pull back
Yep.
the scalp, and that will expose the skull underneath. We do this carefully so that we don't disfigure clearly the face. And when we reflected and when we pulled back
Very
the
good
scalp,
at describing.
I
a
noted
brutal
that there was
process.
blood, what we call hemorrhage, under the laceration or associated with the laceration on the back of the right head. And then
We will let you know in the app. when we
furthermore,
move on to a
there
different
were
witness.
skull fractures associated with that laceration, abrasion on the right side of the head.
Were the skull fractures in the same or different area?
The skull fractures were in multiple areas of the skull, what we call the base of the skull. Imagine the base of the skull is sort of a bowl, and the brain sits on top or in the bowl. When the brain is removed, you can have a very good view of the base of the skull.
Yes, they do that too.
So when the brain was removed and we were able to look at the base of the skull, I noted that there were multiple fractures that appeared to be originating from the area of the laceration, or what would correspond to the area of the laceration.
When you made your
So the
examination,
fractures to the skull correspond with where the laceration was on the back of the head.
the
It's
fractures
on the
in
same
the skull,
spot.
did that lead you to your opinion, or was there more you needed to look at before you came to an opinion about the cause of death?
Well, that was part of the findings that led to my opinion. But yes, I removed the brain, and as is our protocol, I saved the brain in a special solution called formalin that allows the brain to become a little harder, so that our neuropathologist in
This is the
Boston
whole
could
process.
go ahead and examine it. Because when I did look at the brain, I noted that there were injuries. There was bleeding on top of the brain. And therefore, I saved it. The brain ultimately went to our Boston office, and
I bet we'll see that
our
witness next.
neuropathologist, Dr. Stonebridge, examined it and issued a report.
Did you engage in any type of analysis on your own about any injury to Mr. O'Keefe's brain?
I noted the kind of injuries I could see superficially on the brain, and I have looked at the brain after it was fixed and pictures of it, but I did not issue a report on it. The whole point was for our neuropathologist to examine it closely and issue a more detailed report.
I have a few more photos. Would now be an appropriate time for a break, Your Honor?
Yes.
Oh,
So, jurors, why don't we take 15 or 20 minutes?
okay. They're all just taking a break. Well, I guess it's time for the morning break. And we will get there. So, question: can you be a court reporter with visible tattoos? Balrog ballerina, I would think so. I guess it would depend on the jurisdiction and the particular court, because different jurisdictions have different tolerances. But visible tattoos in most jobs have changed, unless I think there are probably some maybe courts that are less tolerant, but also court reporters work in a wide variety of ways. And I'm sure there's court reporters in the chat who can answer this better than I can, but who work in depositions, who work with law firms, who work in civil. So there's lots that is also outside of court, but also sleeves are, I mean, I wore sleeves in court all the time anyway, because it felt right to me to wear sleeves in court. So you didn't see the tattoos that I had then. A lot of the attorneys I worked with, most of law enforcement that I worked with, were able to just wear sleeves to cover them up, and law enforcement would wear like the Under Armour one sleeve. And now it just doesn't seem to really matter all that much anymore. And jurors, I don't think, care. Some people may still, I don't know. I think people are probably, if they come through this channel, more put off by my cursing than my tattoos. Because occasionally I will see that. This is a long morning break. Are they still on break? Oh, they're barely back from break. And immediately to sidebar. I'm going to answer some questions while they go to sidebar. And I just don't, but again, it's not a deal to me. And I think there's different states and different courts have different tolerances, but I don't think it's the end of the world, truly. I really don't. So, even Starbucks changed their policies on visible tattoos, as they should have. Kel Marie said, is it weird to find the Emmy fascinating rather than graphic? Not at all. I also think this medical examiner, as many do, does a really good job of trying to neutralize what could otherwise be graphic testimony and stick to the factual testimony and then stick to more scientific language. So it is not graphic. They're also, the jury will see the pictures. They do not show them for long. There are some things that will not be photographed. So no, it is, I don't think there's anything wrong with being like, okay, that's interesting. What are we learning? Holly and Brooke asked, Emily, is there a judge school or do they just wing it? There is a judge school. I imagine different jurisdictions do this differently, but judges generally should have been attorneys practicing in court for quite a while. So there's a lot that they know, and then there's a lot that they learn. And then there are different ways that different jurisdictions do judge school. Most of the judges I know are in LA, so I know how LA does it, but different jurisdictions do that differently. But yes, there are also books, and you also have peers that you can go ask for new judges. I think one of the hard things for new judges is the amount of paperwork. It's so much paperwork, especially in criminal. It's just so much paperwork. It looks like the members that are choosing to be in the gallery from the victim's family are there. I do not see the victim's mother in court. I'm not surprised by that. I don't know if she just walked back in. I don't think that's her. Nope. So let's get us caught up to real time. We are caught up to real time. There is no more Zoom room. Jordan said, in my town's history, only one judge has ever had legal experience. The rest have been farmers. Well, I would imagine if all the judges have been farmers, then the cases they're dealing with maybe also deals with that, and that would be fine. But yes, you generally want judges with legal experience. So let's see. Laura asked, are there any photos or notes of his inner arm? She noted everything that she saw. And so we've gone through that testimony, but no, she didn't. Inner is difficult because I think some of those came across the top of the arm a little bit, but there wasn't anything else. Jasmart asked, can they ask about the level of healing to the knee? Looks older. They can ask that. I'm sure it will come up on cross if it does not come up on direct. Let's see. Kristen said, I think it's important to maintain the victim's dignity and to take the grieving family into account. It's hard enough to see those images in court. I agree. I don't think, well, I told you guys how I feel about sealing images. There are some things in court I think it is excessive to seal, some things that I agree with, and autopsy photos are one of the things that I agree with. And I know that there will be those that disagree. They can disagree. That's okay. I have my perspective on it. It's like in the Diddy case, there's a lot of media fighting over whether or not the videos of particularly the freak-offs will be released or not. I have, the media is like, the media has the right to access. And I'm like, well, yeah, but the victims also have the right to not have those things public. So I think they should stay sealed. CJLA gifted 5 memberships. Thank you. Sarah said, I was telling my husband about the hear ye's and he was laughing for 10 minutes as I tried to imitate it. Yes, the hear ye, hear ye, hear ye. All right. Avril said, did they take anything from under his nails? They haven't gotten into that testimony yet. She has not talked about it yet. The last witness talked about the fact that was submitted to the lab, but the witness that would have gone through that hasn't testified yet. So yes, we'll get to it.
Those were both marked for ID, so one
All
will be
right.
coming into evidence and one will be a chalk, so you may need to have them available for the witness.
I was just listening to what the court said because it is quiet. So they are bringing the witness back. Cleopatra asked, are the witnesses advised to look at the jury when speaking, or does this make an impact on the jury? It depends on the witness and how they do it.
Sit or stand wherever you're more comfortable
The
for now.
scientific witnesses, law enforcement witnesses, when they explain, they tend to look at the jury because if you're explaining something scientific, it's really hard to understand if you're explaining it well without looking at the jury. If they seem confused when you're explaining something, you can explain, because scientific witnesses, particularly and experts, are truly trying to teach something to the jury about what they know. And you need to look at the person you're talking to understand that. With other witnesses, fact witnesses, witnesses that have witnessed something horrific, sometimes it's really hard for them to look at the jury when they're talking about it and they just lock in on the lawyer. It depends. But if witnesses are overselling and like staring down the jury, I think that can get uncomfortable. It really, really depends on the witness and how it is done. Some witnesses, it seems very natural and very appropriate. Some witnesses, it feels very forced. I wonder if Alessi's doing cross because he's chatting with Brennan, and that wouldn't be surprising to me if he did do the cross. So let's see. Nicole said, currently watching EDB instead of studying for a psych test that I have in an hour. Nicole, you got this. You already know. Get some food, hydrate. It'll be good. It'll be good. Let's see. We're going to answer some more questions. Clea asked, and I hope I pronounced that properly, is jury nullification an option here? Jury nullification generally refers to when there is overwhelming evidence and the jury says, yeah, but we don't agree that this should be a crime, or yeah, we're not convicting this person. The overwhelming evidence part goes hand in hand with jury nullification, where you look at a case and you're like, that person should be convicted. And the jury's like, yeah, we don't want to do that. This is not that case. I think there's a lot of question in this case. We are not to the end of the Commonwealth's case yet. But when there are questions of doubt, jury nullification doesn't really come up because that's just the jury having a doubt versus the jury saying, well, this is a confession on tape and they're on tape doing it. And the jury's just like, no. Have I seen cases where jury have nullified things like that? Yeah, I have. The defendant took the stand in a case at the courthouse where I worked and explained why they did the thing they did and explained that they did it. It wasn't a proper legal defense. There are proper legal defenses where you can say, I don't have the mens rea, or Sarah Boone tried to run a defense in the battered spouse realm. Those are legal defenses. This wasn't a legal defense. It was, I did this. This is why I did this. And the jury went, agreed. Could that person have been convicted? Yes. Did the jury decide that that was not what they wanted to do? Yeah, 100%. So that's really the situation when we're talking about jury nullification. Could the jury find doubt here? I think there's a lot of conversations about whether or not there's doubt in this case and what, if anything, the Commonwealth will do to overcome that doubt. Thank you all for the gift of memberships. I think it's a good conversation to have, though, to understand jury nullification. So let's see. Kayla said, hi, EDB, passed my legal studies course with a 96, but barely passed Spanish with a 72. You're doing great. Have you ever exceeded in law classes but failed in easy ones? Oh, my academic record is a mess. We're not going to talk about that. It wasn't necessarily law, I find, with the ADHD particularly. I did much better in classes I found really interesting, and I got to choose for myself, and not as well in classes that I was made to take that I did not find interesting. It was all based on interest for me. And so it's really hard to force yourself to study something you don't find interesting. It's really easy to take a rabbit hole and play, I don't know, SimCity for, 72 hours straight because you're interested. It just focus is the thing.
Doctor, when we left off,
The more choice you have, the better it gets.
all the injuries to
If they do not turn these microphones back on right now, I am going to fall over. I have not turned this down. The pool camera has not turned these back up.
the exterior of Mr. O'Keefe, and we had talked about your observation of both the fractures in his skull and also your observation of Mr. O'Keefe's brain.
Good Lord.
You mentioned earlier that you use other resources, other testing. Did you
There we
ask
go.
for any type of assistance on toxicology analysis for Mr. O'Keefe?
That's an awkward question.
Yes, it is routine.
Everything
and
goes
it
out
is
for
protocol
tox.
to submit toxicology specimens to the lab for examination.
May I approach, Your Honor?
Yes.
I think we'll get to toxicology results. Lyndon, also Civ.
Doctor, I'm handing you a document. Do you
SimCity,
Yes,
SimCoaster,
this is
Civ, all of it. I love those
the
games.
report of toxicology from the State Police Crime Lab for Mr. O'Keefe's autopsy.
Have you seen that document before?
Yes,
Is that a fair and accurate depiction of the report you saw before?
yes.
Do you want to introduce this as the next exhibit, please?
No objection, Your Honor.
The tox reports will be in evidence. They are putting those into evidence. Zoo Tycoon was also great.
Thank you.
In your experience, Doctor, are you familiar what the toxicology report and the testing involves?
I'm sorry, what was your question?
Are you familiar in your experience with what is
Yeah.
involved in a toxicology test?
In general terms, yes.
And if you studied Mr. O'Keefe's toxicology report, was that important or part of your analysis in your ultimate conclusions?
It was one piece of evidence that I took into consideration, yes.
In the toxicology testing, is there a search to see if there are any type of drugs or medications in Mr. O'Keefe's blood?
Yes.
Okay. And was there any?
There were
Alcohol.
no prescription medications. There were no illicit drugs in his system.
In a toxicology, is there also a testing for blood alcohol content?
Yes.
Yep.
What is the difference between ethanol in heart blood and ethanol under 1102?
In vitreous humor.
Yes.
So we usually submit multiple specimens for toxicology. Some of the specimens are used for screening of classes of different drugs, and then other specimens are used to confirm, the presence and quantify a particular drug. So in this particular case, the lab tested the heart blood, which showed that it had an ethanol level of 0.21 grams per deciliter. And they also tested the vitreous, which is the fluid that sits behind the eyeball.
Yep.
And in that specimen, the ethanol was slightly higher at 0.28.
Thank you, doctor. After your autopsy and observations of Mr. O'Keefe's body, inevitably, did you come to a conclusion about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about
Can you
the
just
cause.
ask? Okay.
To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes, the cause of death was determined to be blunt impact injuries of head and hypothermia.
You mentioned two different things, blunt impact and hypothermia. Was
Correct.
there a primary cause of death in your opinion?
The blunt impact injuries of head.
Hypothermia, was that sufficient to be a primary cause of death in your opinion?
I mean,
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
because if somebody could get to somewhere warm, she can't know whether or not that person would get to somewhere warm. So we're going to get into cause of death versus manner of death. And then we will get in, well, then I imagine we will get into cross-examination. But it's really hard, I think, for the coroner to say, would hypothermia be the primary cause of death in this case if it were not for the head injury? She can't really answer that because you don't know if this person would have stayed out in the cold long enough to pass from hypothermia.
So if I understand, you are not
The
saying
head
to a
injury is the
reasonable
primary
degree of
cause.
medical certainty that hypothermia was the cause of death.
Not the primary.
Right, it was
It
secondary.
contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, degrees Fahrenheit.
And what is a normal body temperature?
98.6.
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
After you complete your findings,
That's undetermined. Were you able to determine the manner of death to a scientific degree of certainty? No, I was not. So that's the manner of death. The manner of death is undetermined. So I guess the manner of death is no manner of death, which becomes undetermined, but that was her answer.
including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yeah, that's why there's an undetermined category for when
Yes.
it's undetermined.
And what is that document?
It's the death certificate.
Did you do so in this case?
I appreciate
Yes.
the way he's asking
When
about
you file a death certificate, do you include your ultimate conclusions regarding cause and manner of death?
Yes, there is a death certificate that is issued immediately after the autopsy. The death certificate is
it. I
a
appreciate the
document
way
that
he's
is
asking about this.
necessary
It needed to be asked.
for the family in order to make funeral arrangements and proceed with their plans. So a death certificate is always issued at the end of the autopsy. If the cause and manner of death are known at that point, they are stated on the death certificate. If they are not, or if we need to do additional studies, then both the cause and the manner are listed as pending. And that death certificate is sufficient for the family to
Do what
make
they need to do.
arrangements.
Right.
Later, as we get more information, as we get more results from our studies back, we issue an amended death certificate. So that amended death certificate will have a cause and a manner. The amended death certificate, in this case, stated that the cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
May I approach, Your Honor?
Yes.
And yes, the lawyers do need to ask every time that they approach either the court or the witness. It is proper
handing you a document.
and needed
You
courtroom
recognize
etiquette.
that
That's
document?
probably the death certificate.
Yes.
What is it?
This is the final or amended death certificate for Mr. O'Keefe, stating that the cause of death is blunt impact injuries of head and hypothermia, and that the manner of death could not be determined.
Do you recognize that document as accurate?
Yes.
Your Honor, move this into evidence, please.
No objection, Your Honor.
All right, thank you. 162.
All right. That is being admitted. I was going to zoom.
And after the
We had the slightest amount of zoom room.
90 days pass, have you
She described why the certificate was pending and then amended. They do the pending certificate to get it to the family so they can make their arrangements. The amended is within that or after that 90-day window when the final reports are done. Pending means the autopsy is not done yet, but that the person is deceased. When the autopsy is completed, after all the talks and everything, then it can be amended. That is the normal procedure because the family needs a death certificate prior to when the autopsy is done. So it's just part of the process.
done any further study or investigation on this case, Doctor?
No.
Thank you. I have no further questions.
Amanda in the chat asked, how does an undetermined death lead to a murder charge? Because the coroner's evaluation is not a legal conclusion. Just like there are times that the coroner can conclude that something's a homicide because it's caused at the hands of another, but there is still not enough evidence to go ahead and charge someone with that homicide. It is a coroner designation, but it does not impact whether or not the district attorney's office chooses to charge. They're not going to not charge a case because the coroner didn't determine the cause of death. And it doesn't negate it. Is it something that needs to be explained? Yes. And will the prosecution explain it here? We will see. They are not done.
May I, Your Honor?
Yes.
There are also
We have not had.
homicide cases where they never find the victim and they still bring the homicide case. But if they've never found the victim and they don't have an autopsy to be performed, they can still bring charges. It just depends very specifically on the case. All right.
Had the pleasure of meeting, so good morning, Dr. Scordi-Bello.
And we're now on cross with Alessi.
With regard to cause of death as opposed to manner of death, is it correct that a forensic pathologist is tasked with determining that cause of death that includes contributing factors, injuries, and circumstances regarding the medical legal death investigation? Is that a fair statement?
Yes.
And I'm using the term medical legal. Is that a term that you're familiar with?
Yes.
And is it correct that medical legal means, particularly for medical examiners, that there's a medical aspect to the investigation that you perform, and there's also a legal aspect or a law enforcement aspect to it? Is that correct?
Legal's not
Correct.
necessarily
And that's a
law
little
enforcement,
different
but-
than what physicians usually do, right? Because isn't it the ordinary course that it's mostly just medical, but medical examiners by statute and law need to have both of those prongs taken into consideration? Do I have that right?
Yes.
So, in other words, the forensic pathologist, which you've indicated you are, is tasked with determining the cause of death, which answers the question as to why, in more layman's terms, why did the individual's body stop functioning at a particular time, correct?
Yes.
So more broadly, the cause of death is generally defined as the disease or the injury that resulted in the death of a person.
Correct.
So let's now, if we could please,
Do we
move
need to
to
go
the
through a
manner
full
of
direct
death.
examination or no?
And I'd like to
I don't
summarize,
think
I
so.
know you covered it on direct, but I want to put it in a slightly different context, and hopefully I'll get it right. So medical examiners, as you've stated, are also
Mr. Alessi, we have been in trial with you, sir, for 15 days, and we have watched quite a lot of your pretrial motions. Do not tell me, I hope I get it right. Sir, we know you know what you're talking about.
tasked with, if they can,
The coroner
determining the
is just
manner
a
of death
wall of
or
testimony
the
at this point.
circumstances under which the death occurred.
He's
correct?
not going to get a smile out of
So
this
manner
corner, I don't think.
and does involve the circumstances under
We know
which
he knows.
the death occurred.
Yes.
And that causes one to go the medical examiner to go beyond just medical analysis. You take into consideration other factors which we'll get to. Is that correct?
Yes.
So you talked about, and I'm just going to go through them quickly, but if you could just check me on this, the five main
A little bit of a
categories of manner
smile.
of death. So you've talked about natural causes, correct?
Yes.
You talked about accident.
Correct.
You talked about suicide. You talked about homicide. And then the last category, undetermined. Do I have that correct?
Yes, you do.
So what I'd like to do is to focus
knows he
on the
does.
undetermined category.
Well, yes.
And my understanding is, Doctor, that that's where you landed, that's where you concluded with regard to manner of death of Mr. O'Keefe, correct?
Correct.
So undetermined is a term that is used and that you use, and does that mean that when the information pointing to one manner is not more compelling than other reasonable possibilities, or the death
Alessi.
investigation lacks sufficient information to opine on a manner of death, at the time of death, the certificate is signed. Is that generally correct?
Yes.
That is such a good question. It got a little long at the end, but that is such a good question. He brings this in all of his cross-examinations really well. I appreciate when he sticks with reasonable interpretations. Remember, and we're going to back up his question because it was a really well done question, and he does this very well. But at the end of the case, when the jury gets the jury instructions, they will get an instruction about circumstantial evidence. And as they get into those instructions and the reasonable doubt instructions, they will be told if there are two reasonable interpretations, you must pick the one that points towards, and I think in Massachusetts it says not guilt. The exact word may be innocence. I do not remember. But if there are two reasonable interpretations, and he'll say, if there are two reasonable interpretations, you must pick the one that points towards not guilty. So when he has witnesses on the stand and he's asking, is it a reasonable interpretation, this or this, then he is building those stair steps to the eventual closing argument when you hear reasonable here, reasonable here, reasonable here, and he weaves it into his questioning. So for this witness, is it reasonable that it's undetermined because it could be multiple things? It's a very good way of questioning. When he starts pushing into so you doubt, that gets a little bit much for me, but I like the way he weaves this in. He does it very well.
Term that is used
each time
and
he
that
does
you
it.
use, and does that mean that when the information
That's
pointing
not you,
to
that is the court.
one manner is not more compelling than other reasonable possibilities, or the death investigation lacks sufficient information to opine on a manner of death, at the time of death, the certificate is signed. Is that generally correct?
Yes.
So, as we've talked about, I'm just trying to follow or just develop some logic and see if this is in agreement with
There
you.
was a smile.
That as a medical
We're not even like 2
examiner,
minutes in.
You're specifically tasked with conducting that medical legal investigation And what we've just talked about is a bit of the method of analysis that you go through for that, correct?
I conduct the autopsy, and I request information information from the investigative body that is out there investigating the other aspect of the case, not the body itself.
Yes. So is it correct that there's 4 general components?
I don't think the court is getting law nerd alerts for what is going on, but remember, we keep hearing the "you are unmuted" in the audio from the pool camera. I don't know what that's connected to, but we're getting somebody's like calendar alerts today. I don't know why. Oop. Come on.
To a forensic pathologist death investigation. Is scene investigation one of the components?
It depends on the jurisdiction where you practice. Scene investigation is part of forensic pathology in certain jurisdictions, and it is the responsibility of the district attorney and law enforcement in other jurisdictions. In the state of Massachusetts, we are responsible for the autopsy, and the DA's office and law enforcement are responsible for the scene investigation.
Investigations, yeah.
Excellent. So,
Ma'am,
scene
can you tell us about South
investigation
Carolina
in
and the
state of
armpits?
Massachusetts
We have questions.
is not within your domain in the office of the medical examiner. That is the domain of the district attorney and law enforcement, correct?
Correct.
How about another aspect, forensic autopsy and laboratory testing? That's within your domain, correct?
Correct.
And how about police reports and witness statements?
That is not under my jurisdiction. That is under the district attorney's office and the police.
Do you consider information, nonetheless, from police reports and witness statements in your analysis?
Yes.
And do you also consider, even though it's not within your jurisdiction in Massachusetts, do you also consider information about scene investigation?
Yes.
When she has it.
So
He
it's correct then
got a charcoal.
that you consider, whether it's within your jurisdiction or not, you consider scene investigation and police reports and medical statements, correct?
Yes.
And then forensic autopsy and laboratory testing is right within your jurisdiction, and therefore, of course, you consider that. And then lastly, medical history and hospital records, is it, therefore, am I correct that that's something within your jurisdiction and that you consider in performing your
Yes.
forensic pathologist death investigation?
Yes.
Yes.
So now let's move on to the application of those principles. So in order to conduct a proper medical legal investigation, the medical examiner has to have certain qualities, if you will. Is one of them being well-grounded in general medical knowledge?
Yes.
Yeah, you have to be
Is
a doctor.
another appropriate training and experience in forensic?
Except in South Carolina. Apparently, you don't have to be a doctor to be an ME, but that is a side quest that we will not go down today. I was floored. But yes, in Massachusetts, you got to be a doctor.
Forensic pathology.
Yes.
In other words, you wouldn't want a specialist, for example, in cardiology without anything more to be conducting a death investigation. Is
Well, you
that
got
correct?
a lot more training.
I would not want them to be conducting an autopsy. Correct.
Right.
lot of
Would you
training goes
want
into it.
a neurologist to conduct a death investigation?
Personally, or are you asking me that? No, I do. I don't think every physician has their specialty and their training. And forensic pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
Right.
Would you want a neurosurgeon to be conducting a death
Okay, Alessi, move on.
To be performing an autopsy? No.
investigation?
You also don't want a coroner performing your brain
a
surgery.
neurosurgeon to perform an autopsy
No.
because you don't believe they're qualified to do so, correct?
I
Smart.
don't believe they've had the appropriate training to perform an autopsy.
It's a smart question. It's
Going
going to
back
the other
into
experts
the
from the
many
Commonwealth.
qualities of a medical examiner and attributes, They also have to have the ability to form opinions based upon all the available
Smart
information
questioning.
using the scientific method along with sound reasoning. Is that a fair statement?
Yes.
And you're familiar with the term scientific method?
Yes.
And is it fair to say that the scientific method generally is sort of a systematic pursuit of knowledge that involves recognition and definition of a problem? Is that fair?
Yes.
Is it also involved the collection of data through observation and experimentation where appropriate?
Correct.
Does the scientific method also include the analysis of data?
Yes.
Does the scientific method also include the formulation, evaluation, and testing of hypotheses?
Yes.
And does it also, where possible, include the selection of a final hypothesis after considering other hypotheses?
Correct.
So what we've just discussed is a
Is
fair
a methodology?
explication, a fair explanation of the scientific method. And
Correct.
the scientific method is part of the autopsy and forensic pathology analysis, correct?
Correct.
Now, applying one concept, that medical legal concept we talked about, just holding for a moment, if you could, the medical and going to the legal, if you will, law enforcement that you said in Massachusetts is not under your jurisdiction, but nonetheless you consider information arising from it.
Yes.
Are you familiar with a person named Michael Proctor? Is that name familiar to you?
It's familiar
Yes,
to
it
us.
And at one time, Michael Proctor was a trooper, correct?
Correct.
And so did former Trooper Proctor inform you of the working law enforcement theory at the time of the investigation of this matter, namely his working theory, a collision of a motor vehicle with a pedestrian? Did he inform you of that?
He informed our office of that. Yes.
He informed your office. And is it fair to say that he informed your office or provided that information to your office in or about February of 2022?
That information, part of that
she's talking about
information was
intake.
provided to our office at the time of the autopsy. One of the
during the
pieces of information that had come in, and there were multiple sources calling into our office, providing information, was that this was a possible person struck by a motor vehicle.
And the time of the autopsy, if I have it correctly, was that around the end of January of 2022?
The autopsy was January 31st.
We're going to get into communications after that, I think.
Your Honor,
We'll
if
see.
I could, with your permission, please publish a photograph which Your Honor has and the parties have stipulated, or that's in evidence. And this is the one.
Chat, remember, we have about 20% plus of people who did not see the first trial, and we will see how this information comes in, and then we will talk about it after this witness.
So we'll mark this as the next.
Hang on.
No objection.
We'll get
We'll
there.
mark it first and then you can display it.
Thank you, Your Honor.
But they are talking about the initial intake and what they learned from law enforcement.
Thank you. May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, if I could hand that to you, please.
At least no one has called her
Take a
Scordi-Belly
look
this
at it
trial,
when you've
because
had
that
a fair
was
opportunity to look
that
at
was
it.
a
You just
moment.
Look back up and I'll proceed at that time.
Yes, I recognize the picture. Well, I've never seen this picture before, but I know what it's depicting.
Thank you.
was a
What
very
is
thorough
depicted
answer.
in that picture?
It's a picture of two individuals standing in a morgue setting, which looks very similar to our morgue at the Cape Cod office.
Very good. If you could just
Two
hold that
people.
for a moment, and with the court's permission, could I publish that for the jury?
Okay.
Two people.
Thank you. Mr. Wolf?
I was hoping they would get to this.
And if you could please zoom in on the two individuals in that picture. Dr. Scordi-Bello.
Oh boy. Oh boy. Oh boy. Oh boy. Oh boy. Chat. Chat. For those of you that have seen the trial before, I'm going to restate everything. Yesterday I said that Alessi's cross-examination set like a long fuse and didn't necessarily have boom goes the dynamite moments. But this man brought some long fuses yesterday. Today, where's my fucking record scratch? God damn it, Emily. This might be building into a boom goes the dynamite moment. I need to know when this picture is from. But we had a witness testify, the dude with the blue gloves on in the foreground, holding like a folder. He testified that he attended the autopsy alone. And I ranted about how frustrating I found it. You might remember the rant. That the lead investigator, case agent of the presumed homicide of a police officer would not attend the autopsy. Because what the fuck? But for all of you that are new to the trial, that sure the fuck looks like Proctor standing there in the medical examiner's office. Now, we don't know what day this is from, but I imagine that Proctor and Keefe are not heading down the Cape to that ME's office more than once. There's no reason to. Once they do the physical autopsy, everything else is reports and waiting for labs and stuff to come in. So, unless this is not the autopsy, which would be surprising to me. I mean, they're not in full, like, the paper suits. And often you would be in the autopsy in the paper suits. So, I've got questions. But this is setting up as if it might be a big issue. Chad, I'm not going code red yet because I don't know exactly when this photo is from. But if this is from during the autopsy, that's different. If this is from another time, that's different. So we're gonna wait and see. But oh buddy, this sure looks like Proctor and Keefe at the coroner's office. Keefe said he was there alone. I'm not going code red yet until we have an explanation, because we don't know yet. But it is setting up to go somewhere very interesting. So I'm gonna back that question up.
In a morgue setting, which
He's asking, do you recognize this photo? She said a morgue setting. Oh. But if it's the morgue, it might not be during the autopsy. That's fair. That's why I'm backing it up. If it's the morgue, it might not be during the autopsy, but we'll see.
May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, if I could hand that to you, please. You could take a look at it, and when you've had a fair opportunity to look at it, if you could just look back up, and I'll proceed at that time.
So we'll see if there's
yes,
a
I
reasonable
recognize the
explanation or
picture.
not.
Well, I've never seen this picture before, but I know what it's depicting.
Thank you. What is depicted in that picture?
It's a picture of two individuals standing in a morgue setting, which looks very similar to our morgue at the Cape Cod office.
Very good. If you could just hold that for a moment, and with the court's permission, could I publish that for the jury?
Okay.
Thank you. Mr. Wolf? And if you could please
Very,
zoom in
very
on the two individuals
interesting.
in that picture. Dr. Scordi-Bello, do you recognize any of the individuals in that picture?
I do.
To be perfectly honest, no, I don't.
With regard to
completely
the
fair.
person on the right, do you recognize that person?
No, I don't.
The jury doesn't know what Proctor looks like, by the way. Not from this trial.
And you said you recognize the setting, correct?
Yes.
And you, if I heard you correctly, you said this is the Cape Cod facility?
It
She
appears
said
to be.
morgue.
Correct.
Right. So you testified earlier, if I recall correctly, that the autopsy was performed at the Cape Cod facility of the Office of the Chief Medical Examiner.
Yes, it was.
And you're normally in, as I recall, the Westfield, in an office that covers Western Massachusetts and it's Westfield.
Correct.
But you were at the Cape Cod facility, as I understand it, because there was a staff shortage and you had to travel down to Cape Cod for this. Is this correct?
Correct.
So you weren't at your normal home base sort of facility. This is a facility that you went to for this autopsy, correct?
For this autopsy and multiple others, yes.
Yes. And you were covering a staff shortage, and that was the reason you went to Cape Cod, correct?
Correct.
For those of you saying it says Proctor and Keefe at the top, this is from the defense's computer and they have it labeled. It does say that at the top. It doesn't mean she remembers. I don't know how many autopsies she might have performed, but everybody that would come in would also be in protective gear. So I'm not surprised that she doesn't recognize who's in that photo.
And what's depicted
And
in
she's
this
not gonna
picture
guess under oath.
are two individuals. For two individuals to be present, is there a protocol that they had to follow to be present for that? Like a sign-in or an authorization?
Yes, there is a sign-in sheet that individuals have to put their name and their shield number and before they can come into the autopsy room.
So they have to put a shield number down, correct?
Their badge
Mention
number.
a shield number.
Yes.
And does that
She's like,
therefore
yes.
mean that
She's like, why is that confusing? Yes, obviously they have to document it. Oh, ma'am, I appreciate you being like, yeah, that's a normal procedure, ma'am, this case.
you don't know who they are, that they are with law enforcement? Are you able to determine that?
Correct. I believe they were with law enforcement.
So those two individuals were with law enforcement, but you don't know who they are.
I don't know who they are specifically and what their actual position was.
But they were with law enforcement.
I believe, if my memory serves me right, there was a person from crime scene investigation and someone from state police.
Thank
But
you.
I'm working on a 2+ year memory.
Fair. That's fair.
And
I'm not going to ask you more questions to probe the memory. We can take that
She's
down.
like, I'm not going to ask you more
And,
questions to
yeah,
probe
we
your
are
memory.
finished
She's like,
with that.
thank
If you could
God.
hand that to the. Thank you. Now, we were speaking about former Trooper Proctor. Do you recall former Trooper Proctor sending you a copy of scene photographs and wanting to schedule a phone call with you so that he could explain the status of his investigation? You recall that?
Oh, boy.
Yes.
And that occurred approximately in March of 2022?
Yes, approximately.
Right. And the method of communication.
For all of you asking, we did not see that photo before. And remember, for those of you new to this trial, we did not see that photo before. And there was a discovery dump or a turnover of information between trials from the federal investigation as well. So could that photo have come from there? Yes, it could have. Do I know that for certain? No, I don't. I do not know that for certain. Could that be a reason that we did not see it in the first trial? Yes, it could be. So this cross got real interesting to me. Real interesting. Real
Communication of
interesting.
that was that by email, to the best of your recollection?
I requested that our medical legal investigator, we have our own investigators at the office that are responsible for obtaining medical records and sometimes being the liaison between us and law enforcement to get reports. I requested that she contact whoever was in charge of the investigation,
Case agent.
and set up a meeting, a phone call. So since it had already been a few weeks since the autopsy, I wanted to make sure that if there was any additional information that could be provided to me, I could take it into account, because I had 90 days to issue a report and a death certificate on this case.
Now, you've mentioned the 90 days on direct. You just mentioned it now. Is the 90 days a hard and fast rule, or is it just something you aspire to as a matter of good practices?
It's not a hard and fast rule. It's something that as an office we try to achieve. Again, the reason being that there are family members, next of kin that are waiting for these reports and these death certificates for various reasons. So is it possible to go over the 90 days? Absolutely, if necessary. But we do try to finish our part in those 90 days.
So it's
Right.
possible to go
They wanna
past the
take care of
90
it.
days, but there would, given the considerations you just articulated, there'd have to be a pretty good reason why you'd want to do that, right?
Correct.
And in this situation, you concluded that you had sufficient information on the medical side and the legal side to come to the conclusions that you needed to come to. Is that fair?
Well, I
Alessi,
had
microphone,
sufficient
microphone.
information on the medical side because I did the autopsy and I had those findings. I did not have sufficient information that pointed to one manner of death over another manner of death. And therefore, I stated that the manner of death was undetermined.
Exactly. So the manner of death is undetermined, and I want to, if I could, with you pursue that a little bit.
JB, I'm
in a
not
moment.
okay. Every time Alessi
But-
walks away from the mic, I'm not okay.
When you came toward the end of that 90-day period, you had information from the law enforcement side on their theory of what had happened, correct?
Correct.
I'll let that one stand.
It's allowed to be.
You had performed all.
I think the objection was probably argumentative because of the word theory, but the word theory has been well established by Sergeant Buchanan. I don't think it's argumentative to call it a law enforcement theory. It's a law enforcement theory until it's proven to a jury, in my opinion. I don't think it's argumentative. And the judge, well, I'll let this one stand. So I guess denied then?
Of the medical
Denied?
investigation and analysis that you needed to perform, is that correct?
Yes.
There wasn't something more that you wanted to do on the medical side. You had mentioned, to be fair, you had Dr. Stonebridge involved as well. You had what you needed on that side, correct?
Yes.
And you therefore concluded on the manner of death that there was a not more compelling or more likely than other reasonable possibilities. Is that fair?
Yes.
So in furtherance of that, on April 14th of 2022, you issued a death certificate, correct?
Yes.
And please feel free to check your report of any dates or any other particular as I go through.
Okay.
He's like, ma'am, we all just want the information as best you remember it or as best it's in your report. You write reports. Why?
I issued my final report
memories.
on April 14th, correct. And I would assume that the death certificate was on or around that same day.
Thank you. Now, to back up a little bit with regard to the autopsy, as you stated, it was conducted, I just want to do a little bit of a timeline, on January
I like the
31st
coroner.
of 2022.
I liked her last time
correct?
she testified. I like her
Yes.
this time.
And we discussed that the body of Mr. O'Keefe was presented to the Cape Cod
Because it's
location, correct?
clear
Yes.
and direct.
And you also discussed that you brought Dr. Stonebridge to work with you on this matter, correct?
She didn't physically come to the office. the way Dr. Stonebridge was involved is at the time of autopsy, when the brain was removed, having seen that there were injuries, I saved the brain in a special solution, and then the brain was transported to our facility in Boston.
Yeah, they sent the brain to
Dr.
Boston.
Stonebridge examines the specimens. And after examining the brain, she issued a report.
And I think we're going to
asked
see
Dr.
Stonebridge probably the next
become
witness.
involved in the matter.
I did.
And Dr. Stonebridge
She saw
is
injury to the brain.
triple.
She saw injury to the brain and then sent, well, put it in the hardening solution. I'll leave out the details. Send it to Stonebridge. I think we'll see Stonebridge testify next because Stonebridge goes through specifically and just looks at the brain and injuries of the brain.
Board certified, correct?
Correct.
She's a forensic
Triple board
pathologist,
certified,
correct?
Stonebridge.
Yes.
That means she's achieved board certification in forensic pathology like you?
Do you know that?
I do.
She's like, I stand my
Yes,
friend, of course. She's a
board certified in
badass.
forensic pathology.
And she is
Go, Dr.
board
Stonebridge.
certified in general pathology, correct?
Yes.
And she's board certified in neuropathology, correct?
Correct.
Can you briefly describe to the jury what neuropathology is?
Can you tell us what a badass Dr. Stonebridge is? Thanks. Go ahead and geek on your friend. Go for it. I'm just assuming that they're friends because of her smile, but I'm making that up. She's like, get it, Dr. Stonebridge.
Neuropathology is a subset or specific additional training in forensic pathology where the person spends a considerable amount of time, usually 1 to 2 years, examining brains and learning all about the diseases of the brain as well as trauma to the brain.
Now, you asked her to be involved, as you indicated earlier, correct?
Yes.
And you determined that she should be involved because there was a brain injury, correct?
There was trauma to the brain, correct?
To the brain. Is it a fair characterization that Dr. Stonebridge is sort of the brains of the brain area of autopsy? Is that fair?
I'm going to sustain the objection.
So,
Oh, Hank, come on. Brennan, my guy, your 3-piece suit might be too tight today, Brennan, because come on. Is it argumentative? No, it's not argumentative. Brennan, just stop it. What? The defense is going to establish Stonebridge as the expertiest expert, and I wonder if Stonebridge and one of the other Commonwealth experts disagree, because the defense is definitely using their time on cross to establish Stonebridge as a badass. So I have to wonder if there's a disagreement incoming with the witnesses. But I back that up because I just wanted to hear it again because it was funny, and I wanted to see Dr. Scordi-Bello be delighted by that
Brains.
question because it's a nice moment.
And learning all about the diseases of the brain as well as trauma to the brain.
now,
I think it backed
you
up a little
asked
too
her
far,
to be
but that's okay.
involved, as you indicated earlier, correct?
Yes.
And you determined that she should be involved because there was a brain injury, correct?
There was trauma to the brain, correct?
To the brain. Is it a fair
He's
characterization
pausing.
that Dr. Stonebridge is sort of the brains of the brain area of autopsy? Is that fair?
I'm going to sustain the objection. Let's move on.
Good. So, with regard to
She's delighted.
Dr. Stonebridge,
I'm delighted.
would you agree that she's really uniquely qualified in some ways? Or how would you describe her qualifications, Dr. Stonebridge?
Sustained.
With regard to
We're getting
Dr.
into-
Stonebridge, what did she do?
this doctor's opinion of what Dr. Stonebridge's qualifications are is, well, not relevant, among other things, but why did you send this out and how did you send it out and why did you work with another pathologist is fair. I also wonder if the defense suspects, and this is my speculation, I wonder if the defense suspects that the prosecution might not call Dr. Stonebridge. I would imagine she's the next logical witness. But if the defense has an inkling that they might not call Dr. Stonebridge, then they can build that elephant in the room of, well, why didn't we hear from Dr. Stonebridge? Could the defense call them down the road if they wanted to? Yes. But building that in and cross, because at this point I'm sitting here going, right, Dr. Stonebridge should be the next witness. But I don't remember if the prosecution asked much about that on direct. And so maybe they are building the jury wondering, well, where's Dr. Stonebridge? So.
I'm going to see you at sidebar on this, please.
Oh, and a sidebar. Well, at least I've given myself zoom room as we go to sidebar to talk about the brains of the brain. And Dr. Brains, this is a decently long sidebar. Oh, not too bad. All right. There we go. And Alessi's like 15th binder. I'm sure he has them all numbered. I'm just joking. I don't know if it's actually his 15th binder. But now if they don't call Dr. Stonebridge next, I'm going to be annoyed.
May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, have you, are you aware of an attorney name, or excuse me, a doctor named Azik Wolf?
No, I'm not.
Now I'd like to move on to another category. Based on the information that was presented to you as part of your examination and analysis, is it correct that you presume that because Mr. O'Keefe's body was found in the snow and his body temperature was 80 degrees, that he died from hypothermia as one of the causes?
Contributing factor.
I reached that conclusion after performing the autopsy and after seeing some findings that were consistent with hypothermia, and then combined with the information that was provided to me about Mr. O'Keefe's body being found in the snow, I came to the conclusion that was one of the things that contributed.
Did you consider whether there may have been other reasons as to why his body reached that temperature of 80 degrees?
I'm very
sort of
interested
applying the scientific method
in these questions
and seeing if there were other reasons.
Other than being out in the snow, no, I do not.
Do you know whether there are other alternative reasons how his body could reach the temperature of 80 degrees?
People can become hypothermic for other reasons, such as sepsis. But in this particular case,
Well, that would be
I didn't
very
have
obvious
any
if there was
reason
sepsis.
to believe that that was part of the circumstances.
Well, wouldn't.
You're familiar with the
Other
medical
level.
phrase differential diagnosis, correct?
Yes.
And a differential diagnosis is a term that's used by doctors to pursue other potential causes of a medical injury. Is that a fair general statement?
Yes.
So, for example, if somebody is having difficulty breathing, a doctor may say, I think it's the heart is their primary hypothesis, but they may want to differentially diagnose this and look at the lungs. Is that an example of a differential diagnosis that let's look at the lungs to see if that may be the problem. Is that a good, fair example?
In the example you're giving, yes.
So applying that concept, and do you believe the concept of, well, applying that concept to this situation, did you perform a differential diagnosis as to the cause of the death and question whether there was hypothermia as any cause of the death of the decedent? Did you make that analysis?
I looked at the anatomic findings that I had at the time of autopsy, the information that was provided to me based on the circumstances and where the body was found. And I came to the conclusion that there were hypothermic changes in Mr. Keefe's body.
So you just used the phrase hypothermic changes. Did I hear that correctly?
Hypothermic
Yes.
changes.
Can there be hypothermic changes without a cause of death?
to the mic.
Hypothermia.
Yes, of course.
So you can have signs in the body,
Yes, and then get warm.
hypothermia, but you can also conclude that a cause of death is not from hypothermia, correct?
If the person is deceased and I am examining the body and there are multiple
She's like, if they're not dead,
things
they're not
that
my
I believe
problem.
contribute to the death, then I tend to include all of them. Meaning that if this was a drug intoxication and the body also showed signs of hypothermia, I would include both of them on the death certificate, because there is no scientific way of teasing out whether it was just one or the other or both. In this particular case, I had two processes that were going on. One was the head trauma, and the other one were these hypothermic changes. I put all that together, and again, included or took into account the
Where he was found,
investigative
right.
information of where the body was found, what the temperature was when the body was found, whether the person was still alive or not. And I came to the conclusion that the cause of death was blunt impact injuries of head. And I included the hypothermia because I saw during the autopsy that there were changes consistent with hypothermia.
So I want
I'm going to pause her real quick before Alessi breaks this down and just point out, when I was complaining about some of Sergeant Buchanan's testimony, he kept saying that he didn't follow the leads with Higgins because of all of the investigative findings. But he just said the totality of the evidence or the investigative findings, the way that she just laid it out, I considered this and 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 this. And that is how I came to this conclusion, is what I would expect to see from an investigating officer supervisor, someone who worked closely with the case. And instead, what we got from Buchanan was, well, all of the totality of the circumstances and all of the investigative findings. He did not go, it was this thing and then this thing and this thing and this thing. She very clearly remembers, and probably reviewed her reports before court, as you should, all of the things that she made a consideration. It's what you hope to see. So if this testimony is landing different with you, it's because this witness is not combative. She's explaining her decisions, but she's not fighting to justify them. This witness isn't reading into the defense questions some kind of negative or nefarious inference. She's answering the questions she's asked. And he says, could it be this? And she's like, well, it's this and this and this and this and this. So there's no defensiveness. It is what it is. And she's going to explain it because she's not defending anything. She's explaining to the jury. And it is a very different type of testimony that from professional witnesses is what you would expect to see when they are just explaining what they did, how they did it, why they did it. And that's not what we've seen from some of the other witnesses in this case. So my assessment as to civilian witnesses is different, but as to professional witnesses, and that includes law enforcement experts, scientists, this is what you would hope to see. She is a great witness in the way she testifies. Not all coroners are as easy to understand as she is.
If I could with you. So you testified on direct, and I think you alluded to it here, that the primary cause of death, use that phraseology on direct, was blunt force injury. Is that correct?
Blunt impact injuries to the head, yes.
Blunt impact injuries to the head. And that's the primary cause, right?
Correct.
And then there's, and I'm not clear on what you refer to on direct as a secondary cause of death of hypothermia, but you've used a little different phrase in some of your answers.
She said hypothermic changes.
Right. Hypothermic considerations. Can you repeat?
No, she
what
said
it was?
hypothermic
They
changes.
said hypothermic changes.
Hypothermic changes, and we agree that you can have hypothermic changes without a conclusion of hypothermia, correct?
No, hypothermic changes are what I'm referring to are actual things that I can see in the organs that are consistent with hypothermia. They're anatomic findings. They're things I can see with my eyes.
So you can, I'm sorry, did you finish?
And those changes suggest and are consistent with someone being hypothermic.
As you sit here now, with regard to, you used the phraseology consistent with hypothermia, signs of hypothermia, that's what I want to pursue just a little bit with regard to further
I'm interested to see
information.
where his experts will go with this, because I find this witness very easy to understand and very
we
credible.
got started on this by asking whether you used the concept of differential diagnosis and hypotheses to determine the cause and manner of death. And you said in one of your answers that you relied upon law enforcement information, correct? Is that
Yes.
part of it? It was, you brought that up. You're the one who said you relied upon that, correct?
Yes.
And you've brought that up on your direct testimony and earlier in the cross. Is that correct, that you relied upon the investigation of law enforcement? So,
Sustained.
so now what I'd like to do is
really
to
compound.
ask you whether, using the concepts of differential
haven't also
diagnosis
gotten to the
scientific
question yet.
method, did you consider whether Mr. O'Keefe could have died somewhere other than where the body was found and been moved and placed in the snow? Did you consider that?
Sustained.
May we approach, Your Honor?
Move along with this. We can approach in a bit.
Thank you. What, if any,
I hate the approach later, bring it
alternative
back. It breaks up the flow.
diagnoses did you apply to Mr. O'Keefe?
I don't understand your question.
But they're going to come back around to it,
What alternative scenarios
or they should.
did you look at, if any, for the cause or manner of death of Mr. O'Keefe?
That's asked and
I'll allow
answered.
that question. What, if any?
That's asked and answered, but the
At
court
the
gave
time
us
of
a
the
what if any.
autopsy,
The court said yes, what if it. I'll allow that what if any. Your Honor, not with the what if any.
I'll allow that question. What, if any?
At the time of the autopsy, I documented injuries and signs of hypothermia. I was provided with a set of circumstances, and at the end of the investigation, or at the end of my timeline, I concluded on the cause, but I did not conclude, or I did not determine a manner. The manner would be the circumstances you are speaking about, whether I considered other causes or circumstances. That's not how it works. I don't come up with hypothetical scenarios on how those injuries occur. I try to state the injuries, describe the injuries, state the cause of death and why that person died. And then I use all kinds of other investigative information that is provided to me to determine if I have enough to make a determination on the manner.
Did anyone provide to you any...
That was the feed, eat. It's been a few days since that's happened. Let's bring this back up. That was me. We know how Tech and I have been working together over the last 24 hours. Apologies. It's fair that she said, I'm not trying to fit this into a box. I am looking at what the autopsy shows, what the injuries show, what all the information shows. And then I am determining if there is an explanation for that or not. And if there's not, then it's undetermined. I think it's a good argument for the defense to keep saying, so you did not have enough information to decide how this happened. I think for the defense, that is a good argument. The coroner couldn't decide what happened, what caused John O'Keefe's injuries. Because for them, they are looking for that reasonable doubt. It is harder for the Commonwealth because they have to prove beyond a reasonable doubt what happened to John O'Keefe. And they couldn't prove that to the coroner. I mean, they've done a lot since Proctor gave the coroner information, but it's a good argument.
Alternatives as to the finding of the body of Mr. O'Keefe in the snow?
Personally, to me, no.
And I'm going to back up that question since everything got yeeted, and I don't want to step on Alessi's question.
Enough to make a determination on the manner.
Did anyone provide to you any alternatives as to the finding of the body of Mr. O'Keefe in the snow?
Personally, to me, no.
Did you ask for any alternatives?
I hear you guys that there's an echo. Hold on. Let me redo this real quick. Sorry, y'all. I've stepped on Alessi's questions twice now. Let's see if we can fix that. Apologies. There we go. That should fix it.
Alternatives to the...
Did anyone provide you any alternatives to Mr. O'Keefe being found in the snow?
Any alternatives to the nature and location of the injury or death of Mr. O'Keefe?
I asked for all the information that was available.
Understood, but my question is, did you ask for any alternatives to the
No, why would she ask for
information
that?
that
She
was
asked
provided
for all
to
the
you
info
as
available.
regards the location of the
Yeah,
injuries?
she's not going to ask it like that.
Did anyone provide you any alternatives to where the injuries could have occurred?
No.
She's not going to ask that question.
So,
I'm going to let the answer stand. So the answer is no,
It's
so
asked
there's
and
no
answered.
evidence of that. So next question.
so you talked about the information you had at the time. What time is that?
The information at the time was a preliminary police report and verbal communications regarding the circumstances of how Mr. O'Keefe's body was found.
And when I asked about the time, I'm not calendar time. Was this January, February, March, April of 2022?
The preliminary
That would have been
police
the end of
report
January.
was on the day of the autopsy, and then information, I don't remember exactly, how long, but in the weeks following, information was, coming in.
Do you have the ability to amend a death certificate?
Yes, I do.
And you can amend a certificate.
That's a good question.
You obtain further information with regard to the circumstances surrounding the death.
Question. Because he's going to walk the jury through, itty bitty step by step. Ooh, baby. No, Emily, no. He's going to walk the jury through. So up until this day, this is what I'm suspecting will happen. So up until this day, if you had more information, you could have amended the death certificate. If you saw something that changed it from undetermined, you could have updated the death certificate. I wonder if they're going to ask her about other autopsies, how many she's performed, if she's seen other motor vehicle collisions, or if they're going to leave it for their expert now that they have an expert. Last trial they didn't, but we'll see. But I think that's where he's going with that, is you could have, if more information came in, you make the best decision you can at the time with the information you have, and you did that. But if new information comes in and there is a new decision, you would update it, and you didn't.
That's correct.
In your previous answers, you were talking about the information you had at the time. And I'm concluding that the latest that would be is April of 2022. Is that correct?
Correct.
Have you obtained or been provided with further information? In other words, information after April of 2022 regarding the cause or manner of death?
What do you mean, have I been provided?
Did the investigation kept
Has
going? Did you keep
someone
getting info?
Physically
New police reports?
provided me with a
Accident reconstruction?
report on
Yeah.
different circumstances?
Yeah.
Well, what I'm just talking
That's what
about
I mean.
is any other information that you have received or considered in terms of the analysis with regard to the cause or manner of death.
Received in what way?
Here's what I'll do. I'll be a little more specific. What I want to do is to get at the head injury of the decedent. Okay. Is it fair
It's
to say
crossed.
that
Just ask her. It's crossed. Just ask. Did you receive a report from an accident reconstructionist? Did you receive a report from a biomechanical engineer? Did you receive a report from this person? Did you receive police reports from anyone else? We've heard there's over 100 reports in this case. Did you receive 100 police reports or just the one? You can leave. Just ask. Just step by step.
head injury? You called it a traumatic. State what you phrased that as, because I want to use your phraseology.
Blunt impact injuries of the head.
So blunt impact injuries of the head. Is it fair to say that that was a very severe injury?
It was a severe injury, correct?
And would Mr. O'Keefe had been rendered unconscious nearly instantaneously with death following shortly thereafter?
It's very possible, yes.
Is it more than possible? Is it probable that that's what would have occurred?
I can't tell you how quickly he would have been rendered unconscious, but at some point after that injury, yes, he would have been rendered unconscious.
Is it possible he could have been rendered unconscious immediately?
It's asked and answered, but
She's answered it this way. I think you need another person for that. Let's move on from that, Mr. Alessi.
there are multiple experts that are going to testify about those things. She answered that she
You
can't
made
answer, so it's
your own determination of the cause
asked and
of
answered.
death, correct?
Yes, that's my job.
Understood. And what I want to do is to pursue the basis of your determination. So you used the phrase brain impact injury.
Blunt impact.
A blunt impact injury
Brittany, if she
Got
said
that
immediately
correct?
last trial, they can ask her about
Non-impact
that.
injuries of head, yes.
Of head, right. And that's
she said
your
possible
conclusion,
today?
correct?
Yes.
Based upon your conclusion, did you make any determination as to whether the decedent would be able to carry out any purposeful movement after that injury?
And he's getting there.
Define purposeful movement.
Sure. I'm talking about the ability to perhaps manipulate their hands.
I don't know.
Did you make any determination as to whether they would be able to engage in any cognitive functions, meaning processing things and making decisions?
I did not make that determination.
They're bringing in, aren't they bringing in the neuropathologist? The neuropathologist is
Did
the
you
perfect person to
observe
ask these
any
questions to.
pattern to the injuries to the head of the decedent?
A pattern? I observed that there were injuries to the back of the head as well as other internal injuries to the base of the skull, as well as the brain.
Your Honor, if we could please publish, I'm just going to check to make sure they're in. If we could, Your Honor, publish 160 that is in evidence. But before we do, Mr. Wolf, I would like to approach Your Honor and let you know in case there's anything further
Okay.
that needs to be done. Thank you.
Okay. So it looks like they're approaching.
Did you show it to Mr. Brennan?
It's already been agreed to as in evidence. and it
Okay.
is in evidence.
Oh, it's in evidence?
Yeah, I just wanted to make sure if there was any statements, Your Honor.
What?
So why don't you come over here because, why don't you come over here?
Okay. So they're going to sidebar just to double check. I appreciate the double checkiness. We're going to zoom past sidebar. And when we get caught up, we're going to get caught up to real time, I imagine, shortly. Some of these exhibits that they put up on the screen, I don't know if we will see.
Yes.
I imagine
Thank
not.
you.
I think he said, may I continue? We will continue.
Dr. Scordi-Bello, if you could please draw your attention to what is depicted on both screens. Pick whatever screen is most convenient for you.
Yes,
And
my
what I want to
vocabulary is
do
not
is
Alessi
to
for
go
sure.
over
It's decent,
what
but
is
it's not
depicted there, and
Alessi.
I'd like to start with
I'm much less formal.
just some basics. What is that white rectangle that is on the photograph?
This?
Yes.
That's a ruler.
Oh,
And
a
what's the
ruler.
purpose of the ruler?
To show a scale, when I measure the injury, I use the ruler to document that.
And if you could please draw your further attention to what I will refer to, and you use your own term, but just to start it, the horizontal line that is appears to be a laceration. You know what I'm referring to?
This, yes, this is a laceration.
Right. So it's fair to say that that's a laceration.
Correct.
And just so we get all that's depicted on this, you referred to earlier up above that the red
imagine they're
area.
using,
Is that an abrasion?
Yes.
And
I imagine they're
do you
using
also
John O'Keefe's
denote
arm in photos
to
of
the
John O'Keefe's
left,
arm.
almost like a J-type item going vertically up? Yes, and going up. Do you see that?
Yeah, that I did not note that specifically. I just noted the whole injury as part of the abrasion.
That's my point. So you
It's
didn't
like,
make a separate
the
note
question.
of what appears to be a J, and it might be easier to see it in the screen over there. It's your conclusion, but is it more? Is it easier to see there?
Which screen can you see?
Yeah, I can see it.
Yeah, and so you didn't make a separate note as to what that was in your report, correct?
No, I did not.
Right. Okay.
Do you consider that an abrasion or something else?
I believe that's still an abrasion.
do you conclude that J is different in any manner from the abrasion that you've noted above the laceration?
I'm trying to track his questions, which is almost impossible
I
without
believe
looking
it
at what they're talking
could
about
be
for me.
part of the
It is my assumption they're looking at the same arm
whole
photo.
abrasion, or it could be something.
The jury has a photo up in court. We don't know if it is the same photo that we have seen, because if it is, they would generally show it, but it could be a different photo that they are not going to show, and that's fine.
Something different.
It just makes it a little harder to follow.
Fair enough. Would a fall backwards on a flat frozen ground produce a circular and not a linear abrasion as depicted
That's a good
here
question.
on the back of an injured person's head?
Can you repeat the question?
Sure. Assume a fall backwards
Would it be a
on a
circular
flat
break?
frozen ground. Would such a fall in impact
linear.
present that type of pattern, or would it
Oh, that might be the photo that's up.
present a circular pattern, perhaps with something like a starfish in the middle?
Oh, Lord.
I'll allow that. Can you answer that?
I can say that a fall backwards could very well produce that injury.
My question is more specific, and that is
Yeah, he's not asking if it
a
can.
fall backwards where the person
He's going the other
impacts
way.
the back of their head on flat, frozen ground. Would you expect that type of a laceration from that type of a fall? Not just a general fall backwards, but specifically a fall backwards where the back of the head hits flat, frozen ground. Would you expect that?
I could, yes.
And under what circumstances could a laceration like that?
He is asking- He's asking about and I wonder if the photo that they had up was the back of John O'Keefe's head as they're talking about this. He's asking about the different ways the skin could split due to a blunt force injury like that, if it would be just one linear or if it would be more. It's difficult to follow without the photo, but that's a photo that's not going to be shown.
All of it together, what circumstances could cause that type from a fall backwards on flat, frozen ground?
Well, the laceration is due to the blunt impact, and so is the abrasion. The abrasion is friction. So depending on the type of surface, you mentioned flat, frozen ground, it's quite possible to have an injury as the one depicted. There's nothing inconsistent with this injury and a fall on someone's, on the back of the head with a blunt surface.
Is there, are you familiar with the phrase pattern recognition in
Oh, boy.
medicine?
Yes,
And isn't pattern recognition something that requires training with regard to being able to recognize certain patterns and determining what could be causing that pattern?
yes,
And just merely recognizing whether there is a pattern takes certain specialty training, etc.
correct.
And isn't pattern recognition a principle that you apply in the medical examiner's office?
Yeah, we do.
And so example
I mean, isn't
of
most medical pattern
recognition could be a knife wound, correct?
Yes,
Could be a gunshot.
correct.
And there's certain patterns that you see on a decedent that can be consistent with those types of causes of injury, correct?
This is laying foundation for their later experts, and that this is something that doctors do, and then they don't just hear it from the defense expert, they hear it from the Commonwealth's expert as well, that doctors are looking at patterns and saying,
Assuming
doctors
a
do.
fall
I mean,
backwards
this-
onto
This group of symptoms matches this pattern. This type of fracture matches that pattern. So he's laying some of the groundwork for that later testimony.
frozen ground, and there being on a lawn with grass, would you expect to see any grass at all in the injury site?
That's a good question.
It's possible to have grass.
Is it possible to have well, are you familiar with the height and weight of
Then
the
again-
decedent generally? And if you need
It's a really good question. The fact pattern in this case with Jen and Carrie and Karen arriving on scene and trying to like wrap his head with a blanket that law enforcement never then recovered, them being moved into the ambulance, then at the hospital, onto the small backboard, onto the bigger backboard. There's a lot of other things happening with John O'Keefe, so it's not the weirdest thing to me if there wasn't, but she did talk about one of the wounds being abraded. I wonder if they'll get into that.
need to look at your notes, please do so.
Yes. Mr. O'Keefe was approximately 6'1" and 216 pounds.
So, assuming a fall backwards and an impact to head on, a ground with grass, a person who's 6'1", there is going to be significant acceleration forces that occur as they're going backwards. Is that correct?
An engineer.
That's fair to say, yes.
And therefore, the more acceleration forces, usually there's a correlation with the force of the impact.
Correct.
And in terms of force of impact and assuming grass on the ground, would you believe it's more probable than not that one would then see some grass on the head?
Sustained is doubtful.
Given what you testified regarding the height of Mr. O'Keefe,
Okay.
and assuming what I just gave to
A
you
lot of
as
factors to this.
a fall backwards and acceleration and forces, would you expect to see anything else on the back of his head?
You have to be more specific than that.
Right.
A lot happened.
Thank you. So
A lot
would
happened.
you expect to see?
Like a lot happened.
Is it possible, if that was the manner of the fall, that there should be grass on the head? Is that possible?
She's not saying that.
Sustained.
I think now's a good time
Did
for them to
you
approach and
consider
just sort out those
at all
issues.
in your evaluation
Time.
Well, let me back up. Do you see any evidence of grass in this depiction?
No, I do not.
Did you recall ever seeing any evidence of grass when you were performing the autopsy?
I did not see evidence of grass.
Which injury was abraded, though?
Did you consider at all in performing your autopsy whether or not grass should be present given what was reported to you by law enforcement?
Sustained.
Did you make any considerations at all regarding grass in regard to your autopsy
This is
report?
probably better for their expert than her.
I
She
did not
Right. She
see
said
any
that.
grass. No, I did not make any determinations.
And was grass at all even a consideration in your analysis?
I had very limited information as to the exact nature of the surface at the time of autopsy.
So the answer is no to that
No.
question. Thank
Okay.
you. Did you have any information regarding the circumstances that you said you look at in trying to determine manner of death as to whether there were any stones or rocks around the scene?
That I did not have any information.
So
Or a fire
meaning you didn't have
hydrant.
any information, you saw no information that there were any stones or rocks by the scene, is that correct?
That's asked and answered. but-
Sustained in that form.
What, if any, consideration did you make in your
None. She had
assessment
no
of cause
information.
and manner of death with regard to stones or rocks?
I did not make any
With regard to any other potential causes other than ground, did you consider any other possibilities that could cause the type of injuries that are depicted on the screen?
There's a number of possibilities that could cause the injury.
Right.
My question is, did you consider, not whether there are, but whether you considered them at the time you were performing the autopsy?
I'm always considering
Yeah.
at the
That's why it's
time of autopsy
undetermined.
what could have caused a certain injury.
That's
Did
why
you
it's
put in your
undetermined.
notes or your autopsy report any of those considerations? Are they documented?
Yes, she said it was undetermined. It's
Now,
not-
in terms of differential
there are multiple possibilities. Ergo, one possibility was not chosen. Ergo, it's undetermined. Is she going to note them? No. It could be this, it could be this, it could be this, it could be this. Therefore, undetermined.
diagnosis that we talked about, did you determine whether there were any other possible explanations for the injuries to the decedent other than what law enforcement presented to you?
I'll allow that.
Internally, I consider all kinds of other explanations. I have to look at the findings and the possible ways that those injuries could have been sustained and decide whether I have enough information and whether I am satisfied with the information that I have in order to conclude or determine a manner.
Did you make any notes at all about the considerations you
I
were
don't
just
think she
speaking
would make
about?
notes on
Other
that.
consideration? Any notes whatsoever in any document in your autopsy report?
Not in my autopsy report, no.
It's not.
Did you make any other notes of those considerations in any document that you created for this case
That's
at
how
all?
that works.
No, these are considerations that I've had and discussions I've had with colleagues in terms of evaluating these injuries and.
And I don't want you to go into what other people said, but I want you to finish your answer.
She thought about it.
Right, no, I did not make physical notes of
Nor would you.
my considerations.
Your Honor, I'm going into
Of all-
a
of
different
all of the
category,
witnesses,
so I just wanted to alert Your Honor
that-
to it.
Right.
Makes sense.
It will take more than 10, 15 minutes?
Oh, yes.
Oh, boy. We're going into a new area. Will that take more than 10, 15 minutes? Oh, yes. Well, that's going to be lunch. I'll see if they go back on the record. I think they'll probably give a sidebar, though. This is going to be a long cross-examination, it seems, or at least another 30 plus minutes. It doesn't look like they go back on the record, and they are just at lunch. So with that, we have gotten to lunch. It is day 16 of the retrial of Karen Read. The court is at the lunch break, and they finished up with the first witness this morning, who was the last witness of the day on day 15, with a remainder of the cross-examination, a redirect, and a brief recross. And then the Commonwealth called the coroner, Dr. Scordi-Bello, who is now on cross-examination. And what was really interesting in this cross-examination is that there are times in a retrial you think you've seen everything, but alas, there is still new information. And what we saw, though I don't think we have answers for yet, and I am waiting, is a photo of two law enforcement officers at the medical examiner's office. The doctor said at the morgue. It has not been clarified well for me whether or not the morgue encompasses the entire building, or if Emily, how do you say this without, or if the morgue is just the storage portion of the office, because normally you would have the morgue, which is the storage, and then you would have where they perform the autopsies. And the photo to me is very clearly Michael Proctor and Officer Keefe. Remember, Officer Keefe testified that he was the only one that attended the autopsy. No one else was with him. And I was like, how in the world How in the world does the lead investigator or case agent or whatever not go to the autopsy in the death of a police officer? I was not pleased with that information and kind of surprised by it. Did not remember that from the first trial. And lo and behold, there is a photo. Now, it is not clear to me exactly when that photo was taken. It is not clear to me if that photo is from the time of the autopsy or not. But there is a log, we are told, where any law enforcement that attended would have to sign in. So I am waiting for more information on that. But it's very interesting that this photo appeared with who clearly looks to me like Trooper Michael Proctor. But this jury doesn't know what Trooper Michael Proctor looks like yet. They haven't seen him testify. They've only heard his name. And there is some other information that we learned in the first trial that we have not gotten into in this cross-examination, and I don't know if we will. Could law enforcement have gone to the coroner's office more than once? I suppose they could. We didn't hear that testimony from Trooper Keefe when he testified. He said he was there alone. So when is that photo from? Because it's clearly at the Cape Cod Medical Examiner's office. Was that during the autopsy? Was that not during the autopsy? I want to know everything. But the defense, through Attorney Alessi, on cross-examination is walking through not only maybe taking some preemptive shots at the prosecution's expert, but also asking some questions that will solidify things that their experts have done. We've talked in cross about pattern recognition, and we've heard them talk about Dr. Stonebridge, who we saw testify at the first trial, who is the neuropathologist who examined John O'Keefe's brain after the autopsy that was sent to her in Boston, and then she did that evaluation. Is the prosecution not going to call her and rely on their neurologist expert and not on the neuropathologist? Well, if they do that, we've seen a lot of testimony from a kind of enthused Dr. Scordi-Bello about the general badassery of Dr. Stonebridge. So after we've heard about Dr. Stonebridge being triple board certified and being just all kinds of amazing, if the prosecution doesn't call Dr. Stonebridge, it will be very interesting to see who they call instead, maybe their expert, and if that person is also board certified from here until infinity and beyond. But at this point, I'm rooting for Dr. Stonebridge. Why? Because I really found her very interesting first trial, and I liked her testimony. And I thought it was really cute when Dr. Scordi-Bello is like, oh, no, I know that. I can answer about what I know of Dr. Stonebridge and all her qualifications and how great she was. It was a nice moment to see the genuine enthusiasm for the brains that is Dr. Stonebridge. I also, though Hank Brennan might have had proper, objections to Alessi's little bit of a quip that Dr. Stonebridge is the brains of the brains, I was just like, oh, come on. There are so many things in this trial. That's just one little question. But I also wonder if the Commonwealth was objecting to Alessi calling Dr. Stonebridge the brains of the brains is because they don't intend to call her. We're going to have to see how that plays out, because I'll be grumpy. I'll be grumpy if they don't call Dr. Stonebridge. I like Dr. Stonebridge a lot. So, if for nothing else, Emily likes this witness, please call them. That's not a good reason for the prosecution to change their strategy, but it's just how it is today. We are going to lunch, law nerds. Let's ask a few questions before we go to lunch. Miguelina let me know that court should be back around 12:35 Central, so 1:35 local. So I'm going to give it a couple minutes, and then I'm going to take a break to get some food and check in with my kiddo, because I have a kiddo home today. So we're going to do that, and then we'll go to our beloved hold video, and I will not screw it up like last time where it ended before I was back from lunch. That was, Emily, is it all your fault? It was 100% my fault. It was 100% my fault. 100% my fault. Laura said, for Everybody International, how many minutes? It'll probably be about 15 minutes from when I leave. So I will let you know when I leave. Redondo Beach put a message in the chat saying that her friend had passed in LA County. I'm so sorry. It is probably hard to listen to the coroner's testimony, I imagine. I'm really sorry for your loss. It is not an easy thing. And waiting on the LA County Coroner's Office, they are incredibly busy. It can be difficult for sure. So I know the chat sent their condolences. I'm sorry about that. Christopher asked, was it ever cleared up whether they found John on his back or was he face down? From all of the information we have, except one statement by Jen McCabe, John O'Keefe was found on his back, and the lividity all supports that finding. Jen McCabe in the 911 call said we flipped him over. I don't put a lot of credence into, well, not just Jen McCabe, but any bystander under stress. There are times if the evidence all doesn't line up that people say things when they're stressed and you're like, what are you even saying? Like, what are you even saying? So I have not seen any evidence that John O'Keefe was found in any way other than on his back, and his autopsy and other information all supports that. So my dog is my ears said, I'm a nerd. Could Dr. Stonebridge be called by the defense? Yes. And they also have their own experts, but yes, they can. It will be interesting to see what they decide to do. Mysteria Claus said a retrial should be boring. Yeah, it should be pretty like, we've seen this. Where are all these surprises coming from? Look, law nerds, this is purely my speculation. First of all, we know that there's new information that law enforcement found and turned over to the defense between the last trial and this trial. It all came up in the motions to dismiss. We also know that from the federal investigation, more information was turned over between trials. So a lot more information came in. Like a lot more information came in. Thank you for the gifted memberships. Orbiter, in that photo, it looked to me like Proctor had like booties on. And I don't know if this coroner's office requires people to be in like the zip up paper suits. That would be common while an autopsy is being conducted, that you would be in paper suits and like head covering, not like a hairnet, but yes, kind of like a hairnet, and mask. And so they were not dressed the way I would expect them to be dressed if they were at the autopsy, like in the moment that that was taken. That doesn't mean that photo couldn't have been taken before they did that, before they went into the autopsy, after they came out of the autopsy. There's a lot of possibilities, and I'm noting it with an asterisk for all of you that I have a lot of questions about that, and I'm not going to make a conclusion until we have more information. We just don't have enough information. Matt, the future ESQ, have we rested for the prosecution yet? No, Matt, good to see you. We haven't. The prosecution said they thought their case in chief would take about 23 days, 23, 24 days. We're on day 16. We're getting close, but well, we're into the medical testimony. I don't know if they're not going to call the lab. We have a lot of lab testimony that hasn't come in yet about the DNA testing and other testing. We have their medical expert, their like dog bite or lack thereof expert, a new accident reconstructionist, the neuropathologist, if they call them. And there were like 4 or 5 different lab personnel that tested different things that haven't testified. But I'm curious if they are going to not call any more civilian witnesses. Like, we might be just completely done with that. So there's a lot of witnesses that haven't been called. So we will see. Let's see. There are just a few more questions and then I'm going to go grab food. For a few of you said, Emily, how do you eat so fast at lunch? First of all, when I was in trial, doing trial work, lunch was often not something that happened. So A, that's not unusual to me. I don't think it's the best plan for anybody, but that's not unusual. B, I tend to bring things back to the desk with me and pick things that are easy to munch on while I am down in the corner streaming because, it makes it easy. So normally it is more gathering than eating during the entire time. Let's see. That bing sounds like the sound on your Law Nerd text. Could somebody be getting it in court? I do not think they are getting Law Nerd alerts in court. I think it is whatever they are using for the you are unmuted, you are muted. It's on that computer is binging, and that sound is used on a lot of things. I really want to customize the sounds on our app. We have asked about it and are looking into that, amongst other things. Team Baker has a lot of projects. Are you shocked? Emily, how much of Team Baker is just powered by ADHD? We have a lot of ideas. We're like, can we make this happen? And then if it's like, yes, this is going to take a minute, it's like, we had the thought, can it be executed immediately? Generally, the answer is no, which is really unfortunate. Bianca said, EDB, when you were in trial, did you find yourself going through the motions at home and randomly ask family, may I approach? No, it was well, I also had a pretty long commute to like try to put trial mode off. It's very hard to turn off trial mode, and my kids refer to it as trial mode. It is not easy to turn off trial mode. Yeah, it's not easy, but no, I didn't ask to approach. I was normally just grumpy, kind of tired, and reading a lot, and then trying to sleep. It is, they are long days. Kimberly asked Emily, will the jury be able to handle the clothing with gloves on? Generally, no. They will be allowed to see it, but generally they will not be handling it. But it really depends on jurisdiction. So, Olivia Kelly said, why did they put things in red Solo cups? That was all covered in testimony by Gallagher. And he said, due to the elements, they didn't have much else to collect it with. And that was their thoughts about that. Willow asked, wouldn't the elusive former Trooper Proctor make the jury doubt because they don't know who he is and why he's not being called? Yes, I think so too. I don't know what the prosecution, well, the Trooper Proctor problem is a problem for the prosecution. It is legitimately the Trooper Proctor problem. It's bad if you call him. It's bad if you don't. I think it's worse if you don't. That's just from sitting here how I see it, because it is a huge elephant in the room. Do they need Trooper Proctor at this point? They don't need him, but does it open a big old avenue of argument for the defense of what's the Commonwealth not showing you and how can you trust this investigation if you haven't even heard from the lead investigator? Yeah, it does. It raises a huge question. And for some jurors, that might be enough. It's like, well, if you're not going to show me the lead investigator, I don't know what the fuck you're doing. Like, it might, for others, it might be like, oh, something happened. Who knows? You could have jurors on there being like, former trooper, maybe he's no longer with us. You never know how jurors are going to fill in the blanks, which is why, from my perspective, the prosecution needs to fill in all the blanks that they can. You don't want to leave a blank space. The defense wants all the blank space they can have. And they're like, see, this blank space, like all those blank spaces, they're going to equate to doubt. So the job of the prosecutor, from my perspective, is to fill in all of that for them. You know, it's like asking 12 people to do a Mad Lib. They're probably going to come up with different answers than you would. You don't want to leave all those spaces. It's just not easy. Brandon Kirk, thank you so much. Winter Guard is one of Travis's favorite things to do. He loves it. But also the thrill that rifles might also give you a concussion is, I think, something that my kid enjoys. Also, throwing heavy things very high in the air is just a lot of fun. It's just throwing shit around can be really fun. So, Winter Guard, all good. All right, David said, just remember ADHD is a superpower. Do all the things simultaneously. Yes, including eat, which I need to go do now. Lawnards, I will be back when court is back. If court is delayed, I'll come in and let you know. If I am delayed, I'll come in and let you know. And, you know, if the music stops, it's blame Fred today. just blame Fred today. Just blame Fred. Or Weems, I do think that the coroner said 2 people at the autopsy, and I do want to go back and look at that after stream today. I do think she said 2 people at the autopsy. However, if someone from the lab was there to take photos, I don't know if Trooper Keefe was asked specifically, were you the only trooper there? Because if someone is from the lab taking photos, they might be considered lab personnel, even if they're technically a trooper. So there's a question mark there for me, and I think it's a question mark there for me. I don't know if that'll get answered, but we'll see. Blaming Fred trying to summon his lawyer. Don't summon his lawyer. His lawyer is probably busy. Fred has adequate more legal representation than a mischief managing orange cat needs. Also, Fred got all of the pets. And because we have kiddo home today, younger kiddo, I bet Fred is upstairs with G. So I'm going to go check in on the fam. I am going to see Julie, the drama. Fred is a sovereign citizen. But honestly, aren't all cats kind of sovereign citizens? They're like, I don't listen to your rules. I don't respect you. This is admiralty law. What are you talking about? I don't do that. All right, it is time to go to lunch. Let's go to lunch, you guys. Get some food, hydrate, or set a 15-minute timer and get the shit done that you haven't gotten done yet today. Now's a good time. Move the laundry. Put away the food. I don't know, figure out what you're gonna eat for dinner. You've got 15 minutes, set a timer and go. Let me know. When I get back, let me know what you got done in the 15 minutes. Even if it's just like leveling up in Midas Merge, I wanna know. Hey Lawnard, court is still on break, but don't forget to download the Lawnard app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Lawnard app has all of your live court notifications to keep you in the loop. LawnardApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Court is still on break, but don't forget to download the Lawnerd app so you know exactly when we're back from break. The Lawnerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Are you ready, chat? I had to put my hair back up. It's hot in my office. Things need to happen. Court is bringing in the jury. They went to sidebar for a bit, so we're just taking a beat to, well, finish a little bit of lunch, because why not? But what we need to do is get to court. They are letting the jury back in, so we are going to what?
Bring the jury.
We're gonna bring the jury. Don't worry, everyone who's like, Emily, we haven't talked about South Carolina. I know. We'll get there. But the hair had to go up. It's hot. I'm hot. Getting humid. We needed the stand desk. It's just all the things needed to happen. The fan's on. If you hear my fan, I'm sorry. I don't think you can. But
All right, Mr. Alessi, whenever you're ready.
we're in cross-examination of the coroner. If you're just joining us, welcome.
Welcome back.
Thank you.
We're gonna stand up and stretch for the afternoon.
To a slightly different aspect of
Hopefully, Alessi will get back to the mic in a minute.
discussion.
My
So,
guy.
You've
On the mic.
acknowledged previously that
Woohoo!
hypothermia is a very difficult diagnosis to make, correct?
Correct.
And you
why it's a
acknowledged that
contributing
in
factor, I
your
think.
grand jury testimony in this proceeding, correct? Do you recall that?
I do.
And
Right.
you indicated in
We know this
that
is a big issue
grand
for the
jury
defense.
proceeding,
They brought it up in
generally
their
the
opening.
diagnosing hypothermia is based on contextual clues. Is that correct?
On autopsy findings and investigative information, yes.
Right. And the last part, investigative, and that's that legal part, sort of the law enforcement contribution. Is that correct that you're referring to?
Correct.
You diagnosed Mr. O'Keefe with hypothermia based upon certain medical data
Hypothermia is
that
a
you
contributing
believe you observed
secondary
in
cause of death.
the
Contributing factor.
gastric area and the pancreatic area. Is that correct?
Correct.
And just for, I think most people will get this, to just be clear, gastric is sort of synonymous with the stomach.
Stomach.
And then we know the pancreas is a separate organ.
I guess we're going to talk about
And
that.
in your
So-
autopsy,
We'll just get there.
you observed
No. Chrissy, we'll get to that.
for example, the lining
time.
of both the stomach and the pancreas. Is that correct?
I'm sorry, what was the word you used?
Let's start with the stomach. Did you observe the lining of the
just got
stomach
back.
as part of Mr. O'Keefe as part of the autopsy?
We're talking
Yes, I
about
observed
hypothermia.
some hemorrhages in the lining of the stomach.
We'll get to that, right? But I just want to talk about the organs and what aspects of the organs first, and then we'll get to that. And with regard to the pancreas, what aspect of the pancreas did you observe?
I examined both the external surface and the tissues around it, as well as the pancreas itself, by making several cuts.
And there was also a histopathology report that was relevant to both the stomach and the pancreas, correct?
Correct.
Histopathology.
That was the court reporter asking to spell histopathology.
Histopathology.
Mr. Alessi, have you ever won a spelling bee? Because I feel like you probably have.
So that histopath,
Like the pattern of how he spelled that was just
informed
1010.
your hypothermia analysis. Is that correct?
The histopathology was done to further confirm my finding or my determination of hypothermia.
So
So you did a lot of things.
do
to
I
do
have
that.
it correct? And let's start with the pancreas. That you noted the pancreas was congested and diffusely hemorrhagic. Do I have that correct? And you feel free to look at your report, please.
She's like,
I
I'll
will.
take a look at diffusely hemorrhagic. I got you. I got you. Other
And
Solo said I did the
specifically,
dishes
if
and
it
finally
helps,
cleaned out the bathroom.
I'm looking at
Page 4.
the report of autopsy. It's not numbered pages, but it would be 4. And you see liver, gallbladder, and pancreas is 1, and then you go down a couple more and you see digestive system. That's what I'm focusing on.
Okay.
And then, and the next page is the histopathology.
Yes.
All right, are we sort of oriented in the same location?
Yes.
All right.
We are
So-
all oriented properly.
Let's start with the pancreas. So if you look at the histopathology page, it says endocrine and exocrine pancreatic tissue with vascular congestion and patchy parenchymal, that's parenchymal, hemorrhage, autolytic changes. Did I read that correctly?
Yes.
And I want to go at these one at a time, so now I'm going to jump back to the previous page.
We are going to get, I imagine, fairly deep in the weeds because the defense is going to use cross to lay the groundwork for their expert. Is the jury following any of this? It's after lunch. Does the jury need to follow any of this? No. For the defense's cross, they need this information in or want this information in when they get to their expert. So it's stuff that they need in the record so they can argue it later because you can't argue it if it's not in the record. Is the jury going to follow? Probably not. How will this information come back up again later when one side or the other side argues it and then the jury goes, oh yeah, that. So we're just going to get all the way into the weeds, just
Where
all the way into
you
the weeds.
discuss the heading liver, gallbladder, and pancreas. Do you see that?
Yes.
And you
Probably
see
a
the
lot of
last
spelling,
sentence says
too.
the pancreas is congested and diffusely hemorrhagic. You see that?
Yes.
So now what I'd like to do, and is that what you're rooting in, if you will, the analysis of
Definitely
hypothermia?
rooting around in the pancreas.
The determination of hypothermia was made, yes, based on these findings and the circumstances I was provided. Yes.
Right, and thank you. I'm going to get to the circumstances, but it's sort of the medical legal construct that we were talking about. I want to just start first with the medical, if that's okay with you.
Yes.
So then let's now move to the organ of the stomach, a synonym gastric in terms of your report. So let's go to, please, back to the histopathology section. And under that, under pancreas is stomach. And there's a bulleted one sentence that says gastric tissue with vascular congestion and focal mucosal hemorrhage. Did I read that correctly?
Yes.
And then let's go back,
You
as we
continue
did
to
with the
read that
pancreas, for the
correctly.
stomach, go back to the previous page in your report under the heading digestive system. And the second sentence states the gastric mucosa shows focal areas of linear hemorrhages. Did I read that correctly?
Yes.
So we've got hemorrhage discussion with the pancreas. We've got hemorrhage discussion with the stomach and the gastric area. Your diagnosis of hypothermia was not based just on gastric and pancreatic hemorrhaging alone, though, was it?
No.
And you did fairly refer to other circumstances just moments ago in your answer, correct?
Correct.
And we're going to get to that. So that means that your diagnosis of hypothermia was also informed by the information we discussed earlier that was provided to you by former Trooper Proctor in his investigation. Is that correct?
Correct.
And one aspect of that information is that he was found, Mr. O'Keefe was found in the snow, correct?
Yes.
So let's go to the death notification report. Am I generally correct that you were...
Yes, I also just heard death note. Death notification report. Death notification report. I'm with
sorry.
you, Chad.
I will. Thank you, Your Honor.
Death
Do
notification.
you recall the death notification report in this matter?
I do recall, the very initial first
Is that
information
your report, though,
that
ma'am?
comes in. That's the death notification.
I don't think that's hers.
given to our intake
right.
staff.
Do you recall the contents of that death notification report?
Would you like me to summarize? I don't recall I don't have it in front of me, but I can tell you what the gist of it was.
Would it be helpful to you if I showed you a document
wants the
that
whole
might
thing
refresh your
in.
recollection on what that...
What was in that for you?
A document that may refresh
She
your
said
recollection.
sure. I think you heard her.
I did. Thank you, Your Honor.
The court's trying to help. The court's like, no, she said sure. Just... They have fans on in court. This was a huge problem during trial 1 because it created some difficulty in hearing. I'm very empathetic to the lawyers, the witnesses trying to hear over fans with the jury, and also not wanting the jury to be hot and sweaty because, well, they don't want the fans turned off, and the attorneys don't want to be the one to ask for the fan to be turned off, for the jury to be uncomfortable, because then that sucks.
Reference to the section that says circumstances of death.
Yes.
What I'd like you to do is read it to yourself, not out loud, and then when you just that section up to here.
Alessi's
and
like,
once you're done,
does
if
that
you're fine,
refresh
you
your
look up and
recollection?
let me know.
Okay.
This is not a report she wrote. This is a report that she received as part of the intake through her office. So that's what they're talking about.
Dr. Scordi-Bello, did that
we were
refresh
talking
your
anime
recollection
briefly.
with
Just-
regard
We were briefly talking
to
anime.
the
Well, we were distinguishing.
circumstances of death section of the death notification report?
Yes.
And you could please state now what your refreshed recollection is on that topic.
What information
Yes,
you
the
got?
initial intake death notification was made by a physician at the hospital, and it stated that we were dealing with a adult male that was found in a snowbank. There was note of having
That came from the
been
911
at
call.
a party. There was some information as to the decedent was walking to a house. There was reference to some sort of altercation or dispute with
Sustain.
No.
There is disregard that.
I mean,
Move on with this, Mr. Alessi.
it's
With this, but just move on.
the reason this is new information is because it's coming from the intake from the hospital. The hospital gathered that information from first responders and possibly law enforcement, but it is all hearsay, and she did not say that it was part of the basis of her determination yet. So that's like 5 levels of hearsay, but Brennan should have objected at the beginning because he has that report and he knew where that was going. So she got that information, but he didn't lay the foundation that she relied on that heavily. And she said, roughly it was this. They need to bring that witness in then. So that's been stricken. I saw a couple of you saying, can we run it back? It's not in front of the jury because it's now been stricken. So that's where we're at with that.
Yeah, yes. In terms of
But again,
the
it's
differential
real hard for the jury to
diagnosis
strike
concept
things
that
from
we
their
were
mind
talking
when the
about, before,
prosecution is saying,
based upon your
You know,
refreshed
objection.
recollection
What don't they
of
want us to hear?
circumstances of death as discussed in the death notification
He's gonna do it a different way.
report, based upon that, did you consider
right.
whether Mr. O'Keefe could have been injured and died somewhere other than the front lawn of 34 Fairview?
I'm going to allow that.
Yeah, he can do it another way.
Initially, no.
Initially, no. So at some point you did.
Let's go to
Moldy orange, a struck comment gets stricken out of the record. Well, I mean, it's in the record, but it's shown that it was stricken out of the record, so it's not for the jury to consider.
Of the two organs we
The jury has heard it. They're told not to consider it. They've already heard it, but it can be relevant more in appellate work after the
were
fact.
talking about, the pancreas and the stomach. Is it correct that the hemorrhaging of a pancreas can be caused by many different things?
Yes, it is.
And to be clear, you found evidence of hemorrhaging of the pancreas of Mr. O'Keefe in the autopsy, correct?
Correct.
Martega Tortuga
And
in the chat
is it
asked,
correct
should the
before-
defense call that doctor? Some of that information's still going to be hearsay unless that doctor relied on that information for treatment. Some of it might still be hearsay.
The grand jury, you yourself were evaluating whether the injuries had been sustained in a different environment. Well, let me ask it this way. Do you recall what your testimony was in the grand jury about hemorrhaging of the pancreas and possibilities of injuries being sustained in different environments? Do you recall any testimony on that subject?
All right, I'll see you at 10.
I'm just making a note. All right. They are back at sidebar. We are going to be caught up live now. We have no Zoom room, which is fine. I will answer some. What? Bro, what? What? Where did your feed go? Oh, what are we doing today? Why is today today? It's time for Emily's Daily Crash Out at the feed. Yes, it is. At least they're at sidebar. Did I get yeeted? I didn't get yeeted, but at least they're at sidebar. I don't know where their feed went, though. Hold on. Let's pull up another feed. This one might not have closed captioning, and I am sure that Team Baker is already looking for another feed. Do not fear. But this one likely does not have closed captioning because it didn't yesterday. Well, at least it's not just me. I don't know why they're having such feed issues, but let's see. This might be a closed captioning issue. Give me one sec. I'm going to look for a few other things because, Lord, this has been annoying. So I was going to answer some questions, but Leonard, streaming is dynamic. So give me 1 second to find a feed that's not going to put up, well, a whole bunch of nonsense on the screen that is distracting because, how I feel about that. So I'm going to look for another one that has closed captioning. This one does not. Hang with me, Leonards. But at least we're in court in the meantime, so yay for us. Unless he's going back to the podium after that sidebar.
May I, Your Honor?
Yes.
Thank you.
Oh, and Ryan Hall y'all's going live. Uh-oh. Well,
At the grand
Is it
jury,
me, Ryan?
did
Is
you
it me?
testify as follows?
Oh, today it actually might be me.
If the
Shit, it's Thursday.
injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. You recall that?
Yes.
Hemorrhaging of the pancreas can also be caused by blunt force trauma, correct?
Correct.
Hemorrhaging of the pancreas can be caused by CPR, correct? Cardiopulmonary resuscitation.
It's possible.
Do you know what a Lucas machine is?
Yes.
We're going to get into that.
And a Lucas
As we
machine
should.
is an automated CPR machine, correct?
Correct.
And it's a rather large device, correct? It gets strapped down to the chest of someone. So instead of someone having
I'm looking
to
for other feeds. That was me.
exercise, etc., you put on a Lucas machine that goes over the chest and it automatically does the compressions, right?
Correct.
Lucas machines can cause hemorrhaging, correct?
Yes.
And in fact, wasn't a Lucas machine applied to Mr. O'Keefe?
I believe so.
And wasn't the Lucas machine applied from when the first responders came to the scene and he was in the ambulance continually and through when he was in the hospital?
I believe so, yeah.
So, when a Lucas machine is used in resuscitation efforts, you'd actually expect to see some hemorrhaging,
It's a
wouldn't
good
you?
question.
Where?
In the stomach? In the pancreas? Would you expect to see it there?
Not in the mucosa of the stomach and not as extensive in the pancreas.
Let's talk about and pick the pancreas first. So you would agree that from the use of a Lucas machine, you would expect some degree of hemorrhaging in the pancreas, correct?
Not always.
But it's certainly possible that a Lucas machine causes hemorrhaging of the pancreas, correct?
It's possible.
And now let's move to, and there was evidence of hemorrhaging in the pancreas of Mr. O'Keefe, correct?
Correct.
Now let's move to the stomach. Isn't it possible that a Lucas machine could cause hemorrhaging in the stomach?
Personally, I have not seen it in that
So the
context.
defense is looking for those
Do you
differentials
rule that out?
I
to
can't rule it out.
hypothermia.
I can only tell you my experience.
So your personal experience is you don't believe you've seen that, but you can't rule out that a Lucas machine causes hemorrhaging to the stomach. Is that correct?
I don't believe a Lucas machine causes hemorrhage to the mucosa of the stomach.
Right. I'm not yet at the mucosa of the stomach, which is a subset.
She's like, right, but
of
I'm
the
answering your
stomach.
question.
Right?
He's
You're
like, no, we're
talking
going
about
step by
the
step with this.
guy.
Talking about the inner lining of
The
the
inner
stomach.
lining, and another name for the inner lining of the stomach is the gastric rugae, R-U-G-A-E, correct?
Yes.
So I'm just talking about the stomach in general, not a subset of the stomach. Is it possible that a Lucas machine could cause hemorrhaging in the stomach?
Not in the stomach, around the stomach in the soft tissues of the torso.
Okay.
Right. And the defense is looking for other possibilities. That doesn't surprise me. And I am looking for closed captions. So do not worry. And we are at a Zoom room, I think. So we're going to wait with Alessi.
So you've said that you're aware that Mr. O'Keefe was hooked up to a Lucas machine, correct?
Yes.
And are you aware of the length of time that Mr. O'Keefe was hooked up to a Lucas machine?
No, I am not.
Do you know how many compressions per minute a Lucas machine causes?
It's a good question.
I would have to say close to 60.
Would 100 compressions per minute be a reasonable amount of compressions for a Lucas machine to cause?
Sure.
So assume 37 minutes of a person hooked up to a Lucas machine and assume 100 compressions per minute, that would
Oh, no, are we gonna math?
3,700 compressions from a Lucas machine, correct?
Correct.
Could 3,700 compressions from a Lucas machine explain hemorrhaging in the pancreas?
You could.
And that explanation
Is it possible?
could be
Yes, it's possible.
why there's hemorrhaging in the pancreas as opposed to hypothermia causing hemorrhaging in the pancreas, correct?
Possible.
Did you consider that at all in your autopsy report, the effect of the Lucas machine? Is it written anywhere in your autopsy report?
I do consider changes due to cardiopulmonary resuscitation. The rib fractures that were observed were attributed to CPR. Usually we will see some amount of hemorrhage in the soft tissues, but in this context, with the gastric findings, the pancreatic findings, and the information that he was found in the snow with a body temperature of 80 degrees,
Right. The totality.
my opinion
not
was
just the
that
one
those
thing.
hemorrhages, along with the gastric hemorrhages and his body temperature, were consistent with hypothermia.
My question was,
It's
does your report
narrower than that.
state anywhere
No, it doesn't.
the words Lucas machine?
No,
No, she's like, no, it's in the medical reports.
And you agree that a Lucas machine could cause hemorrhaging to the pancreas,
it can cause hemorrhage in a lot of tissues,
but including the pancreas.
including the pancreas.
He is chipping away at the foundations of her diagnosis because we know the defense is going to attack the hypothermia. We can talk more about
If
why
you
later, but I
see
think
hemorrhaging
mostly because of
of
count
the
2 in this
pancreas,
case, not count 1.
and you believe that hemorrhaging is a contributor to hypothermic deaths, wouldn't you also expect to see Wisniewski ulcers?
I did note gastric hemorrhages.
So the court reporter needs to
Spelling.
have a spelling of that. Doctor, can you give us the spelling of that?
Would you like to give it?
If you'd like me to, I prepared to give
ahead.
it. Thank you.
The chat votes for him.
Wishnewski.
The chat
So-
voted for Alessi. The chat got what they wanted. The chat got their
Can you
way.
just tell the jurors what Wisniewski spots or Wisniewski ulcers are?
Wisniewski spots
'Cause they name it after
are
you.
small hemorrhages, small areas of bleeding in the mucosa of the stomach that are thought to be associated with hypothermia, amongst other things.
Among other things, is probably where this is going.
Believed to be either a reaction to stress due to the hypothermia or some form of what we call reperfusion injury.
Is it correct that if
spelling
someone
cadence
is
is great.
believed to die, at least in part, from hypothermia, that in 90% of the cases of death from hypothermia, you would find Wisniewski's ulcers?
I do not know the exact number.
A lot of you are saying, damn, Alessi researched the hell out of this. I would say
Is it-
yes. And
That you're not.
Alessi also has an expert who he has learned from. So it's not uncommon. And in fact, it would be more common than not that Alessi would be also conferring with their expert about what to ask this expert. You allow your experts to educate you in the subject areas you're getting into. So he would be talking to his expert in addition to his own research. You would get a little bit of both, and I'm sure Alessi did both. He also deals very much with the experts in cases, and from all reports also is a pharmacist, so has enough of a medical background that it's going to be easier for him maybe than the average attorney to understand. But attorneys that work especially in cases with medical a lot become actually pretty conversant in what's going on with medicine just because of the amount of experts. Really, the job of being a lawyer is to know how to learn quickly and retain that information. Truly, it's just like, I know what I don't know, and I know who to ask. That's the job.
Calling
Yes,
what
by
the
all reports, he's a
percentage
pharmacist.
is for the percent of cases for death of hypothermia that you would
I can't
expect
verify
to
he
find
works as a pharmacist,
Wisniewski's
but he has
ulcers?
that
I
background.
don't,
Do you recall?
Hold on.
I'm sorry.
Move on. The objection sustained. So
Okay.
you're asking.
We'll back up to where he's going.
Is it that you're not recalling what the percentage is for
She said she didn't
the
know.
percent of cases for death of hypothermia that you would expect to find Wisniewski's ulcers?
I don't,
Do you recall?
Hold on.
I'm sorry.
Move on. The objection sustained. So
Okay.
you're asking it. Yes.
It's been
Okay.
asked and answered.
There were no Wisniewski's ulcers present
That's the
in
question.
Mr. O'Keefe. Is that correct?
I believe there were.
Can you point anywhere in your autopsy report where the word Wisniewski appears?
I did not call them Wisniewski spots. I called them gastric hemorrhages.
Right, so you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages in the pancreas are Wisniewski?
Sir, she's talking about the stomach.
You mean the stomach?
I want to start with the pancreas.
She's not talking about the...
Wisniewski ulcers are, the term is used to describe the gastric hemorrhages.
Right, so I wanted to clarify that. So now I want to move to the stomach.
Okay.
You were just asking about the stomach. The whole conversation, you moved from the pancreas to the stomach. And then when you said pancreas, she was like, stomach. And you're like, no, pancreas. You had moved on.
All hemorrhages in the stomach are Wisniewski ulcers.
Not all of them.
Therefore, there can be Wisniewski ulcers and not be hemorrhaging, correct? Just by logic?
What? No.
And not be hemorrhaging?
Correct. You can have a Wisniewski ulcer
Isn't it?
but not have hemorrhage.
You answer. You
You could, but ulceration would manifest in what we call hemorrhage, the actual appearance of it.
That's how they would
What I'd
note
like
it.
to do now is, Mr. Wolf, what has been in evidence, what I'd like to do is to, with Your Honor's permission, publish some depictions of first the gastric mucosa.
Are we talking about the victims?
Start with that, Your Honor. Publish that.
All right. So this is the one that we have not introduced into evidence openly, but it's sidebar, right?
What I'd like to do is I'll start out with the one that is in evidence, which is the gastric mucosa.
Okay.
Start with that.
What number?
Okay. For those of you asking, why does it matter? It's going to matter for the defense. The defense's expert. So that is why we are here. But I am going to switch witnesses real quick.
Okay, so that was the one I was referring to that we did at sidebar, not in open court. Okay.
I'm going to switch feeds real quick to get our closed captioning back.
move N into evidence at this time.
All right.
While
All
he's
I'll
moving
say
this
about
into
this,
evidence.
jurors, is that this may be considered graphic. You satisfied with that, Mr. Alessi?
I'm satisfied with that, Your Honor.
It seems like we're talking
Mr.
about
Brennan, you
stomach
satisfied with
lining,
that?
so
Okay.
all right. I'm going to switch feeds real quick. So give me just one moment
Yes.
as they are doing that because, well, you know what a big fan of closed captioning I am, and I know what a big fan of closed captioning you are. So now that our closed caption feed is back up, why does it keep disappearing? I don't know. I wish I did, but I don't. I think it's just because streaming is dynamic and we need to be reminded of that every single day. Like we need to be reminded just every day. Emily, no, we're going to start. We're going to just go full Dave Matthews here in a minute. So.
May I, Your Honor?
Yes.
Oh, Lord. Okay, well,
Dr. Scordi-Bello, I'm handing you
a stomach lining photo.
Exhibit 164 in evidence.
All of the scientists in the chat, all of our medical law nerds are like, this is amazing. The jury is like,
Please feel free to look at either one.
okay.
Mr. Wolk, if you could publish 164.
I don't know if they will put this up or if we will just see her talking about it. The reason they are doing this with this witness is because they are going to go through this again with
Dr.
her,
Scordi-Bello,
with their expert.
do you recognize 164 as the, well, you describe what 164 is.
This is a picture of the stomach of Mr. Keefe after it was removed and opened and the contents
None
were
of this is in
removed.
evidence yet,
And what
Sherry,
you're
so.
looking at, this
When we
pink
get to those
red
witnesses, we'll get there. Or we won't.
surface is the mucosa. That's the lining of the stomach. And you had used the word rugae before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than
it's not-
everything else.
it's not
That's
after
hemorrhage,
launched
that's
testimony.
blood. And these are the gastric hemorrhages that I described.
Right, so those are the, what you just showed, there's darker areas, there's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to
Correct.
them as hemorrhages.
Correct.
Okay. So what I'd like to do now is to, if I may approach, Your Honor?
Yes.
For the chalk.
I think of all the things the jury has to look at, a up-close photo of stomach lining is probably one of the least difficult things because it's
Your
a
Honor,
little bit more
with your
detached,
permission, may
if
I
that makes
show,
sense.
Dr. Scordi-Bello, the chalk that's marked for identification, is that that?
Yes, and let's see what she answers before we use it for more questions, okay?
Yes. May I hand it to you?
Yes.
Dr. Scordi-Bello, could you please take what's identified as Exhibit M and see if
And for
you
many of you,
can
chat,
identify
I appreciate that you
what
have
that depicts.
medical backgrounds, knowledge,
Yes,
personal
this
experience.
is a picture of a
I'm not speculating on other causes.
stomach. Again, the mucosa.
They have
with
to explain it.
Hemorrhage.
Hold for these, sorry.
They have to explain it in court. So I'm not going to speculate on where we're going with this. It's for the defense to ask the witness and the witness to answer. So for everyone who has other backgrounds, thank you
Yes.
for adhering to the not speculating. Oh, I missed what the judge said because I turned it.
Your Honor, can we take a break?
Yes.
Oh,
Yes.
that was the bailiff. That was the bailiff who said, Your Honor, can we take a break? I'm going to back that up one more time.
Your Honor, can we take a break?
Yes.
Jurors.
Yes.
He said, can we take a break for the jurors? So it might, well, one of the jurors might need to use the restroom. It might be something else. So again, thank you, chat. We are getting a full day's worth of our do not speculate vibes. It gets harder and harder to to do not speculate depending on what's going on in court. But well, I know it can be frustrating. It is what we do. I will tell you when there's times that I am giving you my best estimation, or opinion on what's happening. But you never know. I'm sure we'll find out. But thank you for not speculating in the chat, lest you get timed out by my fingers, because, well, it just makes me cranky and derails the chat. Let's answer some questions, shall we? So the jurors can indicate if they need to take a moment. So Quasi in the chat asked, do we have Zoom room? Nope. No Zoom room. We are all zoomed up. We are no Zoom room. No, none at all. So EORRN said positive vibes, interviewed for a faculty position, and we'll hear results tomorrow. All the good vibes sent. All the good vibes sent. Let's see. Christopher said, I can't imagine being an expert witness. My brain, you've got this. IBS, we absolutely do not. Fair enough. Being an expert witness is not an easy thing. Look, the criminal justice system is not easy for anybody. They are very long days. There are very few breaks. What happens if a lawyer has to go to the bathroom? You do your best to train yourself to not to, or you are dehydrated, which is not good for anyone or anyone's brain. So it is tough. Ali B said his poor family having to hear all this, they would have been given the heads up so they can choose to be in court or not. Families should be given the heads up so they can choose to be in court or not. And so that is up to them. Nance said, thanks, ADB. The Lawnard app reminded me in a totally timely way. The Lawnard app is here for you. The delivery time does vary by carrier, is what we've learned from looking into it, because you better believe with Team Baker moving at the speed of ADHD, we also want to see when we push send, we want the notification on our phone immediately. So we actually do quite a bit of speed testing in the background to make sure that that happens. And when it doesn't, we ask lots of questions. But one of the big things is carrier. So it really can vary by carrier, by phone. We're on an unexpected break. So how long will we be? I have no idea. Are we going to answer questions? Yes, we will answer questions. If you need to go get something done, well, I'll let you know when we come back in the Lawnard app. Today's going to be a lot of alerts day. It's just going to be a lot of alerts day. Am I ready to switch over and see what Ryan Holyall's reporting on the weather? I mean, yes, but he's not live yet. And it looks like our severe weather is coming in later today. So everyone, today is one of those days. You know, when it goes from 50 overnight to 90 during the day, you just kind of know. You're like, weather's a coming. You can just, Ashley said, thanks for being amazing. Ashley, well, thank you. You are, I'm just doing the stuff on the interwebs. And I have a pretty good tolerance for hours without using the bathroom. Trial work has trained me. Fancy said, do jurors get to keep their notes at deliberation? They do, but after deliberation, the jurors have to turn their notes in. So yes, they get to keep them for deliberation, and then they turn them in, and they do not. So Christopher asked, if the jurors spot a clear issue, like a mirrored marker on the back of a Lexus counted as 2, can they ask the court for clarification, even if neither lawyer addressed it? Not in this jurisdiction. They don't get to ask questions with witnesses. And by the time they get to deliberation, if they ask those questions, they may not be answered because the witness has already testified. You saw it earlier today when and I forgot to put this in my summary. I forgot to talk about this in summary, but we had the scientific witness with the mirroring on the car asked today to clarify their testimony. And the court's like, the questions are complete. So even the witness couldn't. So so they can't ask questions. Let's see. Lots of Sunshine asked, did they ever get a time of death in opening? But I don't know if we had it through Buchanan. So I don't think they have it in evidence just yet. So Lizbeth said, does anyone see the notes after they're turned in? The court should destroy them. That's generally what happens. Holly Yang said, I thought they weren't allowed notes last trial. They were allowed notes last trial. They were for that. So Brittany asked, they said it in opening. I said, I think. I am not sure. And Misperception said, EDB. I mean, I shortened it. I try to be impartial with my nurse brain is overtaking, and you have taught me about the law with this topic. Does Brennan keep cutting Alessi off with objection or the judge? Brennan makes an objection and then the judge rules on it. So he is making objections. He generally stands to make objections. So the court, I mean, they're sitting right there. The court can see him standing to make an objection. So yes, he's making objections, even if they're quiet. His standing up is also indicating that there's an objection. So it is. And yes, medical testimony for those with medical backgrounds is one of those things that you're like, okay, but this, or I don't agree with this, or I do agree with that. The more experience you have in an area, the more natural it is to either agree or disagree with the experts. I feel like it's my job to kind of keep the case in what the jury is seeing, but depending on what the jurors know, what their life experiences are, then that can change. If you have jurors, this is why they ask jurors what they do for a living. If you have jurors on the jury who have a lot of experience in this, they can say, that seems odd, this seems, and then they can go from there. So it really just depends on who your jury is, which is why you need to know your case very well and pick your jurors wisely, because their information will come in. Jurors are not told to check their common sense and life experiences. So you can get jurors explaining things to other jurors based on their life experiences in the jury room. So you can do that, and we will go from there. Jay said, Emily, I'm new and wanted to know, where did it go? Does the new camera footage of Brian at the PD show him on the phone when he clearly stated he wasn't making calls at that time? Jay, in this trial, we don't have any statements from Brian Higgins about whether or not he was on the phone. So that's not before this jury. So they don't know. But I would have to go all the way back and take a look, which I'm not going to do until the trial's over. And I know everyone sends it to me. I'll look when the trial's over, because for me, I am very much trying to keep in mind what this jury knows. But if it is contradictory and he does testify, that can come up because they have it on video. But if he doesn't testify and he isn't called by either side, then this jury won't know what he said during the first trial, because they just won't know. So that is that. Well, that is not that. We are at an extended sidebar. So we are, well, we're going to be here for a minute. So we're going to answer questions. And then when we get through questions, I don't know. Well, maybe we'll watch the weather. We're just going to be here for a minute. Breen, oh, it looks like they might be coming in. Breen said, masshole living in Baltimore, drinking my iced Dunkin' guy. Drinking my iced Dunkin' guy. I know. One of these days I'll have to grab, I'll have to figure out what everybody drinks from Dunkin', because I did not grow up in a Dunkin' area. And then I went to college and was like, why is everything Dunkin'? Everything's Dunkin'. But you know, it is what it is. Let's see. I am going to keep looking at your questions and trying to answer them as best I can. Meg R said, what in the leading and speculation are you doing, Brennan? Yeah, he was all in those leading questions this morning. But also, I imagine it's real hard for Brennan, because there's been a few witnesses. He's asked them very clear questions, and then they've gone like the wheels have fallen off and they've gone sideways. And I'm sure Brennan is like, what the fuck? What the fuck are you saying? What the fuck are you doing? Like, what the actual fuck is happening right now? Brennan seemed to me to be caught by surprise with the Trooper B. Are these the things recovered from the hospital? This is from 34 Fairview. Bro, what? What are you even saying? Same with the witness yesterday. Is this what you collected? This. But there's other stuff in the bag. What? He seemed genuinely surprised. I don't know why he should be. He shouldn't be surprised that these witnesses are just kind of wild. It's just, and he's a defense attorney. I don't know if Brennan ever worked as a prosecutor and when and how long ago it was. Defense attorneys generally do much more cross-examination than direct examination because they're not putting on the case in chief. So they do a lot of cross. And he definitely falls back into that pattern of questioning, but that is an ingrained pattern over years of trial work. So yeah, there's times when he just slips right back into it. And it is frustrating for him and for everyone else, I'm sure. Let's see. Brennan reminds me of a businessman from the 60s. I like I'm here for the three-piece suit today. Diana, this came up a bit yesterday too. Diana Miller said, EDB, I remember Mr. Read. I think there was ring video of maybe Karen Read's father and or maybe her brother wiping off the back windshield and pulling up the windshield wipers. Yes, they did. But we also know there was quite a lot of snow coming down in the car. I don't remember what time they left One Meadows Ave, but the car left One Meadows Ave. After that, went up to Dighton. It looked pretty covered in snow when it pulled in because there's videos of that car pulling in to the driveway in Dighton before it's loaded up onto the tow truck. And then when it gets loaded up onto the tow truck, it's driven all the way back to Canton. So there is video of it. I didn't pay super close attention to the video of it because we saw the ring camera and then the other cameras, but later we can go back through it. Those are all timestamped. So if you guys want to go parse through the videos, you can, but those are all timestamped. The thing that's hard for the jury is even though we have instant replay, they don't. So they can't even raise their hand and be like, can you just play that one more time? Which is so frustrating because I'm like, no, rewind that. I missed that. Rewind that. I missed that. And so I feel like that is a hard thing sitting on a jury and not knowing what's going on. Like now, we're sitting here now. Sapples, I'm sure you are caught back up, but also we've got the daily case briefs on the Emily Show channel. We put those out the next day before I stream. So if you want to catch up on the summaries of what happened the day before, or if you want to put those on your favorite podcasting app, if any of you use a podcasting app outside of YouTube, the Emily Show has all those daily case briefs. Those drop every day. The only one that's really out of order is day 4 because I caught up with it later. But those are all up on the Emily Show channel. So if you want to catch up on that channel, you can catch up there. That's where our shorter form and VOD content is, and the weekly podcasts this week. We got a lot to cover in the podcast this week. We got a lot to cover in the podcast. The trouble with Tracy said, I thought the Sallyport videos were only motion activated. So how do we have a time lapse of melting snow, but not the action when the SUV arrived? I have no idea. And no one's been asked and no one's testified to it. So we don't know. Sounds like court is coming back. Light Queen says she seems thrilled to be getting questioned by someone who actually understands what she does. I don't think it happens very often for her. Yeah, the coroner seems to genuinely, well, that might have changed a bit after lunch, but seemed to genuinely appreciate the questioning for Alessi. He's direct. He doesn't.
All right, Mr. Alessi, you can continue where you left off.
He elevates his voice, but he does not, he's not aggressive in his tone and manner with witnesses. And today, I think some of the elevation and the vocal elevation is because it is hard to hear in the courtroom with the air on. Let us resume.
Hey, Your Honor, may I reapproach the witness?
Yes.
So I do think she enjoys it. A lot of the coroners I worked with were like, I didn't want to talk to people as a doctor. Coroners, good job for that.
We're discussing that. Do you recognize that document? start over to reorient the jury. You recognize that?
I recognize what it is, yes.
And what is it?
It is a picture of a stomach, of the mucosa of a stomach with multiple hemorrhages.
Okay, back to the
And-
pictures. Lovely, this is a great question. When the Commonwealth rests their case, will the defense be allowed to have the same amount of time as the Commonwealth? You cannot limit the amount of time that the defense can present their defense. So yes, and if the defense needed more, they could have more. It's just how much time they need for their witnesses, but there isn't a clock on criminal cases, particularly on the defendant's case. And there isn't going to be a clock or a restriction, unlike some civil cases where you will see the judge be like, each side has this amount of time. Because civil cases, there are times that things will go round and round and round and round. You can't get into cumulative evidence. So if you were getting into something that was unduly burdensome and cumulative, then it can be truncated. But no, if the defense wanted 3 weeks to prove their case, or 4 or 5, if they had that many witnesses, then they can bring in those many witnesses. But you're not going to limit them being able to present their case.
That exhibit fairly and accurately depict a stomach with what you have referred to as multiple pulses.
Yes.
Yes.
Your Honor, I offer that into evidence.
Okay.
I'll, you know what, if I can use it as a public, a chalk
Yes, you
publication.
can.
Yeah, that's what I'll do, Your Honor. Thank you, Mr. Brennan.
So you can have it displayed.
Thank you. And again, I'll leave this hard copy with the court reporter. We'll use the
Oh, so it's not in evidence?
It is not.
It's marked for identification.
Are we using this as identification? Okay.
We are with it.
Okay. Madeline said
Mr.
trial's
Wolf?
supposed to be about 5 weeks. The Commonwealth said they had 3.5 to 4 weeks or 24 days of testimony. The defense said about 1.5 to 2 weeks. So give or take. Unless, again,
Dr.
something
Scordi-Bello,
goes off the
is
rails,
that
which
the
can happen.
depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This is the mucosa, the folds of the stomach. They're not very folded in this particular picture, but you can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe. This is a medical reference depiction to sort of generic or some other depiction other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with Your Honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
The objection sustained.
Could we, with Your Honor's permission, publish simply Mr. O'Keefe's
Yes.
gastric mucosa?
Yes.
He published what seems to be a demonstrative exhibit that is not in evidence, whether it's from a medical text or what have you. It is not in evidence, and it is not the victims. They might be able to bring that in with their expert, but there's no foundation with this expert. This expert is like, I know what that's a photo of, but they don't know where it comes from. And now they are going to get into the photos.
Isn't it correct,
of
Dr.
John
Scordi-Bello,
O'Keefe's
that there are
stomach.
much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic
the example.
stomach. Is that correct?
That is correct.
But it
So,
sounds like fewer means
You can take that.
still present. Fewer doesn't mean not present. Fewer means fewer.
Down, Mr. Wolf. Isn't it correct that for hypothermia
They are really attacking.
in the presence
The
of
hypothermia.
Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers.
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Liz, I had to take mine out of
Not
my
always.
office.
I have seen that. I have also seen cases with much fewer
Right.
spots, as you refer to them.
But isn't the majority of the cases
Fewer.
that you have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach?
Yes.
And what percentage
Yeah, Dylan,
of
Yes, I'm checking
the,
Ryan
and I'm
Hollowell's
trying to
feed.
avoid putting it up
100%.
again. So what percentage of the gastric
Don't worry, y'all.
mucosa of
I'm checking my
Mr.
weather,
O'Keefe
too.
would you estimate is taken up by the ulcers that you have identified?
And I think our area
I would
is
say
pretty
somewhere
good.
between 10, 15%.
Just 10 and 15%. Thank you. Now, if we could
We're going to get into this again.
look to the issue
Yeah, it was
of
no, it was me with Ryan. It wasn't you.
continuing with hypothermia.
We're going to get into this again with the defense's expert because they are attacking the hypothermia.
Do you note any evidence of frostbite on the
No, it was me. It was me.
facility?
No, I did not.
Do you know what the weather conditions were in Canton, New York? On the early mornings? I'm sorry, you said Canton, New York.
I feel like 7 people in the courtroom just said Massachusetts at the same time. Alessi is an attorney from New York. I think if one of the other attorneys on the team had done it, people would have been less inclined to chuckle. But he absolutely said Canton, New York. Look, man, it's hard. Just like it's hard for Brennan to not ask leading questions, it's hard for Alessi to not be in New York.
Do you know what the weather conditions were in Canton, New York on the early mornings? I'm sorry, you said Canton, New York. My apologies. Do you know the weather conditions in Canton, Massachusetts, starting at midnight on January 29th,
I bet that's a big old negative Ghost Rider.
going through 6 a.m. on January 29th, 2022?
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusting winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusting winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean
I think they're
that
going to
the
get to that.
wind combined with the temperature brings the actual temperature down, and in addition to bringing it down,
Brings
a temperature
how it
wind
feels
chill
down. It doesn't bring the
calculation,
temperature down. It
It
brings
also has
how cold
a
it feels down.
physical effect on the body, correct? Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
Correct.
Synergizes and
with
exasperates in one sentence.
Wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
I don't know if she knows that.
Yes.
Oh,
So,
I'm surprised by that.
you saw no signs of frostbite on Mr.
Sir,
O'Keefe,
okay.
correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So at the only time you examined him, which is at the time of autopsy,
He's
you had zero
illustrating
signs of
for the
frostbite,
jury that
correct?
this is important to kind of wake them back up.
Dr. Scordi-Bello,
Yes.
now that you have gone through your this part of your examination here today, would you like to amend in any way your
I was wondering if he was going to ask this question.
opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
Yes. That's why it is a contributing cause.
I'd like to move to another topic area, please.
Oh, okay. I thought that was going to be one of his last questions.
You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
That is the question. That is the question.
Injuries.
I'm going to back that up one more time. Because this is where I feel like he should be more illustrative, but we will have a conversation about why the defense is attacking hypothermia later when we talk more about count 2. The hypothermia consideration, I think the defense is attacking it because of count 2 and because the jurors were undecided on count 2 at the first trial, and it seemed like more of them were leaning towards guilt on count 2 than not guilty. So that is why they are laying that groundwork.
In your autopsy in any fashion, any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
In fact,
Not in her report.
there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Sustained.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries
There's a different way to
consistent
go about
with
that.
a motor vehicle accident?
I'll allow that.
There's a different way to ask that, but
Yes, I did examine his
Should have
lower
had-
extremities.
should
That
have
is
had that info.
protocol in any case of suspected impact with a motor vehicle.
Right.
So I did examine his legs, and I did not see any evidence of an impact site.
And could you elaborate to the jury what you mean by no evidence of an impact site?
I'm going to sustain that objection.
why?
What do you mean in your answer?
That's what she said.
No evidence of impact injuries.
Oh, she didn't. She said, I did not
I'll
see
allow that.
evidence of an impact site.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
The phrasing of the question was the issue. I am the real Murph asked, who's coughing? It's in court.
I'd like to turn to, please, the
This gets into
case of
the,
the decedent in your analysis that you discussed on
Undetermined.
direct examination
so did
of
you
that area
look
of
at
the
motor
decedent.
vehicle? Did you consider it? She was given that information.
You talked about ecchymosis, you recall that?
Yes.
In medical literature, there's a synonym for ecchymosis. It's sometimes
He's leaving this for the end of cross because it is after lunch and he wants to leave the jury with this information rather than it getting lost in the middle of all the other medical testimony he needs for his expert. So this is where we put the important stuff at the end. You put the stuff that the jury's going to kind of check out of in the middle.
referred to as raccoon eyes. Is that correct?
Correct.
Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
I mean, what?
Ecchymosis does not cause a laceration to a nose, does
That's
it?
not even what it means.
There was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
These are
Correct.
odd questions.
Did your report at all evaluate
I mean,
whether there was any significance of
the-
the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain from that impact to the back of the head.
the impact to the back of the head is not going to.
Correct.
Right. However, the brain injury, well, it's not going to account for the lacerations. But the brain injury is going to account for some of the other
So
injuries
if we
seen.
could, Mr. Wolk, and with your Honor's
They're gonna show
permission,
that to the
publish
jury
which
again?
is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid. And Dr. Scordi-Bello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it did. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question.
Okay.
Can you state your answer again? Oh, let me read that injury
Ask the
to
answer
the right
again.
eyelid,
Ask the
that
question again.
laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor.
No. Someone just walked up to him. It looks like Jackson. Carly T said, how
Yeah,
did the
Coach,
feds
Your
get
Honor.
information that the defense did? Oh, they're approaching. I don't know why. How did the feds get information that the defense did not get until now? It's a really good time. Is there?
erroneously assumed that that picture was.
Oh, something's going on. We're gonna back that up in just a second. How did the feds get information the defense did not have? The defense is reliant on discovery and their own subpoena powers. There is only so much they can get. The feds are the feds, and there's a lot more they can get due to federal subpoena, but they don't have to loop in the defense in this case. So the feds discovery process is separate from the state discovery process, and the government gets their discovery and turns it over to the defense. The government in this case, the Commonwealth, didn't have it either. The feds had it, but the parties in this case didn't have it. The feds can get just about anything. They are the feds, and they are not really reliant on what the state does. So Jackson approached Alessi. Alessi approached the court. Let's see what happens.
May I approach, Your Honor?
Yes. Show Mr. Brennan.
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation if I could.
Okay.
Dr. Scordi-Bello, you see what's in front of you.
So that photo's not in evidence yet.
Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in here.
Thank you, Your Honor. The judge is like, Brennan, any objection? No, great. You're not objecting, right, Brennan? These are the autopsy photos. Perfect. Let's move on.
65.
So we got to the court just saying, Brennan, can we just? I'm going to zoom while they're marking that into evidence.
Dr. Scordi-Bello, I place before you what is in evidence now is 165. And Your Honor, may I have Mr. Wolk publish 165? Thank you, Mr. Wolk.
It's like, yes, we can, yes. Oh, dear.
Dr.
Okay.
Scordi-Bello,
lose
that
the hair.
laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that injury, you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt impact.
Blunt impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
She can answer that.
Could be consistent.
Right, it can happen. You can
If we
split skin by getting
could
punched in the
Mr.
face.
Woke have the laceration
skin
to
by-
the nose.
Well, a lot of things.
I'm sorry. Hold off on a moment.
I'm going to zoom as they are figuring out what they're doing.
Your Honor, Mr. Brennan has agreed to stipulate this going.
Okay, so like we can mark it.
We've stipulated to whatever other photos they want to bring in, and I appreciate that. These attorneys do seem to work well together in the process of handling things. They do not argue over things that don't need to be argued about.
Dr. Scordi-Bello, I have put before you what is in evidence
Especially
is
when it's
166, and Your
coming to
Honor may,
foundation and things like that.
Mr. Wolf publish.
Yes.
Thank you.
I am. The glass is also a real question here. What about the broken glass at the crime scene? And I imagine that after this witness testifies, we're going to see a clip of Karen Read in court saying, I saw John's face and I picked a piece of glass from the side of his nose because she said it in, I think, the last Discovery ID series. And she talked about picking a piece of glass off of his nose. And so I think that's the direction the Commonwealth is going to go with that. And I think we'll probably see that clip after this witness.
Dr. Scordi-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
Well, an abrasion and a laceration aren't the same thing.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
Right, and that's the point.
You can take that down, Mr. Wolf.
I'm just
On
gonna,
your direct testimony, you talked about
I'm going to start zooming
injuries to
the pauses
the
between
right
questions
arm
at some
of
point.
Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
Correct.
That's correct.
With Your Honor's permission, I would like to,
You asked this a lot, though. Is there much new ground to tread with these questions? At some point. Because you were going in a real good direction with other causes, with the eyelid. But.
Yes.
He's asking to mark it as next. All right. They are marking that.
But I'm also going to waive the court's permission.
I zoom past them marking that. Now they're publishing it.
Just allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you. With regard to what is on the screen, am I correct that you noted these injuries to and these wounds to Mr.
And then they're
O'Keefe
showing
in your
the injuries
autopsy
to
report?
John O'Keefe's
Yes.
arm. This is
And
a
am
more
I correct
redacted.
that you noted that there
more
was
redacted
a
photo.
pattern to those wounds?
Correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based
I don't
on
think
our
he
answers to
laid
the last
foundation
question,
for that.
Something else.
Yeah, I don't think he laid foundation for that.
Ask another question, sustained.
I don't think Alessi heard the court's response. And
Can you
there's no foundation for
identify
that at this
any
point.
cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So, can you answer that, Doctor?
I cannot.
It's out. She said she did not determine a cause of those
You can take
injuries.
that down, Mr.
And then he
Wolf.
said,
Thank
were
you.
they caused by a dog bite? She just said, I did not
Do you
determine a
recall
cause.
discussing
And then he would have to back
at
up and lay
all
more
on your direct
foundation.
examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So,
I don't think she evaluated any of the clothes.
were you aware that there was clothing associated with Mr. O'Keefe when he
She probably assumed that the victim had clothes
started
on.
the autopsy?
He did not have any clothing
With him.
that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
To law enforcement.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
Asked and answered.
No?
That's not unusual. I'm going to zoom past the dead air.
You were unable to reach a determination as to the manner of death of Mr.
Asked and
O'Keefe,
answered.
correct?
That is correct.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those
I
doubts
think
reasonable?
she would say there's multiple
Sustained.
possibilities. He can't ask it that way. He knows he can't ask it
You
that
were
way.
not-
He has to ask, so there were multiple possibilities and you were unable to pick between the possibilities. He can't say, so you had a reasonable doubt. Sir, you know that.
Not able to reach a determination as to the manner
Multiple
of
reasonable
death
possibilities.
of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed.
I'm sustaining it, asked and answered.
Thank you for answering my
And
questions.
that's Alessi.
Dr. Scordi-Bello.
You're welcome.
You can't just give up and end on a sustained objection. There are other ways to ask it. He's just like, okay, fine. All right. It's time for redirect.
All right, thank you, Mr. Alessi, Mr. Brennan.
I'm going to put this at 1.25 until Brennan starts asking questions because he speaks pretty quickly and loudly at the beginning of his redirect. And we're getting to redirect. I want to see if that picture comes up.
Doctor, how many autopsies have you performed in your professional career?
Yeah, let me back this back down to
At
normal.
this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances.
Not
If
always.
the person comes directly from their residence, they may or may not be clothed.
But coming
If the
from
person
medical?
comes from
Hospital?
a hospital where they went first for treatment, many times the person is unclothed. They may be wearing a hospital gown, but in most cases that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained is to the floor.
Is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on. Or ask it.
He can ask that. It came up numerous times. Brennan can ask that.
You were asked questions
Brennan can ask that. I don't think it was leading.
About
because it asks
your
her an open-ended question. Does this normally happen?
opinions
The
relative
answer is either yes
to
or no. But it doesn't assume the answer.
spots
And the court's like, move on.
in the organs of Mr. O'Keefe. And you were asked
he did.
about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes.
Is it important to have a complete statement rather than just part of a statement?
Yes.
And when you were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
I remember it was a long time ago,
Okay.
but I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question.
Yes.
And he read part to you, right? I understand your question, and my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
The doctor can answer that.
Do you remember Attorney Alessi read you that part of your statement?
Yes.
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context,
Sir.
I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained.
Yeah, you can't do it that way. You have to refresh her recollection. You're not impeaching her. Ma'am, do you remember the rest of your statement?
Actually, take a look at
No. Would it refresh your recollection to review the transcript? Yes.
part of your
And
answer back.
then you can ask.
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go from there.
Yeah. He's just doing that the wrong way round.
I can approach.
I backed up because he was talking as I was talking.
Actually, take a look at part of your grand jury testimony. Do you remember Attorney Alessi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go from there.
Alessi, I think, is more indignant,
Ask about your entire answer or just part?
more indignant,
Objection, Your Honor.
Sustained.
You can read the rest of
more indignant for the name being mispronounced because no other attorney sounds more put out when they object than Alessi.
You ask about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
You can read the rest of the answer that you weren't given.
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
You now remember there was more to your
The court said to Brennan, this is phrased as refreshing recollection, so address it appropriately, and told him to ask the right questions.
Yes.
Could you share with us the rest of your answer?
Without
Objection,
reading
Your
it.
Honor.
Without reading it. Turn the paper over, please.
Brennan, do you need a Snickers? There's a way to do this. It's not what you're doing. Alessi's not going to stop objecting. 3 questions, Brennan. Sir.
Ask the appropriate questions, Brennan.
The court asked the appropriate question.
remember the part that
Mr.
was left
Brennan.
out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages, in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of
It's argument.
2 individuals that were in the room at the time of autopsy. Do you remember?
Photo. So for everyone who's like, Emily, what the fuck is just going on? Brennan is just approaching what he's trying to do completely the wrong way round and not asking the proper questions. He's not trying to impeach this witness, which is what he is used to doing with transcripts. He is trying to refresh this witness's recollection. It is a multi-step process. You are allowed on redirect to let the witness complete their answer. On cross, the answers are constrained. Redirect is to allow them to explain if anything needs to be explained. But you can't just read in the transcript and be like, you said this, right? Yes. No. You have to refresh their recollection and then allow the witness to explain the rest of their answer, which can generally be, do you remember the rest of what you said to the grand jury? Yes or no? No? Would it refresh your recollection to your complete statement to see the transcript? Yes or no? Yes. Then you get into what is the explanation or the rest of the explanation or whatever to allow them to then explain the answer. So when the defense asks you this, do you mean this, that, and let them explain. And that's where everybody was getting tripped up in that, because Brennan just needed to slow down, back up, and ask them more questions, which if you're used to doing cross-examination, you don't have to. This is not cross-examination, and unless he's not going to let him just do whatever. Now we're getting in to the multiple people at the autopsy, and I'm very curious about this. But yeah, sometimes it's hard when you're the one that has to do all the direct examinations. Huh, Brennan? It's a lot.
Context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of 2 individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were
So that was at the time of autopsy. There's the answer I have been curious about. 2 individuals that were in the room at the time of autopsy. I don't think it was that clear with the defense. I think it's been made very much more clear with the prosecution.
The FBI!
Oh, 2 individuals in the room at the time of autopsy.
room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names.
Correct.
You said that there would be a log identifying names.
Yeah.
Be a log. Yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
So, Mr. Alessi.
Oh boy, do we have the log? Do we have log? It's log. It's not that log. Do we have the log?
Can move on and we'll come back to it, Your Honor.
Damn it! Janet! What?
I can move on and we'll come back to it, Your Honor.
We want log. We want log. Bring us the log. We want to see the log. Where is the log? Don't move on. I shouldn't be allowed to stand desk. I'm just not contained when I'm standing up. We want the log.
Thank you, Mr. Brennan.
Come on.
You mentioned that Mr. O'Keefe's
Alessi
body
said
temperature
thank you,
was
Mr.
a
Brennan,
little
when
under
they said they'd come
81
back.
degrees when he was brought to the hospital.
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
So there was, is
Also
it fair
a
to say
band,
there was
correct,
over
ma'am?
an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
The body temperature?
Yes.
Objection, Your Honor. Scope.
No, it's within the.
Oh no, that's within the scope.
Basis.
Whether she has foundation for that information is a different question, but that's within the scope.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will
Interesting.
occur.
You were asked if there's any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Objection, Your Honor.
Sustained.
Was there any type of burns on his body that would suggest that he was put in some type of
What?
machine or environment where there was cooling, mechanical cooling?
Objection, Your Honor. Will the
Sustained.
approach-
Sustained. Move on, Mr. Brennan.
Brennan,
You were shown a photograph, a chalk that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
right. What in the
You
world,
were
Brennan?
asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
No, medical legal.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Okay. All right, Brennan.
A police
Oh,
Showing you a document.
I was trying to zoom, and then
That document?
I caught up.
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other
Among other
information,
things,
yes.
right.
How many lines is that police report?
11.
What's the date and time?
Really?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, all right?
Okay.
May I
The report, the initial report was 11 lines long
Yeah.
from January 29th.
May I approach her?
Yes.
1941 is the time.
Second document, is that another document in your file?
Yes.
And is that another report that you considered?
Yes.
How many lines is that report?
5.
They're going through the ME's file.
Is marked for identification, please?
Those are being marked as identification. I think they're going to the,
RR for identification?
I think they're getting to the lack of input from law
Go back to the
enforcement.
questions I asked you about logging in and refreshing your memory.
However,
I can hand you the document.
she also had
I
conversations.
actually read it aloud. I'm just going to ask you to look at it.
Oh, did you hear what he just said? Did you hear what he just said? Remember we were talking about the log? I don't know if this is the actual log, but he asked her to take a look at it.
Does it refresh your memory on the people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Coroner.
She said Mr. Keefe and Mr. Connor, but wasn't the trooper's name Connor Keefe? Isn't that the one name? I'm going to back that up and let her answer again.
Who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Coroner.
Mr. Keefe and Mr. Connor. His name is Connor Keefe. What is happening?
Are you part of the criminal investigation team?
That's a mess.
No, I am not.
Did you go to the scene and evaluate any?
Y'all, I'm not going to code red yet because that is a fuse that has been lit. When it goes boom, we will go to code red because I don't know if he wrote his name on 2 separate lines. There's more. There's just more. We don't know, but there's just more. So we will see.
Evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical
That's a
examiner
lot of questions.
in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You were never, well, let me ask you.
What is happening?
You
Real
submitted
interested to hear
the
recalls.
death certificate on April 14th.
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or
Is
filed
it-
your death certificate.
Is it relevant then?
Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant
I'm going to allow it.
that the defendant said, I hit him, I hit him, I hit him. Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin?
See, Brennan, what's going to be really interesting about this line of questioning is that it seems that she considered these things and did not find it persuasive. So asking her, did you know I hit him, I hit him, I hit him? And she's like, I was aware. Okay, well, it didn't change her mind about the undetermined. So if you list out your whole case for the coroner, who I imagine the jury likes, and you list it all out and say, were you aware of all of this? And she says, yes, I was aware of all of this. And then still came with the undetermined finding, it's not going to help. It's not going to help because she's aware.
Who provided information?
Bold strategy.
That the defendant said,
Brennan?
I hit him.
Let's see how it works out for
Yes.
you.
Were you aware of statements made by the defendant, to Miss McCabe, that she said, may have I hit him? Did I hit him?
Objection, may we approach, please, briefly?
Oh no, Alessi, let him pick up that shovel and keep digging. However, I think Brennan just misstated testimony, but let him pick up that shovel and just keep, I don't think that's going to go well for him. I do think he misstated testimony twice, but yeah, he should know where this is going to go, and it's not going to go anywhere helpful for him. But he did misstate the testimony. If he is saying, were you aware of a piece of testimony? He has to cite it perfectly. Not kinda, not sorta, like dead ass verbatim. Emily, are we just Gen Z in court? I mean, I have a 13-year-old. What do you want me to do? There's only so much one can do.
So, jurors, I want to let you know that, like other evidence that was let in.
Oh, and they asked for an
previously,
instruction, and she gave
this
it.
is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scordi-Bello's knowledge and state of mind at the time of her report.
And they got, the defense got an instruction reminding the jury
At
that
the
this is not to
time-
prove it for the truth of the matter, but this is, were you aware? I think this is not going to go the way he anticipates it.
Of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders,
Back to the
reported
house of
that
cards
she had hit
posing.
him? Did you know that?
I was aware of that information later on.
And
Were
it
you
still didn't
aware
change your mind.
of the investigation regarding alcohol consumption?
Yes,
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
about their,
Their observations?
yes,
Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware that Mr. Whitley told the police that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given, yes.
Right, she knew
Were
that.
you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware
Oh,
of
Brennan.
statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead,
Yeah, I was given.
She
that
was aware.
information.
and the questions of did I hit him? Were you aware of that?
Yes,
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
yes,
Were you aware of the statements that she made to the troopers?
Not in detail.
But generally.
Were you aware that when they spoke to her on January 29th,
Oh, y'all, this is a very relevant line of questioning. I see a
informed-
lot of you saying, why is he doing this? This is a very relevant line of questioning. I just think it's going to blow up in his face. That's where I'm at, and I'm going to keep watching it happen. But the defense said you were undetermined because you couldn't, there were multiple possibilities and you couldn't pick one. And the prosecution is saying, but did you know this? And she's like, yeah. Well, but did you know this? Yeah. Well, but did you know this? Yeah. Well, what about this? Yeah. If she knew all of this at the time that she wrote her death certificate and still came back undetermined, I think it is worse for him. But I'm surprised that he didn't think that this line of questioning wasn't going to help. Now, if the defense was asking this line of questioning, I'd be like, well, it makes sense. What did you base your undetermined on? Fair. But the prosecutor's like, did you know all these facts of our case? And she's like, yes. Confidently, yes.
that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honors.
I'll allow that.
What did she know?
Yes, I was provided with that information.
I was aware.
Were you provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed relative to the broken right taillight she didn't know how it happened?
Yes, I was.
Was aware.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it?
Probably wasn't aware of that.
Not aware of that until much, much later.
After you filed your report?
Correct.
Were you aware
report she can
of
amend at any
location
time?
data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware
She
of
became aware
battery
later.
temperature
The defense
data
is
on
gonna ask
Mr.
about
O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
And would
No.
any of that have changed your mind? Because she
Were you
learned about
aware
some of this later.
statements from the
Did
defendant
not change
to
her
various
mind.
media outlets before you filed your death certificate?
No, I was not.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No.
Did anybody ever provide you any of this additional information you weren't aware of at the time, ask you to evaluate it, and then reconsider your finding?
No.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs either frontal or rear impacts?
Objection, Your Honor.
I'll allow that.
Oh, no,
I'll allow that.
that's not outside the scope.
Most pedestrian fatalities that we see are with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most that they see that result in fatalities
Most
is what she
collisions
said.
involve frontal impact, yes.
How about cases where you've had an opportunity to observe people who sustained injuries from being clipped? Not hit, but just being clipped. Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
Okay. How about a side swipe?
I'm waiting for her to be like, well,
Injury. Is
would
that
it be a
different?
fatality?
relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee.
She didn't say there was a
consistent
bruise
with
on the
a
knee.
Side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
Really?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that point.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration,
Yes,
and you offered that was not consistent with falling backwards on the head alone.
She said it wasn't caused
Correct.
by that.
You were asked if
alone.
that was consistent with a punch.
No, she wasn't.
Correct.
She was asked about the face. No, she was asked about
That's
the.
not the testimony.
That
That's
is-
your objection.
That is, Your Honor.
The court said that's not the testimony. The objection was misstates facts and evidence, and it does. That was not the testimony. The testimony about the nose was not about being punched. That was about the laceration on the eyelid.
Did you provide an opinion that it could be consistent with a punch?
No.
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
Do you have any firsthand knowledge of how the laceration on the nose happened?
I do not have firsthand knowledge.
Okay, back to the nose.
Did you know at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around 5:45 p.m.
I
on
bet she
January
was
29,
aware.
2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr. Alessi.
Yeah, I bet Alessi's got some questions.
Thank you, Your Honor.
Oh boy. Did any of that change your mind? You knew a whole bunch of shit.
Dr. Scordi-Bello, this Attorney Brennan just asked you questions about
undetermined.
alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those
She
records
said
at
that-
some point prior to
There
issuing
was
my report, yes.
None.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
I'm going to allow it. Is in
I think it's
connection with
outside the
alcohol
scope.
too, you said, right?
Correct, Your
Go right
Honor.
ahead.
He said it's correct, Your Honor. The court does not agree that it's outside the scope. The court's going to allow Alessi to go down that path as it relates to alcohol, because she testified that
Yes.
he didn't have any medication in his system, but would she have had the
Yes.
list of
Dr.
medications
Scordi-Bello,
he was prescribed? Yes.
Yes.
Dr. Scordi-Bello, I am providing you with a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes,
And that medication is,
it's an antacid.
right, and so omeprazole is The trade name of omeprazole, Pepsid,
I believe so.
and Pepsid is a proton pump inhibitor.
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
She's just smiling.
And we're going to come back to that in just a moment. But
I think
do
that's
you
outside the
also
scope, but the court's allowing him to
recall
do it.
Testifying
He could have done that in
at the grand jury
Ross.
with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe.
I do remember testifying, yes.
And do you recall
He was
what
so excited
your
to talk about
testimony
proton pump
was
inhibitors.
with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
That's where he's going.
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Is that right? But also, totality of the circumstance is what she was going with. But the defense is
Attorney
going
Brennan
with doubt.
asked you
right?
questions moments ago, and actually several of them, of which included the words, did I hit him, could I hit him? Do you recall those questions?
This part.
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
And it
So-
didn't change your mind. Did you hear how excited he is?
Even though
But that didn't change your
you
mind.
had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Scordi-Bello.
All right.
Right.
Doctor, you are all set.
You knew
You're not
all of
going to
this
see counsel
information.
sidebar.
You knew all of this information, and yet you still came back with undetermined. They kept that recross very, very simple, and I think that was 100% the right call. Alessi was like, other possibilities for the ulceration at the stomach. She said there was a totality of the circumstances, but also you knew all of this. And you were unable to determine the cause of death. And at some point in the closing, we're going to hear one of the defense attorneys say, look, ladies and gentlemen, even the coroner had all of this information and was unable to determine, oh, I wonder if court's almost done for the day, was unable to determine the cause of death. And I just say that because the media is all giving back their passes for the day. The bailiff's coming around and collecting everything. They're at sidebar again. Oh, I bet they're done.
Be very careful with your social media.
And we're done for the day. Yep. And we're done for the day.
All right, so jurors, that is it for today. I'm told that we are on schedule. So with that, I'm going to let you go a few minutes early. So please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful with your social media use. So we'll see you tomorrow morning.
All right. Well, Alessi's cross ended on kind of a womp-womp. But Alessi's recross at the end of the day ended on a 1-2. So it definitely makes up for the womp-womp moment at the end of his cross-examination. I'm going to just make sure they don't go back on the record because there's a lot of time for them. But there's time left. They really left cross on a couple sustained objections, but that the end of the recross is what the jury's walking away with, which is the coroner knew everything that the jury now knows and still couldn't make a determination.
You may be seated.
All right, we're going back on the record.
All right, so Mr. Alessi, I'll hear you.
What's going on? Y'all are going to ask me what's going on. I don't know. But I'm real curious about the autopsy and the log. That's some real new information.
I'll hear you, Mr. Alessi.
Thank you, Your Honor.
Your Honor, what the fuck is this log? Oh, Emily, just let it play. What the fuck is this log?
The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So,
This is regarding the Commonwealth experts.
Has established in reports right up until not established. They have stated in the reports of Aperture, particularly the slide presentation of Dr.
Chat, bear with me. I'm going to try to gain this up since he is away from the mic. Just give me 1 second. See if I can do that while we are all here together. I just have to pull up that. Let's see if this works.
Dr. Welcher.
There we go.
A trigger called 1162.2 that they have associated in
Back
the
to
report
keystroke
of
logging.
Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12:31:38 to 12:31:43. And we have been...
I ran out of room on my notes, and he went right past it, so I'm going to back up because he is talking about information that is coming from the accident reconstruction firm for the Commonwealth and what information they gave and the trigger event for the vehicle and the time of the trigger event.
With a specific time. And that specific time that they have associated with that trigger is 12:31:38 to 12:31:43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the
we're going to find out what his issue is
in the slide. And so
soon.
We have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA.
Oh boy.
Based upon that time period.
Oh boy.
On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. Now, I'm just going to give it.
Dude,
So,
don't interrupt him while he's talking, man.
Although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and
that's
he is now
time?
stating that that infotainment trigger of 11:62:2 is further back in time, and it is past 12:31:43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12:32:16. And
Oh,
Your Honor may recall 16.
1232:16.
It is 12:32:16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen.
Right.
He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 1231.38 to 1231.43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to
oh boy.
To evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed,
is
to, quote, align the trigger with Mr. Whiffen's analysis. And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago.
Right, they had this.
And the data from that
forever.
has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation.
But what are you asking for?
Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's
the tech is ambushing me right now, and of course he had to say it 3 times. And the tech, have we been ambushed by the tech? Yes. Yes. Of course he said it 3 times. And bravo, bravo, fucking bravo. Alessi is in court saying bravo, bravo, fucking bravo. And he is not, chat, everyone who's saying mistrial, calm down. He is not asking for a mistrial yet. We will see what he says. He is asking for the report to be stricken. And he is trying not to be hyperbolic. Sometimes he's hyperbolic. All right, let's.
Our first request is that the
The end of court is getting spicy.
8th report that we received on May 11th
Is to strike that report.
not allowed, that it
Chat will explain when we're done.
be
This is wild.
not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it.
He's mad.
And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its, the information of Aperture that has been extant before the
Back to
May 8th
extant.
date of the report. Thank you.
All right. Do you
Brennan?
have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCA because 2 reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right.
have
So-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion in a Rule 14 violation.
And you're not waiving that.
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARCA.
All right, so tomorrow morning, let me know that. All right,
I think she's cutting him off because she doesn't
And-
disagree
and,
with him.
Your Honor,
he's asking for a continuance. They don't want to
I will do
dismiss.
that, of
They don't want a
course.
mistrial.
And
I mean,
will
they would take a
also
dismissal,
say,
but that's not going to
without
happen.
getting into an elaboration
He wants
of
a
it,
continuance.
we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen.
You guys,
I
you guys
had my
forget
whole
the last time that Alessi got cut off, the court was like, yes, I'm on your side. Tell me what you are asking for. And I think that's where the court is with this. Tell me what you are asking for. I want to know specifically, what are you asking for? I'm going to let him finish because the court has asked, what are you asking for? They are not asking for a mistrial at this point. They don't want a mistrial. She is not going to give them a dismissal on this. Their options that he is asking for is that the new report not be allowed or they get a continuance to work with their experts. So let's continue on. Yikes,
Honor,
yikes, yikes.
I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you
Right.
an example. Mr. Whiffen.
That's an issue.
I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen.
About the timeline.
Based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence.
Right. Because if John O'Keefe is clicking his phone off and on after that time, it creates a timeline conflict. And that is why he crossed Whiffen the way he did. And what do? Bring Whiffen back? Oh boy.
Now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you. Mr. Brennan.
And
This
Brennan.
disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second.
But if it was in your opening, then were you aware of it when you opened? Because that was way before May 8th. Just asking.
Sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance.
They're allowed to do that.
That these times would never align. And that's what he did. He studied the data, he studied the ways, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition, on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moment when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text stream data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong.
He's saying it's essentially a rebuttal.
And it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
Case in chief. My case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said he referenced Mr. DeSorbo, who is a defense witness.
Mr. DeSorbo, the defense witness.
Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within the reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Wow.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because
He asked his
Mr.
expert
Burgess
to go back and
supposedly
look at
is
it.
responding to that. That was months ago. The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A.
Okay.
So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All right, I thought Burgess was, no?
No, neither.
Okay.
No one from
Everybody
Aperture
should know.
was.
Yeah, I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded
Neither
familiar.
Burgess nor Welcher were part
Okay.
of the first trial, but they were retained. Aperture was retained.
We're not
I
going to get an
believe
answer to this today, y'all. That
in
is-
October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in
no,
his
Alessi,
original-
no. Damn it, Alessi, no. The whole chat needs a break for a moment. It is not commonly referred to as variance of time. It is commonly referred to as wibbly wobbly, timey-wimey, and we will accept nothing less. Alessi is so frustrated, and they are fighting over the Commonwealth's new time based on the fact that clocks are different. So the defense is not asking for a mistrial. We'll talk about it. There are very specific reasons they're not asking for a mistrial. They are asking for either a continuance, which means we're taking a couple of days, the jury goes home and court is dark, or for this not to be allowed in. The court is not going to decide this today. The court is not going to decide this today. But is this shit popping off mid-trial? Yeah. Are we surprised? No. Is Alessi mad? 100%. 100% mad. He's like, their experts knew about this. And the Commonwealth said, no, our experts are responding to their experts. And they said, our experts are responding to your experts. So if our experts basing our information off of your experts' information, then you already had it.
Report months ago has a whole section on clock.
He's now clapping. We got to get back to wibbly wobbly, timey wimey.
To provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay, so what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, The last point I
people
wanted
she
to make,
meets
and I
court
think I
staff.
heard Attorney Brennan correctly,
She's
is he
talking about
said
court
he
staff.
was surprised that he got this report dated May 8th. That's what I heard. So if the
he
Commonwealth
request
is
it?
surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it because they're surprised to.
It's a fetching reason to disallow them from using this report because even the Commonwealth was surprised. Your Honor, this report just came out of nowhere. They didn't know it was coming, so you should just, it is a fetching reason to just yeet. Just yeet. Your Honor, literally, we never get to say this literally. Your Honor, literally, the defense is asking you to make fetch happen. Just, it is a fetching reason. Please fetch. Okay, let's let him finish that whole sentence because he is completely on a roll with let's make fetch happen. And the court, it seems, is like, I understand the issue. She's not going to rule on this today, though.
That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that
to ARCA.
I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled the government's objection and has stated that it is going to allow the defense
Yep.
to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. We're going to allow them to testify, despite the fact that we have not had the time to review and to prepare and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Welcher. As you know, he was away. We did not get a report until maybe May 7th. We did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information.
Really?
Well beyond the simple four opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of the material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARCA witnesses. That's going to take time. You've heard from the ARCA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our experts
So everybody wants more
review all the
time.
materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin prep at the end of the weekend. There is no way he's going to be able to testify anytime
Oh,
soon
boy.
and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARCA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back
But then
and address
the defense
new
needs
issues, not the older
that.
issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The
So you don't want him to
unfair
be locked
prejudice
in.
cannot be cured in any other way. So we ask that he be able to
Oh, boy.
continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess's information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
All right. Mr. Alessi, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARCA and the information of ARCA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARCA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that. So
we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of aperture.
Just eating its tail at this point.
ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA.
Yeah, there's a voir dire.
When Dr. Rentschler was on the stand, or Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever,
May 7th.
and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going
She said the
to
prosecution will have to have their
continue
experts
to
review it.
address this matter as if the defense is making perpetual violations.
No.
There was a determination
No.
made, and
That's not
then the
what she
question
said.
was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing
That's
violations.
not what she said.
My final 2 points.
That's not what she said.
What
She said
Mr.
the Commonwealth
Brennan
would need time
is
to review
seeking
it.
is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things,
Let's see if I can.
have ARCA have to
There we
come
go.
on,
We couldn't
And
hear him
then
earlier,
have
and now we can hear him too much.
Aperture come back and essentially have almost a rebuttal to a rebuttal as of right.
Right.
I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal.
2 bites at the apple, right.
Surrebuttal to the defense. I believe, Your Honor, the final point is if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher.
Oh, no, they didn't
It's still
propose one.
open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's
They wanna
almost
bring
a
it in a rebuttal.
self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
He's getting all the
So
words in
I
there.
have a question for you, Mr. Alessi. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay.
That makes sense.
All right. I needed all this information now, so I appreciate it. All right. Thank you.
All rise.
Goodbye.
Y'all okay? First of all, we don't need the extreme OnlyFan close-up today. I don't know. Lawners, how you doing, everybody? Oh my goodness. Court just popped right off at the end of the day. Can you tell the attorneys are tired and emotions are high? Everybody feeling all right? Yikes. All right. Well, they are done with court for the day now, finally. That was a lot. Oh, everybody's pissed. Yikes. We're at the end of day 16. Let's try to summarize, because I thought we were just going to be summarizing the testimony from the coroner. Nay, because after the jury was dismissed just a few minutes early, well, the attorneys went back on the record to fight more over the experts and what is going to happen with the experts. And when Alessi started, it was regarding the Commonwealth's experts dropping a new report. That was the first issue. What's going on with the Commonwealth's experts and a new report that the Commonwealth says was turned over May 9th. The defense said they got it May 11th. That was the first issue. The second issue was, well, we're talking about experts, and can we talk about issues with experts without talking about ARCA? We're at bravo fucking bravo levels of drama in the courtroom talking about who will testify, when, what, and to how. And we did hear Alessi say at one point, ambush has been leveled against us. But what is happening with the Commonwealth? And the Commonwealth said not to level more disparities, but this is what's going on. And can ARCA be allowed to testify to all of their new stuff? And can't the Commonwealth split their expert is essentially what they were asking for, and to allow their expert more time to review all the new discovery from ARCA, which the court previously said the Commonwealth will be allowed time to let their expert review ARCA information. So let's start with ARCA first, and even though it was the second issue addressed, and then we will just jump back because time is wibbly wobbly and clocks lie. So with the ARCA issue, that was the second thing that the court took up. The Commonwealth was arguing that they have not had adequate time to review all the ARCA reports, that the ARCA reports are voluminous. They are many, many gigabytes. ARCA did their own experiments and their own new this and that. And the Commonwealth expert, and the Commonwealth has raised this numerous times, the Commonwealth expert needs more time to review and rebut all of ARCA's information. But what the Commonwealth suggested was, well, we got ARCA's information May 7th. Our expert has not been able to finish reviewing it. So if our expert testifies at the end of this week or the end of, or even into next week, we need our expert to be done reviewing ARCA's information before they're done testifying. And the court had said one of the things with ARCA getting all the information in is that the Commonwealth would need time to review. So what Brennan suggested was we should be able to split this witness. Bring this witness in, allow them to finish reviewing the ARCA evidence, and then bring them in as rebuttal as well. That is not going to fly with the defense, who said immediately, Your Honor, this remedy is not a remedy. The only reason ARCA was doing new information is because ARCA needed to rebut what the new experts for the Commonwealth had to say. Aperture. Yes. Are ARCA and Aperture too close to? Yes. The Commonwealth experts are Aperture, the defense experts are ARCA, and everyone's going like this. So the defense is arguing you can't let them split their testimony. They essentially are shifting the burden. That was the defense's argument. Your Honor, this is prejudicial to the defense. It is unfair because what you're suggesting is the Commonwealth expert testifies in their case in chief and then pauses. Then ARCA gets to testify. Their expert gets to keep reviewing things, and then their expert gets to testify again in rebuttal. The defense is not happy with that solution because they want all of the Commonwealth's information locked in before ARCA testifies so ARCA can rebut the Aperture testimony. But if the Aperture experts keep reviewing the ARCA information and then want to bring it up in rebuttal, Aperture can't have ARCA can't have Aperture's new rebuttal information to review so they can testify about it. So we are now in a complete circle of, well, we're just responding to them. Brennan again raised the fact that the court was allowing the late discovery from ARCA to come in and saying, Your Honor, we keep saying this is late discovery. They dropped a ton of late discovery on it. The court found a discovery violation as to the defense with regard to that, but said that the remedy was going to be to turn it over by May 7th and to allow for a voir dire. Did Brennan use his voir dire to ask about new opinions, new testing, and what ARCA was doing? No. He asked about signal chats and who had lunch with whom. That's what he asked about. Now, at the end, the court did cut him off at the end of his voir dire and was like, you're done. So he didn't even start down that path. So he had time, but ARCA wasn't done with their reports at the time that he did that voir dire. So the voir dire went into more communications than into determinations. So we are now in like a blue screen boot loop of whose experts are going to testify to what and how. So with regard to ARCA, the defense does not like the prosecution's suggestion that their expert testify, then ARCA testify, then their expert gets to go again. And the Commonwealth is arguing that their expert has not had time to review ARCA's information, which is a legitimate problem. The Commonwealth's expert should be able to review all of the defense expert information before they testify. And the timing on that got real close because it wasn't even turned over till trial was underway. And the court knew that was going to happen. The Commonwealth knew that was going to happen. The Commonwealth complained about it, and the court said, you're going to have to figure it out. You're just going to have to figure it out because it's really, we're not going to tell the defense that ARCA can't testify. But if they try to split the baby, it could create an unfair and undue burden for the defense. As I previously stated, do you see how we're in a loop? Because then the defense is like, well, if ARCA hasn't seen all their results, they can't address them. This is why there are discovery deadlines. So we're not doing this. Yet here we are. The first issue that came up was about the aperture experts for the Commonwealth and whether or not they changed the time of impact. And we're going to the notes because we are dealing in matters of seconds, and seconds matter. And Alessi, let me back this up. We're backing up the notes. We're backing up the notes until we get to the point. How many pages of notes did I take? A lot. Are we going to have to synthesize this more before tomorrow? Yes, 100%. When Alessi started, he talked about the aperture experts dropping a new report on them May 8th. If I previously said May 9th, I was incorrect. May 8th, the day after all the ARCA stuff came in, May 8th. But they say they did not get it until May 11th. The issue with that is that they are using those timing reports or the impact logs that are numbered. And those logs, they are corresponding to a time this testimony got very nuanced during trial number 1. But they are taking, I think it is the keystroke log number 11-622. And in previous reports from the Commonwealth's expert, they had pinned the time of that event to between 12:31:38 seconds and 12:31:43 seconds. And they said that was in slide 137 of the experts' disclosures to them. And remember, the defense already fought over these expert disclosures, saying there's 400 slides of all kinds of stuff, but no opinions. So the timing from that particular log, we're back to logs today, was between 12:31:38 and 12:31:43. The new report on May 8th shifts that time to 12:32:16. And the defense alleges that the new report indicates that the Commonwealth expert aperture is aligning, it's the exact words the defense used, aligning their time estimate to Ian Whiffin's testimony during this trial. And the defense brought up one of the numerous issues for them is that Ian Whiffin's already been cross-examined at length about time and the last time that John O'Keefe interacted with his phone, because the last time John O'Keefe interacted with his phone is incredibly relevant if the Commonwealth is arguing that he was struck between 12:31:38 and 12:31:43. If his phone is showing him still doing things after that time, the defense expert is going to say the injuries to John O'Keefe would have rendered him immediately unable to manipulate his phone or anything of the nature. That is what we expect to see from the defense experts. It's why the defense was getting into those questions today with the coroner, saying, with this injury, could someone have control of their hands, their arms? Would they have been moving, or would they have been rendered immediately unconscious and unable to have any bodily, volitional, intentional bodily movements? And Alessi argued our cross-examinations have been built very specifically around the reports that we have. And the reports that we have very specific timing. So to get a new report that now shifts the time from that 12:31 time to the 12:32:16 time to align with Whiffin's testimony, they say undermines everything that they've already done in this case. But the defense is not asking for this case to be a mistrial. Why? Because if they ask for a mistrial and the court grants it, this just starts over again. It doesn't resolve anything. They did not ask for the case to be dismissed. Do I think the court would do that at this point? Unlikely. And that's not what they asked for either. May they put together a motion in writing and ask for that between here and tomorrow or the end of the week? They may. They very well may. But they haven't yet. What Alessi asked for was more time or to exclude the new report. And then Brennan got up and said, Your Honor, wibbly wobbly, timey wimey. No, he didn't. No one said wibbly wobbly, timey wimey except for me because they are very serious and they are in court. But God, today was a lot. So Brennan got up and said, But Your Honor, this isn't new information. I said in my opening that there were different clocks and the clocks were wrong. The clock on Waze versus the clock on the cell phone versus the clock on the Lexus, the clocks are wrong. And our expert, Aperture, reviewed their expert, who the closed captioning just calling Mr. Disorder, and I think that is hilarious, but I think it's Mr. Disorba. Brian Sorbo, I don't know. I'm going with Mr. Disorder because that's what closed captioning just kept saying. And I think the court at one point actually said, Mr. Disorder? I don't know. But that is a defense report. So the Commonwealth said, our expert looked at their expert report and found that their expert was wrong and then shifted their report. The defense is saying, this is preposterous, not their words, mine, because the Commonwealth has known about the issue with the clocks for at least 6 months. Though I remember this issue about the 3 clocks inside an iPhone coming up in the scientific testimony in the first trial. When we were talking about the timestamps of thing, it was what memory used what clock. It might not have come up specifically to this issue and to John O'Keefe's phone, but the issue of the clocks potentially having, Tokyo drifted in time did come up in the first trial. So the defense's argument is this isn't new. This isn't new information. And the Commonwealth did not give us this information before trial started, and they should be precluded from using that information. And the court asked, what is the other option if we don't preclude it? And the defense said a continuance. We need more time. What would a continuance look like? It would look like more dark days in court where they are not in court. And the jury is like, hey, come back in a week. Hey, we're going to take a week off. Do I think the court's going to give them a week-long continuance? Probably not. Could the court exclude it? They could. Would the Commonwealth lose their minds? Yes. What is the result that is least likely to result in an appeal if there is a conviction is one of the things that the court is going to look at. And the result that least likely becomes a problem on appeal if there is a conviction in this case is to disallow the Commonwealth from using the updated report to tell the Commonwealth that they can call their expert at the very end of their testimony and not allow them to split their expert testimony regarding ARCA, or to give a brief continuance, maybe a long weekend, like a Friday and a Monday off, to allow the experts to get caught up if they could do that. Those are the least problematic for appellate issues results. But the defense might ask for more. They might write up motions and ask for more. This just came up today. It's May 15th. The defense has had this report, they say, since May 11th and have not brought this up yet, but we are getting closer and closer to these experts testifying. The defense also confirmed in court that their defense they expect will be about a week and a half, all things depending, and that ARCA will testify towards the end of that. I think the court asked that question to attempt to gauge how much time the prosecution might need. Because if the court keeps out the issue of the clocks and the drifting clocks, then that is separate and apart from the Commonwealth's expert having a right to review ARCA's new reports. And the Commonwealth's expert does have a right to review those reports, and they knew timing was going to be crunched on that. But they're probably just going to get crunched on that. And if their expert is unavailable, that is going to be unfortunate, but their expert is going to have to find a way to either review those or not. So the court may well give a little bit of time for that. Or, could the court allow the Commonwealth's expert to testify after ARCA? Not in its entirety, I don't think. you can, because that's not the way that the order of evidence is supposed to come in. This is not the end we're going to hear from it. The court did not rule from the bench. The court said at one point, this is the information that we needed, but the Commonwealth is in a pickle as to ARCA. They do have a lot of information that their expert needs to review. There are reciprocal discovery deadlines for a reason, but the Commonwealth is going to have to sort it out. The court might give them a little more time. That's a different issue. The new report, when the defense has already cross-examined numerous witnesses on the timeline that the Commonwealth has provided, is a issue for the defense that is at the Commonwealth's hands. And I think the easiest result for the court is to exclude it. We'll see what the court decides to do with that. I don't know if the court will give a continuance, because a continuance doesn't fix the fact that the defense has been doing cross-examination based off of the reports that they had. A continuance can't fix that. So I won't be too surprised if the court agrees with the defense on that report or decides to ask a few more questions about why that wasn't done sooner. Because as Mr. Alessi pointed out, the Commonwealth also said that they were surprised to receive that report as well. Well, if you're being surprised by your own expert, then did you ask your expert to do something? Did you know they were going to make a new report? It's going to be interesting to see what the court does. Is all of this going to get resolved like tomorrow? Probably not. No, probably not. And in all of that, we didn't even get to the end or talk about the end of the coroner's testimony, because the end of the coroner's testimony, I think, was a real interesting choice on the part of the prosecution. And you know what? We'll fix it in post. We'll put this part first and put the explosive stuff at the end. It'll be fine. We'll figure out a new order. Watch the case briefs to see what order we decided to put this all in. And if I have to sit down and record something else because I think about this more, because that's possible today, because Lord, that was a lot of information. At the end of the coroner's testimony today, in redirect, the prosecution went down a line of questioning that really was maybe not the best strategic choice. They started asking the coroner, did you know that all these individuals said that Karen Read said, I hit him, I hit him, I hit him? Did you know that Karen Read said she didn't know how she cracked her taillight? Did you know that people were drinking? Did you know? Did you know? Did you know? And for most of the responses, the coroner said, yes, I was aware of that information. There were very few things that the coroner said, no, I was not aware of. And those involved media reports that Karen Read had given after the fact, etc. So it just set up the easiest layup for Mr. Alessi when he got to recross to just say, so you knew I hit him, I hit him. You knew what Karen Read said. You knew that that she mentioned her taillight had been broken. You knew all of this. And your finding was still undetermined, which is why I was so surprised that the Commonwealth just laid up that line of questioning, because the Commonwealth essentially laid out almost their entire case for the coroner. Did you know this? Did you know that? Did you know she said I hit him? Did you know she said I could have hit him? Did you know that she'd been drinking? Did you know that her taillight was damaged? Did you know taillight was found near the victim? Did you know? Did you know? Did you know? And then the result is yes. The coroner, who testified very well, said I did know all of that. And this was still undetermined. She talked about the fact that they checked John O'Keefe for all the lower extremity injuries you would expect to see in a vehicle collision, and he did not have any injuries that you would typically see from a motor vehicle collision. That is really the end of the day. The jury left today with the coroner saying, I knew all of this information that the jury also knows. And my determination of manner of death, how John O'Keefe got the injuries that caused his death, was undetermined. So though cross-examination for Alessi was a bit of a fizzle, and I actually yelled, don't end it like that, the end of recross was a huge win. But that huge win was completely set up by attorney Brennan. And we're not even talking yet about the massive conflict about who was at the autopsy. Because the defense brought up a picture of who sure as fuck looks like Trooper Proctor to me and Trooper Keefe. And they finally brought in the log. And do you know what it says on the log, according to the medical examiner? That there were two names. And she said Mr. Keefe and Mr. Connor. And to my remembrance, wasn't Trooper Keefe named Connor Keefe? So now I want to know if they signed two different names or if he put his name on two different lines. And it seems, at the end of today, it seems that Trooper Proctor was at the autopsy. But I remember that Trooper Keefe, the junior guy, said that he went to the autopsy alone. He went to the autopsy alone. Because I was damn near apoplectic that the IO wouldn't even bother going to the autopsy. But lo and behold, when asked about that photo, Brennan specifically asked the coroner, who were the two people there with you during the autopsy? She said, I don't remember their name. It came back up on redirect that there were two. Oh boy. Well, the issue of who was at the autopsy by itself might not be the world's biggest boom goes the dynamite moment, but when you look at everything else in this case, it is one more thing where you have Trooper Keefe saying, I went to the autopsy by myself. I believe he was asked specifically, Trooper Proctor wasn't with you. And then lo and behold, there's a photo. And the thing is, wouldn't the prosecution have had that photo before that trooper's testimony? I am very interested to see how this all sorts out. And I want to know what badge numbers are on that log. I've got more questions about the damn log. Tell me about the log. I want to know everything. Whose badge numbers were on it? Is that a Scrivener's error that somebody wrote their first and last on different lines? Or is it not? Because it looks, well, real sus. And the trooper testified. I think I'd have a little bit more grace for it if the trooper hadn't testified that he was alone. I mean, what the fuck is happening in this case? What is happening? How are we in a retrial and it's still just like, what? All of you have asked, can we pull the picture up again? Sure we can. Oh, chat, we got time. You know why? Because I had an appointment at 4:30 that got canceled. So we've got time. Oh yeah, we got time. Hold on. Let me run that back. I bet I can find that hopefully pretty quickly. It was during cross. It's just, was it during cross before this feed went down or after this feed went down? You know what? Let's pull up a different feed real quick instead of the one that got split into two. Hold on. Because it was during cross. Oh, let me see. I am on my stand desk, so it is harder for me to see my third monitor based on my stand desk. But hold on. Let's get to the coroner's testimony. I'm going to try to zoom. Miguelina, if you have a timestamp, I think we probably timestamped it. If you'll let me know, because I'm going to grab a different oh, but that's from our timestamp, and ours is not really close in time. But hold on. It is within that cross-examination. Oh, there it is. Found it. Oh, there it is. Tag team back again. Check it, direct it. Emily, are you just entertaining yourself at this point? Yes. I've nothing to do with how crazy today was. I'm just like, Like, what do you even do with that? Sweaty? Like, today was wild. There's that. Also, why aren't you all in like, why isn't everybody in like booties and like white paper zippy uppy suits? Like, what are we doing? What are we doing? So this, oh, I had it playing. I thought I was paused. I'm not paused. Not paused. That's the photo that was shown to the coroner of the two individuals at the autopsy. So, to me, that looks like Proctor. This could very easily be who took the picture. I don't know. This might just be security cameras. I don't know. That has not been established who took the photo. We don't know. I bet it's going to come up more, but the jury doesn't know what Trooper Proctor looks like, though I bet somebody, I bet at some point, can I zoom in? No, I bet at some point someone will zoom in on all of the identification and such. And I bet that there will be more. I saw a couple of you asked in the chat, was this not during the autopsy? The testimony that came in is that this was during the autopsy. That's what the coroner said. The coroner said, I can't, it won't let me zoom in. It is a weird position for security. I don't know. And we won't find out. It looks to me like Proctor. But again, that's what it looks like to me. But the testimony elicited is that this was during the autopsy. That's the testimony that was elicited. So if that's not accurate, then that's not accurate. But they are going to have to, I think the Commonwealth is going to have to figure this out, because it's a lot. It's true. Tully also is bald. It's true. Let's see. And the thing is, though, Erica said at the top, it literally says Proctor and Keith. Yes, but the defense labeled that. So that is not necessarily proof. That's what the defense labeled the photo as. So we know who the defense thinks it is. But Trooper Keefe said that he was alone at the autopsy. So this leaves, for me, a very large question. This leaves a very large question for me. Where did this photo come from? How did the prosecution not know about this? Why did Trooper Keefe say he went to the autopsy by himself? The coroner said 2 people. If that's not Proctor and is somebody from the crime lab, then the prosecution's going to have to tie that back around. But the jury doesn't know who Trooper Proctor is, and the coroner doesn't know who the people in these photos are. Do I think we're going to see this photo again? Yeah, I do think we're going to see these photos again, and I think we will have questions about it. Helene asked, could it be Higgins? None of these people are Higgins. Also, Higgins would have no reason to be at the autopsy. He was not law enforcement on this case. I could make some ATF jokes, but I'm going to refrain. But Higgins wouldn't have been there. Even if it's not Proctor, if it's Tully or another law enforcement officer, Keefe still said he was the only one there. So how did this not come up? I don't know. But it doesn't look good. And the thing is, when you leave a bunch of questions, that is a problem for the prosecution. Leaving a bunch of questions is exactly what the defense wants to do. Questions equal doubt. For the prosecution, they need to answer those questions. And right now, they are not answering those questions in a lot of areas. Like in a lot of areas. So we've got a lot of questions that need to be answered. Let's see. Can you screenshot the photo and then zoom in and tell us your thoughts? Oh no, I'm not doing amateur sleuthing. But I will take a look tonight when my brain does not have so much going on. But no, because it looks fairly lacking of information. However, what the defense chooses to bring in is, well, we'll have to wait and see what the defense chooses to bring in more about this. And we're going to have to wait and see if the Commonwealth circles back to this, because it's left, for me, very big questions. Before the coroner clarified there were two people at the autopsy, there were two people at the autopsy. She said one could be crime lab, one could be a trooper. It was before we got to this photo, but she said this photo is from the autopsy. So we will see what happens with that. It is a very strange thing, a very strange thing. And I think it's a lot of photos. Let's see. Tonali said, I don't think the photo is from the autopsy. It might not be, but what the evidence is before the jury right now is that the photo was shown to the coroner. The coroner said, I don't know who those people are, but two people were at the autopsy. And then the prosecution brought in the log of who logged in, and the names were the two names of the one trooper who said he was there. So if this is misrepresented by the defense, that's also a big issue. If the defense has represented this to be from the autopsy and it's not, that's also an issue. I don't see that as where we're at, given that the coroner said, yes, two people were there. She said, I don't know who those two people were, but two people were there. So two people were there is very different from what Trooper Keefe said, which was just him. So Cat Mom said, I want to see the logbook. I want to see the logbook too. I want to know how it was written in the logbook. I don't think we're going to get that information. I don't think we're going to get that information in at all. So I don't think we're going to see it. They gave it to the coroner on redirect, and she said, it seems like Connor and Keefe. So that is where we're at. The doctor said, Tuco Limited, the doctor said it was during the autopsy. She did not say specifically that this was the autopsy room. She said that this was the morgue, which could have a broader meaning. But she said, a lot of you have said, but the file name is put on by the defense. And actually, the prosecution probably could have objected to the file name being shown and had it redacted out. The file name's put in by the defense. So I'm not squaring on the file name, because the defense can title a file anything they want to title a file. So they think it's Keefe and Proctor. They certainly do. Could the prosecution, if they had clocked it, objected to the file name being shown to the jury? 100% they could have. Did they? No, they didn't. No, they didn't. Would the jury have clocked it? Maybe. It depends on how well they can see from where they're sitting. The Lauren said, I really like the medical examiner. I really like the medical examiner too. I think the medical examiner is like, I do my job. I stay in my lane. I know what I know. I know what I don't know. I'll tell you what I see. I'll tell you why I make my decisions. And I'll tell you the reason I made my decisions. But she's also not going to shy away from possibilities. This is possible. That's possible. This is what I think. This is my determination. But yeah, there are other possibilities. So we'll see. All right. Let's continue on with that. So what witness are we going to get to tomorrow? I guess we'll see if they call the brains of the brain tomorrow or not. I don't know. All right, let's see. What about Proctor's comments about the ME last trial? Those are not in evidence this trial, and they were not asked about, of the ME. So those are not in evidence. Claire said, questions, thoughts about the Commonwealth's witness order this trial? It's such a different presentation, but I'm finding the order of witnesses confusing. That's fair. And I think, Claire, for those who watched the first trial, it feels like there are things left out. Like the details aren't as thoroughly vetted. I don't think this order is confusing to the jury other than how did this happen? Because the Commonwealth has grouped things together foundationally. It's really hard to parse it when it's like, ooh, but there's this and then there's this and then there's this. We know there's other information. The jury doesn't. What I find difficult is that they don't have a clear timeline. I think that's a problem with the case facts, not the presentation of evidence, though. I don't think the jury has a clear timeline. And so they're having to kind of piece together as they go what happened, and they don't have the accident reconstructionist yet. But they do now at least have the injuries to the victim. They now know what the cause and manner of death were. So we've gotten a little bit more, but it is very much a more streamlined presentation of evidence. I think there's a risk that they streamline it too much. But again, I think it's a huge risk to ask the coroner, did you know all of this, our entire case? And you still found it was undetermined. And the coroner's like, yes. Yeah, 100%. 100%. 100%. Yoli asked Emily, if Karen loses, can they still prosecute her in civil court? Yoli, I'm going to reinterpret your question. If we're asking about the civil wrongful death lawsuits from the O'Keefe family, yes. If we were talking about prosecute from like the law enforcement standpoint, no. But if she is acquitted, if it hangs again, can the civil lawsuit for wrongful death still go forward? Yes. And yes, people can be found not guilty of committing a crime and liable for wrongful death. The criminal standard and the civil standard are very different. And the evidence that may come in or not come in at a civil case is very different. So you can have circumstances, I think most notably probably the O.J. Simpson case, but you can have circumstances where someone is not guilty beyond a reasonable doubt, but still liable in the civil sense. Yes, it can happen. This was earlier in the chat. Sergeant Mom asked, so Canton PD never had the clothing examined. State troopers had John O'Keefe's clothing examined. It's not the medical examiner's job. So the medical examiner, even if they had the clothes, wouldn't evaluate them very much. That went to the crime lab. We saw the beginning of that testimony yesterday, and there's more of that testimony to come, I would suspect, because we haven't gotten into all the scientific witness that decided whether the pieces of red plastic were from the Lexus and are the same type of plastic and all of the chemical analysis. Like, we haven't gotten to the AP chemistry exam of it all yet. Nicole Lang said psychology midterm this morning, now spending the afternoon catching up on court. This is a long day after exams. This is a long day after exams, a long day after exams. Jenna said, you have my toddler chanting, we want log. I mean, it's big, it's heavy, it's wood. Who doesn't? Who doesn't? Let's see. Emily, do you think she is making a case for the prosecution or the defense at this stage? I find the coroner to be incredibly neutral in this case. And I think the coroner does not eliminate doubt effectively for the Commonwealth. And one of the things that the coroner says that does not effectively eliminate doubt for the Commonwealth is that John O'Keefe does not have the type of lower extremity injuries that you would expect to see in a car accident, which is why you saw Brennan saying, but what about if somebody's sideswiped? What about if somebody is clipped? The Commonwealth is going to start pushing towards that count too, and whether or not Karen Read was a significant contributing factor to the death of John O'Keefe versus this being a volitional homicide, I think, because some of those questions are, okay, well, the coroner's looking for traditional injuries in a head-on vehicle versus pedestrian. And I imagine that their experts are going to differ. We don't know what their accident reconstructionist is going to say. I am going to be very interested to see. Lena said they are picking the Commonwealth's case apart so much better this time around. I have thoughts about that too. Hank sounding like an ally on redirect after every Hank is misrepresented. I don't believe that he didn't ask for a new report. On the second part, I don't know if I read that properly, but my brain's kind of stopping today. On the first part, the reason I think it seems much clearer how the defense is tackling witnesses is because the Commonwealth is actually tackling their witnesses in a cleaner way. The facts are the facts. And if the facts are bad for you, the facts are bad for you. That's just, I mean, ask Diddy's attorney. There's only so much you can do with bad facts. But when the evidence is presented more cleanly, and it's been presented more cleanly for the Commonwealth, it's much easier to tell what evidence the defense is pulling at because it's just not lost in a word salad of everything and just a word salad of all of the things. So I think the whole case is presented more clearly, and with the whole case being presented more clearly, it's just easier to see what's happening. So much got lost in, was it snowing? What about this? What about that? Just a lot got lost. We also have different lawyers. It's just an entirely different trial. So entirely different trial. Let's see. I'm going to try to ask some of the other questions and see what happened. I am going to, I'll probably go back and look at my notes on Connor Keefe's testimony because, well, the jury doesn't have the benefit of doing that. We do. We've got the instant replay, but I want to look at my notes because I remember being like, I can't fucking believe that the IO wouldn't go to the autopsy. Like just the disrespect. It just struck me as incredibly disrespectful that Proctor or Buchanan wouldn't go to the autopsy. And I did not let that go. I was offended by that. It was just like, how do you not go to the autopsy in this case? And so again, because I remember things in sound and words and music, I remember how annoyed I was by that fact. We also will link in the chat the case brief from that day of testimony. If you guys don't want to go back and watch Trooper Keefe's testimony, we'll link the case brief in the description so you can just watch my breakdown and summary of that day and see what my impressions were on that day of testimony because we have case briefs on the Emily Show channel. Let's see. Jojo said, I found it really weird that they asked her about Karen Read's comment. Isn't the coroner supposed to be impartial? Coroners are hired by the state, so they are technically government witnesses. And coroners, though, being the scientific nerds that they are, tend to wonderfully say, my opinion is this, it is based on this. And what I appreciate about most coroners is they're really pretty rigid about that. I love it. They're just like, no, I see it this way. And you are not going to change my mind. I am the doctor. The coroner is allowed to take into consideration the context that is known about a death, if there is context known about a death. And so the coroner is allowed to take in all that information and decide if the information they know lines up with what they're seeing. But coroners, in my experience, default to what they're seeing before any of the other information. But does knowing someone was found in the snow impact what they look for? Yes, it does. Bethany said, Ryan Hall just got called Weather Daddy. Well, A, it's appropriate. And B, I think Ryan Hall is expecting another kiddo. So in all the ways, also, I love whenever I pop over into the chat, well, anywhere on the internet, I love seeing all the law nerds in the chats, but I always appreciate it. And I realized probably the channel stuff yesterday probably caused chaos in some other streamers' chats, and I feel very badly about that. I did not mean to cause, any of it. And when I learned about it, I was tremendously stressed, and I'm sure everyone else was too. And I was like, oh no, we have caused chaos. I am not trying to be a chaos gremlin. Like generally that's intended. That was not intended. That was not fun. Daisy Rain said, EDB, would you call the ER hospital staff? Yes, I would. And for what side? Well, as the prosecutor, I think they want the information in that the ER knew and what they did, and they can talk about the time of death and the life-saving measures, and they can talk about what was done at the hospital to explain some of the information that the coroner has. But Brennan is just like, he is keeping this case narrow, and he might keep this case so narrow it backfires. He might keep this case too narrow. We're going to have to wait and see. That's going to take us some time. That's going to take some time. So thank you guys for all of we always appreciate the compliments. Sherry said Keefe testified that he attended alone. I mean, that's my memory of it. The patch badge on the second person appears to be Mass State Police. I can tell that it's a badge. It looks like the seal of the state of Massachusetts to me. I don't know what EMS or crime lab would have vis-a-vis what the troopers might have. Eileen said the Q was anyone from his unit with him? And he said no, not that he was alone. They weren't in the same unit. I will go back and listen, but Proctor is in his unit. He was the junior person at the DA's office. So they were the same unit to the best of my memory. So we need a pic of Proctor to compare. I'm not going to go grab a pic of Proctor to compare because the jury doesn't have a picture of Proctor yet. We're going to have to wait to see how this gets tied up in court. And I don't know how this will get tied up in court. Right now, I'm just like, what is happening? Casey Cat said, were there two different badge numbers? It was not asked on recross or redirect. Not asked at all. So we will see. Liz Burt said, every time you come in with a Doctor Who reference, I love your coverage even more. Thank you for sharing wibbly wobbly timey wimey. And Blue Box, look, the painting back here, I always do this wrong, but that says hello, sweetie, back there. That is what that says. I need to get one that says spoilers and put it back there. That's what I should do. That should say spoilers. It's like a Where's Waldo back here in the office. So I really do need to get one that says spoilers. Because for sure, spoilers. Let's see. River Song is the best. I agree with all of you. I appreciate all of you discussing weather. I realize I have derailed that. Normally we're just like a chats down topic. And now I'm like, we have digressed into weather and nonsense. Yes, we have, because today is just wild. But the defense is going to argue, how can you not have doubt? That's what the defense is going to argue. And the Commonwealth is going to say, we've shown you all of these things. But if the Commonwealth thinks that, could I have hit him? Did I hit him? I hit him is going to carry the day. I think they are going to be disappointed. But I also think the defense is worried about count 2 and about that contributing cause of death, because count 2 is not intentional or volitional. It's whether Karen Read was in that chain of causation. And they are looking at attacking all of that too, because count 2, I think, is of all the counts, the more difficult count for the defense to deal with. Some of you are saying Brennan slammed his laptop shut like a child. I did not see that. Everybody did jump up pretty fast to get out of that courtroom, for sure. AZ Barbie Girl said, I got my husband to watch Emily and he really enjoyed her reactions. Then she mentioned Creed. He has a full-on crush. Say hello to Marty. Hello, Marty. We do love Creed. We also took our teen to a Metallica show like last week. I have still not caught up on sleep. But you know what, Law Nerds? Sleep. You know what we're doing this weekend? Dr. B was like, hey, what are we doing Saturday? I'm like, I don't know what we're doing on Saturday. He goes, Joan Jett and Billy Idol? I went, Joan Jett and Billy Idol? Yes, we are. So that's what we're doing. That's what we're doing on Saturday. We're going to go see Joan Jett and Billy Idol, because there is no rest when it is concert season. So that's what we're doing this weekend. It's going to be amazing. And I can't wait. Because Joan Jett is so good live. I think we've seen Joan Jett live 3 times, maybe 4 times. It's been so much fun. So we're going to 100% go do that this weekend. Law Nerds, I'm going to bounce out tonight because there are other cases I need to catch up on. And I am busy at the end of the day prepping the podcast so that I can record it for all of you, hopefully early in the day on Saturday is what it looks like. assuming there's a full court day tomorrow, and there's lots and lots and lots and lots and lots that I need to catch up on in the Diddy case in South Carolina and whatever's going on with Taylor Swift. So I've got lots of reading to do. Lawners, I would love to sit and answer questions for a lot longer. We will answer more questions tomorrow. Thank you for being here. Thank you for being a Lawnerd. Thank you for being patient. The hardest thing about trial is that there are so many what ifs right now that it is frustrating. But if you have that many what ifs in this case, it is likely that the jury also has that many what ifs in this case. And the process of slogging through the answers time and time again, in this case, has not been always as easy as just, oh, this answers that, this answers that, this answers this. I am still at the point where I have a lot of questions, and I am interested to see the new experts for the Commonwealth, but what time is the Commonwealth going to get to talk about? I don't know. Hey, T, I was just wrapping up. How you doing? You've got to, can I finish saying goodbye? I was in the middle of my goodbye with the Lawnards, and then you can say goodbye, and then they can't see you from there. I was just signing off. He's like, all right, we got, Utah, give me 2. Yeah. You're wearing shorts. It was hot today. Yeah, fair enough. All right, Lawnards, I'm going to go answer 2 questions. It will probably be more than 2. Oh, we were talking about pictures. Travis is like, what is up on the TV? Pictures. It was pictures. Lawnards, take care of yourself. Stay weather aware, depending on where you live, because there is weather. I mean, it's that time of year. I will see you tomorrow in court. Don't forget to get the Lawnard app, because I can keep you in the loop with everything that pops off. And in this case, it seems like what's not going to pop off. Because what's not going to pop off, we've got much more to talk about tomorrow. I'm going to roll the outro. I'm going to see you guys tomorrow in court. Of course, Travis is here. George is here. All the things. Lawnards, I'll see you tomorrow. Bye. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Lawnard app at lawnardapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court. And of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Lawnard app. Thank you for being here, and thank you for being a Lawnard.